Sorted with technology, all good? Thank you. Tēnā koutou katoa, welcome to the resumption of hearings on the proposed Timaru District Plan. This is hearing stream D. We'll open with karakia. I invite Commissioner Mackay. Thank you.
Kia tau ngā manaakitanga a te Minaro, ki runga ki tina o tātou, kia māhia te hua mā kehe, kia toi te kupu, toi te mana, toi te araha, toi te reo Māori, kia tūturu, ka whakamaua, kia teina, hui e, tā ki e.
Tēnā koe. Ko Cindy Robinson tōku ingoa. I am from Christchurch. I'm a lawyer and hearings commissioner, and I'm the chair of the panel. I will just allow the remaining panel members to themselves. We'll start with you.
Morena koutou, ko Rodsday Cleven, toko ingoa, no Otapoti ahau. I live in Dunedin. I'm an independent commissioner appointed to the panel. Thank you.
Kia ora, ko Megan Mackay toko ingoa. I am a lawyer and independent hearings commissioner based in the Taumitu Takiwā of Selwyn.
Good morning, Stacey Scott, Timaru District Councillor and also Commissioner on the District Plan proposed.
Kia ora koutou everybody, my name's Raywin Solomon and I hail from the Kaikoura area, but I'm working in the Taumitu area, not as a commissioner, just as a project manager, but I've been doing commissioning work for 23 years.
Thank you. The panel was also assisted by Ms Thorne. If you could introduce yourself. Oh, you don't have a mic? Ms Thorne is a planner hailing also from Otapoti, and she provides technical assistance to the panel during this process. Also, you will have met Ms Linda Perkham in the back there, our hearings administrator, who is doing a wonderful job keeping us on track and coordinating matters with submitters. So just a reminder of the hearing process here today. This particular hearing stream is dealing with issues relating to ecosystems and Indigenous biodiversity, natural character, natural features and landscapes, open space and recreation zones, and also contaminated land and hazardous substances. Participants in the hearing process are hopefully now familiar with the proposed district plan website or web page accessible through the Timaru District Plan. On that page you'll find the hearing schedule for this week and all of the evidence and submissions that have been filed, both in relation to this hearing stream, but also the primary submissions are also available on the council website also. With each hearing stream, the panel looks at the submissions and is careful to identify whether there are any potential conflicts of interest. We are an independent panel, so I will just, as we've done in other hearings, just check in with councillors, with commissioners as to whether or not they have disclosures to make in relation to this particular hearing stream.
No disclosures from me.
I just have one. My husband, Dave Scott, is a member of Federated Farmers. We farm in the Waimate district.
Thank you.
Yes, kia ora. I have one disclosure to declare. I was General Manager of Taumitu Runanga from 2018 to 2021, and we were involved in Environment Court action at Kaitariti. And I was not the lawyer, but I was instructing the lawyer, and in the doc evidence, the ecology evidence refers to that particular case.
Thank you, Commissioner. And I have no further disclosures. In terms of those matters, I'm comfortable as chair that the panel members can continue to participate in those particular issues, but of course if there are any matters that any submitter or council wish to raise a concern with, please do so, and we can address that. So the next step here is council has a role in the hearing process to provide Section 42, what's known as Section 42 reports, which enables the council to engage, in most cases I think, independent consultants to, and in some cases council staff, to review the submissions and the evidence and to provide recommendations to the panel. Those are not binding on the panel, but they are of great assistance for the panel to navigate the breadth of submissions and identify what the core issues are for each hearing stream. So those reports were pre-circulated before submitters had the opportunity to file their evidence, and Council 42A reporting authors have also updated those recommendations in light of the evidence that they've heard or seen already, and will continue to do so throughout the hearing process. Council was also represented by legal counsel, so welcome Ms Vila. What we will do is we'll hand over to you to open the case for this hearing stream, and then to introduce your 42A reporting officers. Following the morning tea break, we'll move to hear submissions. So welcome Ms Vila.
Thank you, Madam Chair. Tēnā koutou katoa, ko Jen Vela aho, and I'm counsel for the council. I have filed legal submissions, which you'll have. I'm just going to pick up on 3 matters that I've raised in those legal submissions, but before I do, I just mention that I did notice a couple of errors last night as I was reviewing, and so I've just filed a replacement set today, but they're very minor corrections, and I'll take you to those as I go through.
Okay. Have we got printed copies of those updated
I've
submissions?
updated. I only sent them through this morning, but they're very small, and I will tell you exactly what they are. Yeah.
Thank you.
So I'll just start by introducing the council officers. With me, I have at the very end Mr Nick Boyes. He is an independent planning consultant, and he's prepared the Section 42A report for the natural open space and sport and recreation zones. Then Mr Willis, who has prepared the report for contaminated land and hazardous substances, and he's appeared before the panel before. And then we have Ms White on my immediate right, and she has prepared the ecosystems, Indigenous biodiversity, natural character and natural features and landscape Section 42A report. And in Ms White's report, there were 2 memoranda attached from other experts, and those experts are online with us today. So we have Mr Mike Harding, who is an ecologist, and he's responsible for preparing the SNA mapping. And Ms Yvonne Fluger, she is a landscape planner, and she's responsible for the district landscape study that's identified the amenity landscapes and the ONLs and ONFs. So we have Mr Harding and Ms Fluger with us for the morning session to answer any questions, and they will be listening into other relevant submitters, but won't be here throughout the whole hearing, but are available to come back if the panel has any questions beyond this morning session. And similarly, Mr Boyes and Mr Willis may not be here for the entire hearing either, because there are very few, if any, issues that seem to be outstanding in relation to their Section 42A reports, but they'll be in the building, so again can come back if necessary to answer any questions. So that was the first thing, and I think there's just 2 substantive issues that I'll pick up on. I've addressed them reasonably thoroughly in the submission, so I'll just bring them to your attention again. The first starts at paragraph 11 on page 5 and relates to giving effect to the MPSIB. So there are a couple of submissions that have suggested changes to give effect to the MPSIB. I think you'll hear from DOC and the Rooney Group today or tomorrow. And those submissions relate to DOC seeking amendments to give effect to or include a specific requirement that gives effect to the policies in the MPSIB around avoiding adverse effects on SNAs, and also applying the effects management hierarchy. And Rooney Group have raised an issue in relation to clearance of Indigenous vegetation for sort of extraction of aggregate and specific sort of consenting pathway or policy pathway, I suppose, for certain types of aggregate extraction in the NPSIB. So I think I've sort of thought about this in a way, or I've sort of tried to set up, I guess, a framework for the panel's thinking around this and asked 3 key questions. So the first is, can the amendments be made? And I think the answer to that is yes, there's scope within the submissions for the panel to do so. And you might recall in my opening legal submissions, I made some submissions about those national policy statements that came into effect after the PDP was prepared, and said that provided that there is scope within the submissions, you could do so, but you don't necessarily always need to. It really depends on what the particular MPS says about implementation and timing. So there is scope in the submissions to make the changes sought by the submitters. The second relates to whether you need to do that right now. And the doc evidence and legal submissions have pointed out that the NPSIB contains a sort of general direction to give effect to the NPS as soon as reasonably practicable. But there are actually other provisions that are relevant to that, to the timing of implementation as well. And ultimately, there are a couple of deadlines in there. Overall, the NPS has to be given effect to, or changes need to be made to plans to give effect to NPSs within 8 years from the commencement of the NPS. But in relation to the planning provisions for SNAs, they have to be, plans need to be changed to give effect to those within 5 years. But despite those 2 deadlines, there's a general direction to do so as soon as reasonably practicable. That doesn't necessarily mean at the first available opportunity. So I think you need to consider whether it's reasonably practicable to make changes in the context of this PDP to give effect to the NPS. And I think Ms Newell's legal submissions for DOC sort of acknowledge that by saying what reasonably practical means is context specific. So the correction I'd like to make, 2 corrections I'd like to make is at paragraph 21. I've erroneously, or a bit of a slip of the tongue really, said that giving effect to the NPS might be done through consenting decisions. Of course, that's not right. You give effect to the NPS through making plan changes. So I've just suggested striking that last sentence of paragraph 21 out. Yeah. But also in paragraph 23, to replace give effect to with consider. Of course, you will consider the NPS when you're making a decision on an application, and put a full stop after applications and strike the rest of that out. So apologies for that. And then I think there's a question, you can, but you don't necessarily need to. It depends on the context. And so then in terms of context and whether you should, I think there are a couple of other things that might be worth considering for the panel. And one of those is, well, if we don't make amendments to the PDP to give effect to the NPSIB right now, what happens? How does that sort of play out? So the first is that in the context of a resource consent application that's not a non-complying activity, we'll put that aside for a second, the NPSIB objectives and policies are still going to be a relevant consideration in terms of 104.1b. And I would suggest that given that the PDP doesn't actually give effect to the NPS, then those objectives and policies would have quite strong weighting in any decision on a resource consent application.
I mean the NPS objectives and policies.
Sorry, the NPS objectives and policies, yes. In the context of a non-complying activity, though, both submitters have raised an issue around how that interacts with 104D. And in the context of DOC submission, excuse me, if you have an application that is contrary to I guess the issue is that 104D requires consideration of whether or not the objectives and policies of the PDP whether the proposal is contrary to the objectives and policies of the PDP, and so the NPS objectives and policies don't come into play in the context of 104D. Where you have an application that might sort of be contrary to the objectives and policies of the NPS, but not the PDP, I think the overall outcome in a substantive sense may not ultimately affect the overall outcome because of the fact that your NPS objectives and policies come into play at 104.1b. And so I think they would have quite significant weight in the context of your overall decision. So you might still pass the jurisdictional bar, but your overall merits assessment is is probably not ultimately affected.
And there's nothing new in that, is there?
No.
And the same thing is applied to coastal policy, national policy statement for coastal areas as well.
That's right. Yes.
There is a lag in terms of plans catching up with
There always
national
is.
direct-
And in the context of the RENI Group's submission and Mr Hull's evidence, though, there is a narrow subset of activities that are recognised in the NPS objectives and policies as having a sort of policy pathway towards to getting a consent. But where the PDP objectives and policies don't currently recognise that particular sort of subset of activities or narrow set of activities, and so it is feasible that you might get an application that would be contemplated in the context of the NPS, but would not pass the jurisdictional bar in the context of 104D, because the objectives and policies simply don't sort of recognise that level of nuance. And so you may end up in a situation where a decision maker is not able to go past that 104D step to a 104 overall merits assessment. And Ms White has given some further thought to how that might be addressed if the panel would wish to do so. The only other thing I'd mention in that context is that, and my opening submissions in hearing aid did say, look, we are always operating in the context of some regulatory uncertainty, and we know that there are some changes coming, but at this point in time we have to just move ahead with the law as it is right now. I would just caution in this case that we know that there are some changes coming to the NPSIB early next year, so that's been announced by the government. We don't know what they really look like, and the only sort of sense of that that we've been given is that the government has said that the policies will be adjusted to sensibly protect the most unique environments without putting undue restriction on land use and better support quarrying and mining activities. So those objectives and policies in the NPS that come into play, or that DOC has sort of raised, and also that RENI Group have raised, may well be the target of some changes that will be proposed early next year, and the anticipation is that they'll be passed by mid-2025, and so that will be before the panel ultimately makes its decision. So it might be worth keeping a watching brief on how that might play out.
No doubt other submitters will as well, but we just encourage the council to keep the panel informed if there's a change, and then we can look at what the process is.
We will do so, of course. Yeah. Are there any questions on that before I move on to the regulation of riverbeds?
Thank you. So you've just described the consenting process with the non-complying gateway test, and then moving on to if an application was contrary to that, then you would then be able to consider the NPS objectives and policies through section 104(1)(b). Am I correct that if the proposed plan was considered incomplete in terms of the NPS IB, that then there would be even a further safety step back to Part 2 matters?
In the context of the 104 assessment, yes. But of course, if you don't pass the jurisdictional bar in terms of 104D, I think that would be sort of the end of the road, essentially. Yep.
Yes, okay, thank you.
Yep.
So just picking up on that, so is there any issue from your perspective jurisdictionally whether or not, I mean, obviously any activity, there's an effects issue. So an activity where there's a significant adverse effect or, you know, a more than minor adverse effect is going to have difficulties immediately with the gateway test. But isn't the key here to ensure that there is not a roadblock?
That's right.
To the similar range of appropriate activities identified in the NPS IB in the plan. So it may require a tweak to the objectives. Is that what we're suggesting, rather than necessarily changing the consenting pathway, the consent status, but just ensuring that the objectives in the plan are reasonably aligned
That's exactly
to the NPS IB?
Yes, that's exactly right.
Yeah.
Yep.
It's not on this bit. Carry on.
Thank you. So the second substantive issue that I'll just pick up on is the issue around regulating activities in riverbeds. And so there are a couple of submissions that raise issues around that. And so there's two key questions really that have been raised in that context. And the first is, does this council have the jurisdiction to make rules for activities in riverbeds? And the second is, and what submitters are really trying to avoid is what they call unnecessary duplication of consenting requirements. And of course, the first thing I should say is that the council doesn't want to create unnecessary duplication and would seek to sort of remove that as far as possible, but it also just needs to fulfil its obligations and functions and duties under the Act. And so in terms of the sort of strict jurisdiction under the RMA, I don't think there's any dispute that district councils do have jurisdiction to make rules over riverbeds, because riverbeds are defined as land and therefore come within the district council's jurisdiction. But the rules that district councils can make in riverbeds need to be for one of its own functions, and obviously not for a function of the regional council. So I think the sort of crux of that is, I've set out in sort of paragraph 36. So each council can, and we have overlapping jurisdiction in a number of different areas, and it's sort of well recognised that each council can regulate activities for the purposes of its own functions, provided that a district rule isn't inconsistent with a regional rule. And that doesn't mean that you can't have a district rule that regulates the same activity as a regional rule. And I mean, a good example is that if we're talking about aggregate extraction in a riverbed, if you picked that up out of the riverbed and you moved it onto land outside the riverbed, that becomes a quarry, essentially. And when you make an application for a quarry, what we do in practice is put together one application, file them with both councils. The district council will require consents for air discharges and potentially earthworks if it's close to the to groundwater, for example, and the district council will require a land use consent, and they may even consider the same issues, air discharges, but in different contexts for different functions. One might be air quality, and the other might be nuisance or amenity reasons. And so that's a normal thing that we do. And in the context of this hearing, the issue arises in relation to the VAL and ONL overlay, as well as the SNA overlay, but the issue will arise later on in the context of the SASM overlays as well. And as far as the VALs and the ONLs go, in terms of jurisdiction, that's kind of the end of the story. But in terms of SNAs and maintenance of Indigenous biodiversity, the RMA also requires the RPS to state which local authority will be responsible for objectives, policies and rules in relation to maintaining Indigenous biodiversity. And the RPS does that. And I've set that out at paragraph 38. So it contains a statement of joint responsibilities and says that there will be shared responsibility for specifying objectives, policies and methods in riverbeds for maintenance of Indigenous biodiversity only where, and there's two situations, and the first one is the relevant one here, only where the district council has identified an SNA that includes the bed of a river or lake or wetland. And that's replicated sort of elsewhere, and I've said in 39 that there's been some language changes along the way, but not to that particular provision. So the question that's been raised by Rooney Group is, what does include mean? And the suggestion is that it means that the SNA in the riverbed has to be part of a larger SNA, and that the district council can't just map an SNA in the riverbed. And I think if we look at the definition of include, I don't think that's clear on the face of the Statement of Joint Responsibilities. And I think there is an argument to say that if this council has the jurisdiction to do that, and you want to take that jurisdiction, effectively take that jurisdiction away, there should be a clear statement. It should be clear on the face of the statement that you're intending to do that, because the council needs to know how to fulfil its functions. And then if you look at the definition of include, one definition is to have as part of a whole, and so that would support an interpretation that says the bed of the river is just a small part of a bigger whole. But the Collins Dictionary also defines include as to place in an aggregate, class, category or the like. And so you could read that as saying, well, the riverbed is in the category of an SNA. And the Merriam-Webster dictionary says to contain, between or within. And so again, I think you could interpret that as saying, well, the riverbed is within an SNA. And so I don't think that's clear on the face of it, of the statement of joint responsibilities, that the District Council can't map just the riverbed. And I've had a conversation with the ECAN about that, and my understanding is that ECAN interpret it in a way that would allow the council just to map the riverbed, but you could perhaps, I've spoken to Ms Francis and she's here today, so perhaps she can provide some further information on that. But even so, Mr Harding has advised us that, for the most part at least, the SNA mapping in riverbeds also includes the riparian margins and the berms of riverbeds. And of course, a riverbed is defined as bank to bank at the river's fullest flow. So that can be sort of further explored with Mr Harding, but I think regardless of the interpretation, for the most part, the SNAs would fall within that statement of joint responsibilities in terms of the District Council's jurisdiction.
It might be a question for the Rooney submission, but if the provision is intended to only apply if there's an adjoining or attached district SNA, does that leave a gap? Like, what then? I mean, the values have been assessed. There's a process to assess them, but really what we're concerned is who should regulate and what that regulation should be. It doesn't change the fact that it may or may not qualify as an ONL. Or,
That's exactly right, and I have mentioned that too, and I think that really comes down to what the regional rules cover. So then the next question obviously is, well, is there a duplication? Why is the District Council regulating, and why is the Regional Council regulating, and what are they regulating? So the regional rules, my understanding of them, and I have to say it's a sort of fairly cursory one, but my understanding of the regional rules is that there's a permitted activity, and there are a bunch of permitted activity standards, and that those standards don't cover they do leave a gap. They don't fully cover the values for which the SNAs have been mapped. And so I think if it was interpreted in such a way as that the District Council couldn't include rules for SNAs that are just in the riverbed, you would ultimately end up with a gap, because there's no, as a permitted activity, there's obviously no trigger to undertake an SNA assessment in the context of the regional plan either. So the Regional Council doesn't map SNAs, the District Council does, but there may be circumstances in which a significance assessment might be triggered in the regional plan.
and sorry, I should note the Rangitata race
Yes.
submission is the one that also addresses this issue. But has the council done any work that provides that comparative analysis in terms of the objective policy and rule framework under the regional planning framework compared with the district, to identify what that overlap is? I mean, it's easy to talk in generalities
Yes.
about what it might be. We can fill in some gaps ourselves,
Yes.
but what is the analysis there? Has that work been done by anyone?
So Ms White and Mr Harding have given some consideration to that and could talk to that in a little bit more detail. But in terms of sort of putting pen to paper, that we could do that task potentially sort of before the end of the hearing, but definitely, you know, after the hearing, if that would be helpful.
Helpful.
Yeah, thank you.
To do that. Could you, just on that, what is the role or relevance of the Water Conservation Order in relation to the Rangitata in terms of identifying, I mean, what are the values that the Water Conservation Order protects, and is there some overlap there? And how do we take that into account in the mix of this process?
That's a very good question, not one that I've considered myself yet. Mr Harding may be aware of the values associated with the Water Conservation Order, and may have considered those. I'm not sure, but perhaps a question to ask him. And of course, we could provide some further analysis on that if that's necessary after you've had a conversation with Mr. Harding.
I think a good start would be to have a copy of the Water
Sure.
Conservation.
My question is my understanding of the case law is that there needs to be some type of evidential basis that the effects that are trying to be managed are actually different. And if this did come before the court to be questioned, it needs to have some clear evidence to say, well, these are the effects of the regional plan and these are the effects of the district plan. And are you confident that this is written in such a way that it makes that clear?
So we need to be clear that what is being regulated by the district plan are effects that are within the district council's functions, and essentially that's the control of sort of the use of land to manage effects. So that are not within the regional council's jurisdiction. When you say, am I confident that this is written, do you mean the legal submissions or the plan?
I mean the plan,
Yes.
so if this was to be challenged, then it's quite clear from an evidential perspective that the effects here are different than those in the regional policy statement.
So I think that's something that Ms White could probably better address because she knows the detail of the plan provisions far better than I do. But I agree that is something that we need to make sure is clear, that what's being regulated by the district plan is within the district council's functions, yes.
That analysis that we spoke of before, that comparison, I think will be a good
Yes.
start, and then we can look at aligning what evidence is in front of us in this process.
Yes.
Now, this question might come out a bit awry, but why do submissions that include planning and legal evidence question DC jurisdictions with regard to riverbeds if its jurisdiction is clearly set out legally and has been standard practice for years?
I'm not sure that's a question that I can answer, unless you're talking about my legal submissions, but if you're talking...
It's a general question about why these submitters are questioning the district council's jurisdiction over the riverbed areas. When that's set out legally and, under the Local Government Act or the RMA, and, it's been standard practice for years. I don't understand why they're questioning it.
I think what they're really trying to get at is avoiding that, what they see as unnecessary duplication, because of course if you need a resource consent from both councils, that costs more money, and it seems from the evidence that there may be some concern around having inconsistent conditions from one council or another. I mean, we deal with that normally in practice by, as I said before, making an application to both councils at the same time, and the councils often consider the application at a joint hearing if there's a hearing, and that was reflected in Judge Newhook's sort of discussion in the Wanaka case that I referred to in my submissions as well. So we normally deal with those potential inconsistencies by good practice, but I think the issue really is there unnecessary duplication here or not?
Okay, thank you.
Thank you. Is there any other matters that you want to address us on in the legal submissions? Or
No, I think that's all we need to do. Thank you.
Thank you for that. I'll let you introduce your first.
Sure, well, we might start with Mr Boys, if he's ready to present his summary.
Good morning. So I've prepared, obviously, the 42A report and then the short summary. You'll see that it is rather brief, given the evidence or lack thereof in relation to the matters covered in my Section 42A report. I'm not sure, do you want me to run through the summary in any great detail, or I'm happy to just go straight to questions if you'd like? I'm in your hands.
Just for the record, I think just refresh us, just quickly take us through your summary.
Excellent. No. I'll run through the summary. So at paragraph 3 there, I set out the key issues there. One of them was the provision of educational facilities within the open space zone. There were quite a number of submissions, further submissions in relation to the provision for and the use of helicopters for conservation activity within the natural open space zone. The extent of the coastal environment included within the natural open space zone. The provision for freedom camping within the natural open space zone, and I should note the proposed district plan generally and how it deals with freedom camping. The provision for the protection of Indigenous fauna outside areas identified as SNAs or significant natural areas. The provision for existing use rights regarding the occupation and use of the existing South Rangitata huts, and the provisions that apply to the current use of Levels Raceway for motorsport and other related activities. So they were the key issues that I identified coming out of the submissions. They were addressed in the Section 42A report. In terms of the evidence that was received, that was restricted to the issue of freedom camping, and that was from Ms Williams on behalf of the Director General of Conservation. That evidence recommended an advice note be included in the plan to identify that freedom camping is managed through the Freedom Camping Act rather than through the district plan, and that potential solution was also signalled in my Section 42A report, but noted as being outside the scope of the topic, and therefore I recommend the consideration of this matter is deferred to hearing F, temporary activities, and that remains my position. In terms of the issue regarding the use of helicopters, I had some correspondence with Tony Michelle, Executive Officer of the New Zealand Agricultural Aviation Association, post preparation of a 42A report. That correspondence effectively addressed my interpretation of Section 4.3 of the RMA and the types of activities that are listed in Appendix 1 to the Conservation Management Strategy, which is also cross-referenced as Appendix 1 to the proposed district plan. At paragraph 7 there, I outlined, quoted from that correspondence what my interpretation was, and as a result of that, Mr Michelle come back and said that he was satisfied with that explanation, that the activities that they wished to pursue were covered by Section 4.3 of the RMA, and hence I take that's why they're not scheduled to present any evidence at this hearing. In addition, there were following matters were further raised in evidence at paragraph 9. Mr AJ Rooney, submitter 177, supports the recommendation set out in the 42A report to rezone land at 32 Milford Road, Temuka, from this active recreation zone to GRUZ. And Kiwi Rail Holdings sort of setback requirement of 5 metres from a railway corridor for new buildings or structures within the open space zone adjoining the railway corridor. Now, I noted that that matter wasn't actually specifically addressed in my Section 42A report, but I went back and looked at the original submission and did note there that it related to multiple zones, which include the natural open space zone, the open space zone, and the sport and active recreation zone. But I understand that Ms White is addressing that and has had discussions with Kiwi Rail, so I make no further comment on that at this stage and leave that to Ms White. Corrections to my Section 42A report, I wasn't able to identify any corrections that are required at this stage. The list of resolved and outstanding issues, none arising from evidence at all. I note, though, that there are some submitters appearing who have not pre-circulated evidence, such as the South Rangitata Reserve. So I haven't provided a preliminary view on those matters at this time. I'll hear that evidence and any questions update you throughout the course of the hearing as required. And finally, probably the other issue there is the update on the Levels Raceways situation. In the Section 42A report, I include an assessment of the submission from the South Canterbury Car Club, which related directly to activities undertaken at Levels Raceway, and I indicated the potential use of a special purpose zone or the like. That would be a potential planning option to address the submitter's concerns and provide a planning framework by which to assess those activities. Since writing the 42A report, I have looked into the existing resource consents that are held by the South Canterbury Car Club in more detail, and also the context of those consents in terms of their contentious nature, what process they went through, the nature of the conditions and the like. Based on that, I'm of the view now that the scope and nature of the process that would be required to insert any new special purpose zone into the proposed district plan is beyond what I would consider to be appropriate to a submission. It would, in my view, it would be more appropriately dealt with as a separate Schedule 1 process to enable the adjoining landowners and other key stakeholders to have a say in those future planning provisions, noting that a number of those previous consents were relatively contentious and at least one went to the Environment Court. So in that context, I'm of the view that the Rule 10 as notified, which results in motorsport events as well as ancillary motorsport facilities and activities being fully discretionary activity, is an appropriate outcome at this time. And otherwise, my recommendation in relation to that South Canterbury Car Club submission, as set out in paragraph 9.1.13 in my Section 42A report, remains the same. So that's just an update on that particular issue, and that was basically the content of my summary, but happy to answer any questions you have.
Sorry, can I just clarify? So in the 42A report, you had recommended consideration of a special purpose zone, and you now don't recommend that process? Is that...
No, sorry, my 42A report recommended that the submission be rejected.
Right.
But did signal that there was potential to work with the submitter to perhaps develop a special purpose zone, which would be an appropriate planning framework and a framework that I've seen in other instances in relation to motorsport activities.
And have you engaged directly with the submitter on your views?
Yes, well, to be fair, there hasn't been a lot of two-way communication, but I have sent an email to the South Canterbury Car Club setting out effectively the content of the summary, and that was done to alert them so that they got that from me rather from the summary report, and also there were numerous attempts to contact them by phone given the number that was on the submission, but I haven't actually been able to have any sort of detailed consultation or engagement with the submitter directly.
Thank you for that. I'd just be concerned if perhaps they had thought that they had persuaded you to accommodate their views and now you don't, and they haven't elected to participate in this process.
Yeah, so unfortunately I can't update on that. I haven't had a response to the email either.
Okay. Thank you for that.
No, thank you.
Thank you, Mr. Boyes. So we're hearing from the South Rangataga Reserve today, tomorrow. And I had a question about some of the amendments that you've recommended in response to their submission. So you've recommended an additional matter of discretion be added to OSZ Standard 3 to ensure that in the event height needs to be increased, that might avoid the effects of natural hazard risk. And when I was looking through those standards, I wondered, is there any related considerations in terms of standard 4 around the setback of buildings and also standard 5 in relation to the height boundary? Did those also need any consideration as a consequential amendment, or...?
Well, the obvious one arising out of that would be height in relation to boundary. I don't think the boundary setbacks would, but it's something I can have a look at specifically and come back to you. But no, thanks for pointing that out. Yep.
Thank you. And my other question related to the issue of orderly exit. So the submitter raised that the question around whether the proposed plan ought to have a provision providing for that. And I note in your Section 42A report, you've stated that the proposed district plan does not include such provisions. Are you saying there that it wasn't warranted to have such a provision, or that it's not the place of a proposed plan to have such a provision?
It was the latter, on the basis that I'm not aware of what the political situation is in terms of the future tenure or occupation of the huts, and I thought that was a bigger issue than a proposed district plan rule.
Thank you. So in that sense, any discussion around orderly exit is a separate process to the one that we're looking at here for the proposed plan?
That would be my advice to you, yes. Yep.
Thank you.
Thanks.
I just have a question on that Rule 10 and your amendment to 3. In Rule 10, subsection 2, it expressly states that you must refer to the standards under Pura 2, but in your amendment to 10.3, it doesn't actually expressly state that you have to refer to the standards. So should that be added in to the Rule 3 as well, like it is in the sub-Rule 2?
Yeah, it's something probably a matter of detail. I can check and come back to you on that one. Thanks. Yeah.
Okay, and my other question doesn't relate to that. It's a natural open space zone, and again, it's a technical question. So at your paragraph 7.1.3, you respond to forest and bird, and you amend the matters of discretion. So where it does say ecological values, it's followed with including habitat for Indigenous fauna, and you've done that with Standard 2 MD4, but you haven't done it consistently in other areas, for example, Standard 4 MD3. So is your recommendation that wherever it says ecological values, that it then goes on to say including habitat for Indigenous fauna, or is it only in some?
The changes that I've made in the 42A report are only the changes that were requested in submission, so I'd probably have to give it more thought as to whether or not further consequential amendments were required, relying on that forest and bird submission. But it's something I can check through and come back to you on.
Okay, thank you. They're my only questions. Thanks.
Yes, thank you. I'm looking at your summary paragraph 15, and it talks about it's to do with the Levels Raceway. You describe the contentious nature of previous consents and the nature of conditions imposed on those consents. Could you elaborate a little about this, please, because it seems pivotal to your recommendation to not accept the special purpose zone?
Just to clarify, my recommendation is not to accept a special purpose zone because it wasn't requested specifically in relief sought by the submitter. It was just an option that I put forward in the 42A report. In terms of the conditions that are on those resource consents, I just felt that they weren't easily, adopted or turned in or converted to standards or rules in a plan to the point where it wouldn't potentially change their meaning or the way in which the activity operated, to the point where there might be a sense of injustice to the parties to those resource consents who feel like the scope of the activity that might be allowed under the district plan being more or less than what was in the resource consent. Now, I note that those parties weren't further submitters, but it is quite a change that would be required to the plan as notified in order to insert effectively a whole new special purpose zoning. So I thought the difficulty of that process meant that it was probably something that I flagged as a potential option in the 42A report, but on further consideration, I think that that's not an option anymore.
Okay, thank you. And my other query is around paragraph 6, where you talk about the issue with pest control being, the words pest control being in the CMS and the words weed control in the PDP. So would not weed control be implicit in pest control?
That was effectively the interpretation that I had. Yeah, as the submission was effectively seeking confirmation that weeds were included as pests, and so my interpretation was the same, that yes, they were. And then I looked at the actual wording that was included in the conservation management strategy, which effectively determines the proposed district plan rule in this case, and it uses the term plant pest rather than
Right,
weed.
plant
So
pest, right, got
so I think so based on that explanation that I gave Mr. Michelle, he was quite satisfied that the activities that they want to undertake could be undertaken under the district plan as permitted.
Great, good, thank you.
I have no further questions for you. Thank you very much.
Thank you.
Thank you, Madam Chair. Ask Mr Willis to present his summary, please.
Yes, thanks, Madam Chair. Commissioners. So, yes, my name is Andrew Willis and I prepared the Section 42A report on contaminated land and hazardous substances, and also the summary statement dated 7th of November on that topic area. And in accordance with your directions to Mr Boyce, I'll just take you through that. Starting at paragraph or section 3, which is a summary of the key issues. So these were the key issues that I identified in my Section 42A report in response to submissions on both the contaminated land and the hazardous substances chapters. And the first one was whether to broaden out contaminated land management to include risks to Indigenous biodiversity and environment generally rather than just human health. And then there was an issue around whether to control hazardous substances at all, given duplication and other legislation. Some submissions seeking clarification around how to apply a quantitative risk assessment for hazardous substances and what would that entail and when would that entail. And then whether or not to provide a pathway for extensions to major hazardous facilities. And then whether all the listed sensitive environments that were included in the plan were relevant to major hazardous facilities or not. And also there was a change in process, I understand, between when the chapter was done and when the planning maps was done. And there were a number of major hazard facilities were identified in the planning maps, but there were also significant hazard facilities. A number of those were shown on the planning maps, which weren't included in the schedule. My understanding was they were included in area because of a change in approach to major hazardous facilities away from significant hazardous facilities. So there were some errors in there which needed resolving, and a number of submitters queried whether they were major or whether they were significant or not. A lot of those issues have resolved themselves through the Section 42A report and subsequently through evidence. There's a key matter outstanding is whether or not all those listed sensitive environments are still relevant and whether I've done a reasonable job at narrowing those down. And in particular, it's in relation to natural hazards and its impact on the port. And there's a matter of detail at the moment as to what would be included or not included and how you might exclude or otherwise the port from those activities. There were also some additional matters that I hadn't identified in my key summary in the 42A report, which were issues, but I hadn't identified in that list, which are still live as identified through submissions. And one of those is whether or not to include the Redruth landfill as a hazardous facility or exclude it. That's come through. Whether or not to exclude underground fuel tanks at service stations from having the rules apply. And then there are a number of matters of detail relating to provision drafting in response to our recommended changes to try and achieve an outcome that responds to the matters raised through submissions. There's some evidence around whether or not that's created more issues or still not acceptable or not. I've identified a correction to my report. And then there's a list of resolved and outstanding issues. So that's set out in the appendix as well, but as set out in paragraph 9, there are some matters that I think are reasonably clear. And obviously what the first one is responding to that mistake in HSR 4, so that rule is simply around new major hazardous facilities, not additions, because I have now resolved that. There's I think we probably do need a new policy for dealing with natural hazards and major hazardous facilities rather than grouping it into policy one. I had originally thought we didn't need to, but on further looking at the evidence, I think that is actually appropriate. So I agree with the concept. What I haven't confirmed at this point in time is the wording of that policy, and also in particular whether it's all hazards, but not high hazards, or it includes high hazards as well. So I haven't quite formed an opinion on that yet. It's clear that the definition of sensitive locations in the existing plan has an issue in relation to wetlands and how that's calculated, and the submitters have pointed that out in their evidence of BP oil et al., and I agree that they're correct, so I think that needs to be resolved. It's an existing issue. And then the amendments for underground fuel storage, and I consider, based on the evidence presented, that it is appropriate to exclude those from those areas that are subject to flooding because they're underground. I haven't formed a view yet on whether or not they should also be excluded from those other hazards which may have an impact on those underground tanks, such as faults, liquefaction, and also impacts on drinking water protection. And there's also the issue around duplication with LWRP as well for drinking water protection, which I do need to work through as well. So those are the outstanding matters, and then the Appendix A captures my understanding of those in terms of what is resolved versus what is outstanding and outstanding in part. That was all I wanted to say. Just take any questions.
Thank you. Mr. Willis, where you say that you haven't quite formed a view on some matters that are still outstanding, is that in the category of you want to hear the evidence and discussion, or you're still thinking about it?
Well, it's both. I'm quite keen to hear the evidence presented and to see what questions come of that. But also I haven't formed a view on some of those because I haven't confirmed whether and how, for instance, the Land and Water Regional Plan might deal with drinking water protection and whether I'm satisfied that's sufficient. I haven't formed a view. Plus, there's the matters of natural hazards are still to be heard before this hearing, and that has an impact on where that goes with that topic. I am also the 42A author for that topic, helpfully. So I haven't quite formed a view yet on how natural hazards in the port will be dealt with generally, but also specifically in relation to hazardous substances.
Are you the author for the natural hazards?
Yes,
42A?
I am. I will be, yes.
So just in terms of helping us keep track of these issues as they go through the process. So as we've had in other hearing streams, there'll be an opportunity for you to provide some interim thoughts after this hearing on the basis of what's being heard. But as long as you clearly identify what still remains at large subject to the natural hazards chapter, if you could clearly signal in that response those issues that remain at large pending that hearing stream, and then perhaps in the natural hazards hearing stream, if you have had the chance to give some thought to it, it would be really helpful to have some drafting and to test that with the submitters on that particular issue, particularly where they've engaged planning representation or legal representation.
Sure. Yes, so just on that, I've had, I think, 2 or 3 meetings now with the Regional Council and the Port, specifically on natural hazard management for the natural hazards chapter in relation to the port zone. Yeah. And so that is evolving in the background.
Yeah. So it could be something that you could pick up in the 42A report for that next hearing stream, and then at least, and it would be good to have the drafting, because then that sort of focuses people's minds on how how it will interplay with these issues that we're dealing with.
Yes, Madam Chair, my intention is to provide a solution that parties are in agreement with for the port, assuming we can get that far, and provide that to you as part of that Bridgeway report. And that will also need to circle back to hazardous substances.
Okay. Thank you. That's good.
I have a couple of questions. So an outstanding issue, if I've understood this right, is still the port's requesting for like a blanket exemption. So when it comes to the definition of sensitive locations and also policy 1 of hazardous substances, they're seeking everything except for the port, or but for the port. And I think you're still considering that. Is that resolved, or is that one of those ones that you're waiting for further evidence?
I think it's reasonable for the port to be excluded from. You'll see in my 42A report that I've proposed or recommended a reduced set of sensitive locations to come up with a different definition, because I've reasoned through there that the existing zone provisions and district-wide provisions already cover matters such as the building and what is the issue of what's inside the building or the activity. For some of those sensitive locations, for instance, heritage, what is the issue of having a hazardous substances next to a heritage building as opposed to the building itself? And so my view is that could be narrowed down. So I've proposed a narrowed set of sensitive locations anyway, and then there's the question of which of those should still apply to the port or not apply to the port. And through my 42A report, I considered that of those, the most relevant that would still apply would be the high hazard rules for high flooding, high flood hazard, because that can include water moving at pace through that area, which can create issues on built form structures. So that one in particular, because of the way the rules are structured, it's kind of, there's a sort of not quite a double negative, but it depends whether and how it's referred to in the definition versus in the rule. And so that one's still outstanding in my view, but I was comfortable that the port could be excluded from all those other matters. For instance, it's not an issue of riparian margin, because there isn't one as far as I understand it. It's adjacent to the coast. And I think they do need to have them within 250 metres of each other, because it's a small confined space and they're already there now. And that's what the port does. It has these in close location to each other. So I was comfortable with those. And then obviously the other listed matters I was comfortable to exclude too. So it's kind of exclude from everything, except I'm still unsure about the high hazard matters.
Okay, no, that's really helpful. Ms Seaton, she provides evidence that says about half the port therefore will be included in the sensitive locations. And you're saying, well, it's quite reasonable for these areas, and you're still considering height, so I understand that response.
And if I might just clarify then, so just so the panel's aware, the operational area of the port is actually quite small, but then there are associated activities which are very clearly symbiotic and required as part of the port's operation, which are outside of the operational area. And so there's the question of, is it just the operational area or wider? And the port zone, PORTZ, is the wider area. And the majority of activity, or almost all the activities in there, I understand, are associated with the port, but not necessarily all of them. So it's more of a general industrial, but with association. So there's the question of whether it applies to those too.
Yes. Yep. No, that's really helpful. I have two more questions, not related to ports. So again, sensitive location definition, the reckoning definition, and you've said you now agree that wetlands should be excluded. Does that, sorry, you agree with the submitter? And I guess my question is, are you therefore recommending that wetlands is excluded entirely from that definition?
Well, in terms of the port, yes.
Sorry, I mean...
Sorry, not the port?
Not port, just generally. So under the sensitive locations definition, it did say that includes areas that are below the area of 100 metres from the edge of riparian margin or wetland area, and in your updated summary statement you said you do agree and accept BP's submission now, but I didn't know if by agreeing you meant to exclude wetlands entirely.
I see. Right, I understand. No, it's how the setbacks are calculated. In their evidence, they've said you're double counting basically through the definition of what is a wetland. So there's a distance on top of a distance, and I agree that there's an issue in terms of how the existing plan calculates that. Yes.
Right.
So it's just about the calculation. Yes.
And my final question is the definition of hazardous facilities, and this is me trying to better understand the submissions of Hort and who aren't coming to submit and prepare, even if they're not appearing at the hearing. So I thought I'd take the opportunity to ask you. They wanted a exemption for agri-chemicals used on the basis of a standard that they've presented, but I don't know that particular standard. And you have rejected that and said not recommended to accept the relief that they seek. And my understanding is that you're saying no, because of the quantity of agri-chemicals, if there's a particular quantity, that it is appropriate for the quantity to be included, and if there's mixing of chemicals, then they should be included. And so I just wanted to know, is the basis for you rejecting their inclusion because of the quantity or because of mixing or a bit of both?
So there's also a submission referring to agrochemicals from from the farming community as well. But it wasn't that one you're referring to, which is in relation to what is in or out of that definition of hazardous facilities. Agrochemicals are excluded. Yeah. So I'm just trying to clarify which. Have you got a submission number? For that?
There was NZAAA and
Yes.
HORT, and they both refer
Oh,
to...
HORT, right.
Yes, HORT particularly
Yes.
refers to the standard,
Yeah.
and I don't know what the standard is, and so I don't know if
Sure.
agri-chemicals should be included, and if so, or excluded, and if so, if it's a quantity.
Right. Yes. So the incidental storage of agrochemicals for land-based primary production is excluded from the definition of hazardous facilities already, just as a matter of course. And I think that's appropriate. And so there's a question around where and how that might apply for dairy farming as well, and I think that is excluded. And then there's a question around what are the quantities associated with what's incidental, and also for mixing off-site, is if you're doing it for like helicopters or aerial sprays as well, and there's a question in that. And in my view, that wouldn't be captured. It's not if you're just simply mixing it on the fly, that's not a facility, in my view.
Okay, that's it. Thank you.
Yeah, okay, thank you.
Thank you. I'll follow on the agrochemical question.
Yeah.
I also had looked over some of the submissions that we're not hearing from during the course of the hearing this week, and I did note that Rangitata Dairies had raised a question about the chemicals in dairy sheds, and it appears there may have been a bit of a talking at cross purposes almost, but I did have a question around. The submitter seems to want reassurance that the chemicals that they're using in their dairy shed wants confirmation as to whether they are considered agrochemicals or not, because then that then influences whether they're exempted or not. And I'm interested, it wasn't quite tied off,
Okay.
and I'd just be interested in your thoughts there.
Yeah, well, I saw that Rangitata Dairies Partnership Limited, so Justin O'Brien, I think, has provided some evidence for them. And he does cover that matter of whether it's their dairy sheds and the chemicals that they use there are agrochemicals. So my understanding is they are, and I appreciate what they've said in their evidence, but I had a quick scan of that and I was looking through thinking, so the definition of hazardous facility excludes agrochemicals and fertiliser and fuel for land-based primary production, and then I looked up dairying is a form of agriculture, and agrochemicals are used in agriculture. And dairying is a form of agriculture, and the definition refers to agrochemicals in dairying, and also primary production refers to agriculture and pastoral farming as well. So that's land-based primary production. So I'm confident that agrochemicals are excluded on the basis that they're associated with that activity and with land-based primary production.
Great, thank you. And the chemicals that the submitter is keeping in the sheds, do you know what they actually are? Like, has there been?
No,
No.
I don't know what they are. I'm just assuming.
So you're assuming that they're
associated with that activity.
Yeah, sure, which is
Yeah.
probably a sensible assumption. Yeah,
Yeah.
okay, that's great, thank you. I do have one minor query. In the plan set, in response to submitter Bruce Spears, in the definition of unacceptable risk, I note that there are 2 footnotes attributed to Mr. Spears, but there's only one change, and I'm wondering if I've missed something there or if that's
That's a matter of detail.
perhaps
I may have to come back to you on that unless I can quickly find that. I'll just search Mr. Spears. So the issue is that there's 2 footnotes attributed to him, but you're not sure what the second one's around.
correct. Just want to be sure I haven't missed something in the relief sort.
Or
It's seems to be the same submission point, doesn't it?
66.9. I'll have to come back to you on that.
Yeah, from my reading, it appeared to be just the way the calculation was expressed, the measurement was expressed, but I wanted to double check with you in case there was another change that you intended to have reflected but wasn't.
I think that's probably, just looking at it now, which I've now found, I think it's the issue is that I changed my decision. I put it at the end of the sentence and then thought, no, I'll put it after the change, and then I didn't go back and delete the other one. I think that's probably what's happened there. Yeah.
Thank you. If you could just confirm that for us, that would be really helpful. In terms of the outstanding matters, in response to the oil companies and the evidence of Ms Westerby and Mr Trevella, they're concerned that the recommended amendment to provision CL Objective 1 is now altered. And they're concerned, just find my notes. So in their view, they're concerned that the objective now relates to any risk as opposed to a more confined objective outcome. Are you able to explain to me your view on that, noting your own interpretation of how that objective now reads?
I struggled to understand what the concern was when I read it, actually. And I thought it was essentially saying the same thing but in a different way. Yeah, so I didn't see the difference in interpretation that they had identified. And so I was hoping that might come up through the hearing, and then I could hear that as well.
Thank you. We'll be asking that question, so we might get some more clarity there. Thank you. Similarly, in terms of the outstanding matter relating to the oil company's uncertainty regarding the meaning of management works and the intent of this policy, which is not already addressed by CLP2, have you managed to think this through, or are you again waiting for questions of the submitter?
Again, that's a matter that I haven't turned my mind to, and I thought I'd wait and hear the presentation of evidence and any questions that arose. Yeah.
Thank you. And one more question from me. In relation to Enviro NZ, and I appreciate that you want to consider this and that you've not formed a view, I note that Ms Rossa did provide a drafting option.
Mm-hmm.
Have you considered that at this point?
I think the drafting option provided would work. Should the decision should I recommend, or the panel determine that it's appropriate to exclude it, I think that drafting works.
That's all my questions. Thank you, Mr Willis.
Sorry. I'm just looking at HSO1, the objective. Do you think that objective reads well? Mainly the last part.
I'll just find that. Let me just find that, Commissioner. Do I think that HSO1 as recommended to be amended in my 42A report reads well? So the risk associated with the use, storage and disposal of hazardous substances are managed, and in relation to major hazardous facilities, unacceptable risks to the environment and human health are avoided.
Is there a word missing between facilities and unacceptable?
I think it's okay. There have been some strike-throughs at that point, but I think it's fine because of the comma that's there.
I just wonder, is it the same to say that the unacceptable risks associated with the use, storage and disposal of hazardous substances are managed?
Needs something
I just,
in there.
the last after the comma on facilities,
Yeah.
it doesn't make sense.
You could put a "the" in there, I guess, after the comma.
Oh,
Are managed and the unacceptable risks are avoided. So there's two things. You manage
Yep.
risks and you avoid unacceptable risks. Yeah. I think there's just a bit of a draft.
Oh, okay, right, I understand, right.
Yeah.
that's all, thank you.
And I have no further questions for you,
Okay, thank you,
Mr. Willis.
Thanks,
Thank you
Madam Chair.
very much for your report.
thank you.
Madam Chair, I'll ask Ms White to read her summary, but also just remind you that we've got Mr Harding and Ms Fluger online. And I'll ask them both to turn their cameras on just so that you know they're there. Thank you.
Just in terms of an update on timing, we were due to have a break at 10:30. We will take that break at 10:30 and continue after the tea break. Apologies to the two submitters lined up, but I think we have plenty of time before the lunch break to get through the submit. Thank you.
So good morning. I'm Liz White and I've prepared the Section 42A report that deals with a number of the natural environment values chapters, so specifically ecosystems and biodiversity, natural character and natural features and landscapes. My summary is a bit longer than my colleagues' summaries because there's quite a few more issues that these chapters traverse. So I will sort of skip through my summary but can stop and go back if required. The first thing that I just wanted to note was in my summary I hadn't dealt with the evidence of Melissa Pearson for Port Blakely. That was simply because I think there was some filing issue and I wasn't aware of that evidence. I have since read that evidence and I note that in essence we're happy with the recommendations with one minor adjustment. I want to think about that a little bit further, but I think that I probably agree on that point, so there's probably nothing outstanding, but I do want to just think about that a little bit further. At paragraph 3, that just identifies or repeats the key issues out in the Section 42A report. I won't go through those. Then at paragraph 4, I've basically listed the ones of those that appear to remain outstanding in terms of what's been filed in evidence. I'd note that it's a shorter list, but also that some of the issues have also narrowed. So, for example, there was an issue identified by submitters about how biodiversity outside of identified SNAs and other areas is managed. That issue has narrowed in terms of it being more about the specific details of the additional rule and policy wording that's been proposed. And similarly, there were submissions about the definition of riparian margins, and the evidence that's been lodged is now only in relation to wetlands. So yeah, paragraph 4 just sets those out. At paragraph 5, in addition to those key issues, there are a number of matters that were traversed in the Section 42A report and which have been responded to in evidence and which are largely outstanding unless I've made a recommendation. And that's reflected in the table as well. So in essence, paragraphs 4 and 5 are kind of a summary of everything that's in the table. In terms of corrections, I've just got a couple there that the evidence that's lodged has identified a couple of errors that I've just corrected. In addition, Ms Pearson for Port Blakely has noted that in my appendix I've recommended an advice note, but in the actual body of the Section 42A where I've recommended the rule that wasn't included, and she's assumed that Appendix A is right, so just to confirm that is the case, it is intended to be included, and so the Appendix A version is correct. As with the other Section 42A authors, I haven't provided a preliminary view on all outstanding matters. Obviously can answer questions with respect to those, and just at paragraph 10 essentially have outlined the updated or things that I agree with further to considering the evidence. I won't go through all of those because some of them are relatively minor, so they're amending matters of discretion. I just wanted to highlight at paragraph 10C, this is to do with the bat protection overlay, and I had recommended an addition that was supported by Port Blakely, but having read the evidence for the Department of Conservation, I've recommended, well, I think that one of the changes I recommended I no longer support. So I just wanted to highlight that to the panel because it was obviously resolved with one submitter and not with another submitter, and now I've thought about that further. So I just wanted to highlight that there is potentially still an outstanding matter there. Then just in terms of subparagraphs, I think E, F and H, they just relate to, so the additional rule that I've recommended that would apply to Indigenous vegetation clearance outside the other specified areas. There was just some further comment around the specifics of what was and wasn't included in that rule. And so in response to submissions and having discussed that particularly with Mr Harding, I've agreed that there could be some additional tweaks or clarifications in terms of definitions in relation to the specifics of that rule. So those were the main ones I wanted to highlight. Paragraph 11, I've just noted, I accept that there's an inconsistency in terminology around railways. I haven't made a recommendation around that because I think that that's something that I need to consider further in terms of what is the most appropriate term. I accept it should be the same one, basically. I'm just not sure what that is yet. At paragraph 12, I've just signalled there that I was included in some discussions between Environment Canterbury and DOC regarding a potential new rule for the bat protection overlay, and I understand that some wording has been agreed and that will be presented, I think, by those submitters, so I won't comment on that further at this stage. And then just from paragraph 13 onwards, I've dealt with the activities in riverbeds, which Ms Vella addressed this morning. So I haven't attempted there to address the jurisdictional issue, which obviously Ms Vella has dealt with. What I have, I guess, attempted to do is look more at the last matter, which is even if you can manage activities in riverbeds, should you? And so what I have attempted to do there is just have give a bit more thought to that as a sort of a preliminary position. The first thing I've noted just sort of in paragraph 14 is there doesn't seem to be a consistent approach in the other plans that are in the region. Because my first thought was if TDC is the only district doing this, then that might seem a bit odd, but that doesn't appear to be the case. And in particular, I've noted that the Christchurch District Plan does have areas of ecological significance identified, which include large areas of river or riverbeds. And those areas do have or are subject in the Christchurch Plan to vegetation clearance and earthworks controls. So that is consistent with the proposed approach. The other thing that I've looked at is just at paragraph 18, and if there's specific questions on this for Mr Harding, but I guess wanted to understand what the values of the areas that he's identified to then try and tease out, well, are they actually managed through the regional plan rules or not? So paragraph 18 just sort of sets out why he's identified those areas. And then at 19, and I think this was the question that you had around, well, what do the rules in the regional plan manage or not manage? So this isn't a fulsome, I guess, assessment, and I can provide a more fulsome one to the panel, but just from a sort of a quick scan of those, there's obviously a set of rules that manage activities in riverbeds. The ones that I think manage the same activities as the district plan are the ones that relate to vegetation clearance, structures and earthworks. So obviously we're not talking about the discharge-based rules. And from my initial read of them, I don't think that they manage landscape effects beyond natural character effects on water bodies identified as high naturalness water bodies. So there are high naturalness water bodies that are identified which fall within the ONL. But there are some other water bodies that are not, and so therefore the rules don't manage natural character effects or effects on landscape more broadly in relation to those. And then in terms of biodiversity, I think there are controls that relate to aquatic ecology, which makes sense. And there are some rules about restricting excavation with 100 metres of birds nesting or rearing. And again, there's some clearance of Indigenous species that are limited, but only where they're in those high naturalness water bodies. And I just note again that there are SNAs that are not high naturalness water bodies. So the other thing I've noted is the Land and Water Plan doesn't identify specific areas. So in terms of the mapping or the exercise that Mr Harding has undertaken, essentially that hasn't been undertaken for the regional plan with rules framed around that. So my preliminary view, based on having a look at those rules and thinking about that, is essentially that I don't think the rules in the Land and Water Plan go far enough in terms of managing the effects that are of interest to the district council's functions and in terms of achieving the objectives in the district plan, so specifically the eco objectives and in terms of landscapes, the NFL objectives. So that is a preliminary view, and I can do a more fulsome review. The other thing I would say is that I hadn't until this morning looked at the objectives and policies. The objectives and policies do have some direction around Indigenous values, basically, Indigenous biodiversity values. And so I might need to have a bit more of a think about that. The other thing that I wouldn't mind doing is also, if I can get hold of a helpful consent planner from ACAN, it would be useful to talk to them about where you have an application under this rule, what are the things that you consider, because I think that I've looked specifically, I guess, at the permitted activity standards. It might be that most of the activities would not fall within the permitted activity regime, and actually then you'd get into the objectives and policies and you do get that more fulsome assessment. So that's just my preliminary view, I guess, at this point, but appreciate that needs some further thought. Then just lastly, turning to paragraph 21, this, again, if you have some questions, Ms Pfluger is available. One of the matters raised in the statement from Te Runanga o Ngāi Tahu was about what is included in the natural features and landscapes schedule, and the specific request was to cross-reference to the SASM chapter. And I don't consider that that's appropriate, that kind of cross-referencing, but one of the matters included in the statement talked about mana whenua involvement in the identification and protection of landscape values. So outside the SASMs, what was their involvement actually in the NFL chapter? And so there's two things. One, which is included in the statement, but I understand from Ms Pfluger that input was actually provided by Ara Whenua in 2018. So Ms Pfluger does have a copy of some of that correspondence, and she can correct me if I'm wrong, but I understand that, so in the schedules there are associative values identified in terms of the ONLs, and within the associative values there is commentary around essentially values to mana whenua, and I understand that that came from the input that was provided by Ara Whenua, so I just wanted to make that clear. But I think the main point there is that Ms Pfluger and I agree that if those are not, if they haven't been captured appropriately, if the associative values in the way that they're described are not correct, then they should be corrected essentially by mana whenua. So there's no problem, I think, with doing that. I think the distinction is I don't think that should be by reference, by cross-reference to the SASM chapter. I think it should be in terms of reviewing the associative values and just confirming, was the information provided in 2018, has that been accurately captured? Should there be additions? Should there be amendments to those wording changes? So that's something that I can follow up with that submitter as well at the end of this hearing, and hopefully provide something in the interim reply. Cool.
Thank you for that, Ms White. Can I just one question I'd like to just explore with you now. In terms of your summary at paragraph 14, when you've looked at what's happening in other districts within the region, I appreciate one of the things we can consider is what the sort of regional approach to, and that sort of derives from the RPS. But in terms of the obligations of section 74, I'm just wondering about the emphasis on the Christchurch plan when the legislation requires us to consider what's happening in or the extent to which district plans need to be consistent with the plans or proposed plans of adjacent territorial authorities. That's 74(2)(c). And I just wonder whether or not, in the context of this particular issue, we should be more focused on what's happening in the district plans of adjacent councils, and whether you could break that down for us or provide a more direction on that.
So I think there's probably two things that I can do. So one we've talked about is providing a bit more of a fulsome assessment in terms of the regional plan.
Yeah.
And the other thing that I can do is look at all the plans of adjoining territorial authorities and how they deal with it. I think the point of drawing on the Christchurch plan was not in terms of section 74(2)(c). It was more because it was more to do with the RPS and looking at basically the districts that are covered by the RPS. So that was the reason. But I appreciate that there is another question there about, well, actually, are they the best one to look at, or is it the adjoining? Yeah.
Thank you. That would be helpful for me. Look, I think what we'll do is take a tea break now and then come back with panel questions for Ms White and then deal with the expert witnesses following that. Thank you. Okay, we'll return at 10:45. Thank you. Welcome back, everybody. We're continuing with the Council Section 42A report of Ms White and panel questions. So, Commissioner.
Thank you, Ms White. I'll start with the Rangitata Diversion Race Management submission. I have a couple of questions relating to the amendments that you have proposed to the ONF overlay and the additional clause you've added to provide for existing rock weirs as a permitted activity condition. Is there any risk of any unintended consequences with adding rock weirs to that list of permitted activity conditions if, for example, a rock weir might not have been lawfully established and doesn't have prescribed parameters or limits in a consent? Are there many kind of instances of this perhaps occurring around in rivers around the district where it might have a broader consequence?
There is that potential, but I would say that that potential arises in relation to all of the activities that are also currently listed. So I know in some plans, rather than just talking about existing, they do say existing lawfully established. And I mean, you could add that in terms of rock weirs, it just, ideally you'd add it to all of them. I'm not sure that there's scope in submissions to do that. But so I think that would overcome the what if they haven't been lawfully established, and then you're kind of actually permitting the ongoing activity. I'm not, so provided they've been lawfully established, I'm not too concerned. I think the issue that's been highlighted by the submitter, they've got an example, and using that example, they've said this is where we see there's an issue. I think that issue would arise with respect to any others as well. And the other thing I'd note is that we're really only talking about here about earthworks that are for the purpose of the maintenance and repair. So it's not authorising the initial establishment, which in itself would be captured by the rules and therefore be subject to consent conditions. So it's really saying if you have actually already got it and you're doing the ongoing maintenance repair of that, then that can continue to happen basically without the need for an additional intervention.
Thank you, that's very helpful. Thanks for talking me through that. In terms of that specific clause being added to the permitted one condition, can you explain to me if the same amendment is required for the VAL overlay, and if not, why not?
I just thought of that right before you asked me that question. And I think the answer is yes, it should be, and in particular because I think the VALs are less sensitive, so it shouldn't be more restrictive in those areas.
Just that would simply be the same clause added to the bottom of that list of permitted activity conditions.
Yes, that's correct. The other thing that I should say, and I can't, apologies because I don't think it was in my summary, but I also don't think it was in my 42A report, but it's something that I have talked to the submitter about, and if I haven't included it, then I'll include it in the interim reply. But there is also an issue that at the moment the mapping very close to the weir, there's an error in that it identifies it as both an ONL and a VAL, and that's actually incorrect, and it should only be ONL, not VAL. So basically the maps were changed to include it in the ONL, but the consequential change wasn't made. So the mapping is incorrect because it should only be ONL, and that's possibly why I only included it in that rule. But you're right, there's no reason not to apply the same management to where it's a VAL.
Thank you. In relation to Ms Williams' evidence from DOC, representing DOC, where they're seeking changes to the eco provisions to align with the NPSIB, and they've drawn on the Waimakariri approach in evidence to support the relief they seek. Have you had the opportunity to consider that And has that influenced your view at all?
So I haven't specifically considered the approach in the WIMAC plan, but I've thought about the specific, I guess, amendments that are sought, and I still have the original concern that I had, which is the NPS IB, to my mind, is quite comprehensive. And yes, it includes an effects management hierarchy, but the way that effects management hierarchy is to be implemented through the NPS IB is quite comprehensive, and it's knitted together. And I think it is difficult to simply just add reference to the effects management hierarchy in one place without thinking about, does it actually align with the NPS IB? And I think when you start going through that exercise, it's not. The difficulty you have is that you have the existing objectives and policies in this plan, and because they're not quite the same, you just start having to unpick, and that's my concern. So, and that's essentially why I haven't, I guess, looked at other plans and how they might do it, because I think in this context, we've got a plan that was notified before that was gazetted, and then you've got the NPS IB, and I think that having thought about how you could potentially pull bits of it in, I just think there's too much to unravel, and you'd end up having to basically do it all, which I think needs to be done in a comprehensive, separate process.
Thank you. And in relation to the policies that they seek in terms of having the effects hierarchy approach, etc., we've had some legal submissions from Ms. Vella today, and we've kind of heard about that, the practical implementation of a consent pathway and what that would look like. You're confident that with a non-complying activity, given the jurisdictional barrier with the gateway test, and then falling back to section 104(1)(b), that there's sufficient certainty there?
So I think that there is one example that Ms. Vella has given in the legal submissions that I'm less sure about, and it's that example where there is something that might have effects that are both more than minor, a non-complying activity, where the effects are more than minor and it doesn't align with, it would be contrary to the objectives and policies in this plan as they are, where there might be a gateway or a pathway through the NPS IB. I think if I'm less clear in my mind about the legal aspect of that in terms of whether 104D then says that's it, can't be considered, and therefore the consideration of it under the NPS IB can't occur, or whether you can then consider it in terms of 104(1)(b). I think this is also specific to quarrying and mining, less so for things like infrastructure, because that is dealt with in this plan. I did think about the possibility of amending the policy framework to have some sort of exception, and the exception either kind of repeating the NPS IB or potentially even referring off to it. But the difficulty, again, it's that unpicking thing. So if you look at the NPS IB, the clause 311 that says here's the exceptions, and then here's how you, here's then the direction that you then apply. The exception applies to a specific direction in the NPS IB, which is about avoidance, and what is directed to be avoided in that is not the same as what's directed to be avoided through the policies in this plan. So I think it's, in particular, I think it's Eco P5. And so if you provided some sort of exemption in Eco P5, then you'd be applying a broader exemption than what's in the NPS IB. So you get back into this kind of thing of, you can't simply go, oh, well, for quarrying and mining, we can sort of pull it in, because I just think there's too many moving parts. So there's that point that I made about it's very specific list of things that are to be avoided, which the exception applies to. The other thing is that it doesn't just say that applies to all quarrying and mining. It says quarrying and mining where you, I think there's a regional or national benefit and there's another type thing. So it's not quite as simple as changing the activity status for that activity, because that pathway isn't provided for that activity in every instance, and the exceptions are to specific things which are not the same as the plan. Sorry, that was a bit broader than answering your question, but I just wanted to explain that I had thought that through as to whether you could address that particular issue in some way, and I think it's very difficult to do that at this point.
That's very helpful, thank you. My next question relates to the Telco's submission and the evidence of Mr. Anderson. So the submitter sought that the roads be excluded from the provisions relating to ONF, ONL and VAL. And in your Section 42A report, you didn't support this. However, based on landscape evidence and drawing from the QLDC approach, you recommended a more permissive rule framework. And Mr. Anderson has responded to that, and in his view, it's too narrow, and he's drawn on some of his own implementation challenges that he's experienced through his work in the Queenstown district, I believe, to justify a 25-metre height. And one of his key points is that the diameter of a structure doesn't influence the extent to which it dominates a landscape, say. That it's not the height but the bulk of a facility that can detract from the appreciation of a view. Have you discussed this with Ms. Pfluger specifically? I know you've come back and responded with, in your summary, with some amendments to the standards, but have you specifically discussed that point around landscape?
So, yes, I have, and it might be a good time for Ms. Pfluger to jump in if you want her to. I think what I can say is that from that discussion with her, that has influenced the change in the recommendation around the minimum height. And my recollection is that we were persuaded in terms of the VALs because they're a less sensitive landscape. Well, perhaps I'll pass to Yvonne because I think her advice was it's the ONLs are more sensitive, need to be more conservative. But are you happy if Ms. Pfluger answers that?
Thank you, Ms. Pfluger. Did you hear my question?
Yes, I did, yeah. Well, so Ms. White has already sort of alluded to the fact that we discussed the differences between the ONLs and the VALs, and I think Mr. Anderson outlined in his evidence that he considers that the ONLs in Queenstown are very mountainous sort of terrain, and he understands in that context that the 8-metre height limit may be required, but also that is more practical. A lot of the older ONLs within the Timaru district are actually quite similar in that respect. They are the mountainous parts. The VALs are more modified in general and have lower landscape values as well. So in that sort of environment, I consider that, given that they're quite slender structures, with the amendments that Ms. White is recommending there, that would be acceptable to have them higher. But given that the ONLs are more sensitive and also, the sort of more mountainous areas, I consider that 8-metre is appropriate just in relation to other districts. I mean, I live in Queenstown and work here a lot. That seems to be appropriate in terms of the effects that those structures have.
Thank you. So, in principle, you're in agreement that the bulk influences the propensity to dominate. However, you're not convinced that in the more sensitive environment that higher height is warranted.
Yeah, 25 metres is very high.
Okay, thank you very much.
Kia ora, this is Commissioner Mackay. Before we move off that point, I just had one question on that, which is Mr Anderson also says that he prefers to look at the total facility height rather than pole plus antenna. And so have either of you given consideration to that?
Yeah, I think the final that we landed on was the total height. Is that right?
No, I think we'd, in my recommendation, I'd gone for 8 metres plus 3.5 panel antenna
But
above that.
For the visual amenity landscapes, I think it was the total height, wasn't it?
Yes, the amended recommendation is a total height, so yeah.
Yeah. I think the outcome is probably the same.
Thank you. I've got another question before we'll pass on to other commissioners. In relation to fed farmers, they've raised a concern that Eco R1.4 may still capture instances of ordinary pastoral farming practices, which involve vegetation clearance. And Ms Thomas has provided some detail about why, in her view, the rule may not be suitable. So, in terms of that rule, the limit of 2 metres, in their view, is not sufficient, and they seek removal of that 2 metres in the rule framework. And they provide examples, alternative examples. What would the impact of that have, and what is your view on that?
So I think, again, it might be appropriate for Mr Harding to comment on that from an ecological perspective, but I think in a general sense the intent of having that 2 metre, I guess, restriction is to limit the level of clearance that's associated. I don't think that that's particularly uncommon. I'd have to check some other plans. I know it's the same as that in the Mackenzie district. I think that there are similar controls in the Selwyn plan, but I'd have to double check that. But I guess it's because what that is trying to allow for is maintenance, repair or replacement of stuff that's already there. And it's essentially saying, here is the kind of the limit of what you can do, but as part of that. So it's not about, again, sort of new clearance, it's about that maintenance. But I wonder if Mr Harding would like to comment from an ecological perspective of whether or not the removal of that, I guess, 2 metre limitation, what effect that might have.
Mr Harding, did you hear my question?
Yes, I did.
Thank
Can you hear me okay?
Yes, we can.
Yeah, I hadn't turned my mind to this in particular, but I am familiar with this provision in other plans. And I guess my brief response would be that in some parts of the district, any clearance could have adverse effects on Indigenous vegetation. And so it is very useful to have some sort of restriction or standard to limit that effect if it's a permitted activity.
Thank you. And any particular reason the standard includes 2 metres as the metric?
No, I'm not aware of where 2 metres comes from, except that I'm conscious it's present in other plans, and I guess it's pragmatic. 2 metres provides sufficient distance to get machinery alongside a fence for clearance, for example, or perhaps a vehicle to clear a ford or crossing. I imagine it's pragmatic rather than ecological.
Thank you for that. That's helpful. I wonder if, Ms White, if it might be useful just to get a sense of whether that 2 metres is a kind of practical, consistent standard across other districts. Thank you. And my last question relates to fed farmers also wanting to remove the term grazing from the definition. I haven't got that of Indigenous vegetation clearance. And I was interested in your view of the appropriateness of that and what impact that would have if grazing was removed in totality from a definition relating to Indigenous vegetation clearance.
So the first thing I'd note is that it is, in my experience, it's become common to include that in the definition of vegetation clearance. So this plan and the proposed definition is not out of step with other plans in that regard. The other thing is that where submitters had raised concerns about the practical effect of that was addressed in the 42A report, which has resulted in some additional clauses being included. So the effect of removing it would mean that they were then redundant, because if that's not included in vegetation clearance, then having a permitted standard relating to it becomes a bit null and void. I also, I think that the submitter might have got a little bit confused with that, in the sense that they've sort of said because that new standard permits grazing that's not overgrazing trampling, therefore you can exclude it from the definition. But I think what they haven't appreciated is then that standard wouldn't link to anything. So I'm not quite sure that the reason for asking for it to be exempted is quite the right reason.
Thank you very much. No further questions.
Yes, I'll stay on that rule just for now. Just a couple of questions, and again, it might be for Mr. Harding or it might be for you, Ms. White. So I see that in Rule 1.4, there's a change from using dispositional landforms to naturally uncommon ecosystems, and I just wanted to understand a little bit more about what term is preferred and why.
I might start with that and then pass to Mr. Harding. So I think one of the submitters who's presenting evidence, and I can't remember if it's Environment Canterbury or the Department of Conservation, but one of them raised concerns about if you refer to depositional landforms, what does that mean? So in terms of certainty of the rule. So in discussions, I think, with Mr. Harding, and he thought a bit further about that, there was the consideration of, well, how would you define depositional landforms? But my understanding is that his preference would actually be, on further reflection, for it to be naturally uncommon ecosystems. And then, again, my understanding is that that is probably slightly more aligned with the Canterbury Regional Policy Statement, because correct me if I'm wrong, Mike, but I think depositional landforms are a naturally uncommon ecosystem, but there are other naturally uncommon ecosystems which would equally be considered significant in terms of the Canterbury Regional Policy Statement criteria, and I think that is really what Mr. Harding was suggesting should be effectively caught. Mike, do you want to comment any further on that? Sorry, I probably half answered it for you.
Yeah, I can contribute there. The origin of the depositional landforms issue is that in Policy 5 of the CRPS and the proposed district plan ecological significance criteria, Indigenous vegetation on naturally uncommon ecosystems is significant, so in other words would cross the threshold to be an SNA. The temptation to use depositional landforms was because that term is actually defined in the MPSIB, but the situation which it's trying to address in Timaru District is that there's relatively extensive areas of Indigenous vegetation in the upper Rangatato Valley which are not captured by SNAs, and they would there needs to be a provision to provide protection for that vegetation. The landforms which are should explain as well. The landforms are moraine and outwash gravels, but the MPSIB definition for depositional landforms includes colluvial colluvium, like sort of fans, large slope fans in that definition, and that's not appropriate in the Upper Rangitata Valley. They would not automatically be ecologically significant, and they are not defined as a naturally uncommon ecosystem. So my advice to Liz is, for clarity, would be to refer to naturally uncommon ecosystems, because they are defined in a published document and they are defined in the RPS, and they cover those the ecosystems which we need to provide protection for in those parts of the districts. The other ecosystem the other listed naturally uncommon ecosystem which is relevant in the Upper Rangitata is the braided riverbeds. So that'd be the three big ones. So yeah, so in summary, the naturally uncommon ecosystems is the preferred definition because it is defined elsewhere, and it aligns directly with RPS and proposed district plan significance criteria.
Great, that's really helpful, thank you. Still on that particular clause, but I do think this is a question for you, Ms. White. In your summary statement at paragraph 10F, you've reconsidered the doc evidence that talks about the inconsistencies between Rule 1.2 and 1.4, and you say that you will amend to limit clearance within an improved pasture. But what I wasn't quite clear on is whether or not that recommendation is then to make sure, in that alignment, will you be saying that the sensitive area rules will be more restrictive to line up with the less restrictive rules, or the other way round?
I think the answer is the other way around. So I think at the moment the sensitive areas rules is broader, so it would be amending that one, so that applies to riparian margins and a couple of other things. So it would be amending that one so it's more restrictive and aligns with the more narrow things which are included for the SNAs and for other vegetation clearance more generally.
Great, thank you. And last couple of questions. There's no submission on this point, but I wanted to understand a little bit better about how Eco Rule 1 actually works in regards to the clearance for customary use. And in that rule, it says that it's permitted for customary use where it's certified by Arowhenua that the activity will be carried out in accordance with the Tikanga Protocol, and that Arowhenua then notify the council prior. And I just wanted to know, is there an agreed system in place with Arowhenua at this point in time that they've confirmed and agree with, and understand that there's a Tikanga Protocol that's aligned with that?
So I don't know the answer to that question. I am aware that Arowhenua have been involved in the drafting of the provisions, and so I assume that this provision has had some input, but I don't know beyond that as to whether that type of protocol has yet been agreed and that type of thing.
Right, okay. I think that would be really helpful to know what they're committing themselves to. And my last question is in regards to the Turunga Rangitahu's request for the new rule for kati hui rapa activities in the NFL chapter. And my understanding is that you've recommended not to accept that, and Tront has provided evidence that there are structures that are permitted for existing rural activities and structures within these landscapes. And so I wanted to know, is the concern here about, does it hinge on existing or new, or is it the type of activity? So NFL Rule 1 permits for the network activities and also rural activities.
So the rules in the plan are largely not entirely, but they're largely focused on the building as opposed to what the building is then used for. So it's the effect of the building. Now, there is a distinction so that when you get into the standards, there are some distinctions, I think, between activities that relate to farming, an acknowledgement that the landscape in these areas is generally zoned general rural, and in the VAL it's rural lifestyle. So I think that there is some distinction made, and my understanding is that that's partly because from a visual effects perspective, farm, but with it being also a rural-based landscape, farm buildings the landscape is less sensitive with respect to those types of buildings and structures because of their environment. But other than that, I think it's more focused on what is the visual effect of the building or structure, as opposed to what is the building or structure used for. So my understanding of the request by the submitter is that they were wanting a permitted activity for buildings associated with a particular activity, but that doesn't address but what are the effects of the building on the landscape.
Right, okay, so so that means it's irrelevant where it refers to the existing rural activities or a public amenity or a network utility. Like if the activity itself is irrelevant, why are those things mentioned then?
Yes, so that's what I was saying, where there are some specific things, and my understanding is that relates to, so for example, a network utility, there's two things I suppose with them. One is that they are generally a different type of built form.
Yes.
And the second thing, I guess, is that we also have the energy and infrastructure chapter, which provides policy direction specific to that type of activity, and it's that balancing that, kind of enabling that type of activity with managing its effects. So it does make that distinction.
Right, okay. So if there's buildings that are there already that are used for existing customary activities, which is my understanding of the Tront request, is to say if it's already there and it's used for that activity, can it be permitted like those others?
So if it's existing, it won't require a consent because it's got existing use rights. So there isn't a need for a permitted activity rule to...
Right, it's new.
Yeah.
Okay,
New.
okay, thank you.
I'm actually following on from that chapter too, NFL chapter and standards. A submitter, H. Frank, was concerned that NFL S2 did not align with the NFL P2. And the submitter seeks that NFL S2.2 is amended to apply to 500 metres rather than 900 metres above sea level. And I just presumed in the analysis that you agreed with that. But my concern, I found it quite difficult to understand the map and what impact that would have between 500 and 900 metres with landowners. So I was wondering either yourself or Ms. Pfluger could highlight to me what impact that would have on current landowners by putting these kind of restrictions in place. I'd like to better understand, because obviously it's quite, to me, a fundamental change, and it covers a very large area, and landowners might not be aware of what impact this will have on them. So I was just wondering if you could educate me some more on what type of landowners would be impacted by this change.
So I might initially pass to Ms. Pfluger in terms of that question about the change in extent, and then once she's answered that, I can then say what is the impact effectively in terms of the rule framework.
Yeah, certainly. I understand you've been provided with the higher resolution map of, yes, that's good. So in terms of the ONLs, they are largely in mountainous areas, apart from the upper Rangitata Valley, which is a valley floor landscape. in terms of the contours along these areas, would you like me to talk through the map maybe a little bit? Is that helpful? Do you have the maps in front of you?
Thank you.
So on these maps, you can see the outlines of the ONLs in purple and the VLs in blue. And then within these areas, we try to show the 500 and the 900 meter contour lines. So the lighter yellow line is the 500 meter contour line. And maybe we start with the front ranges around the Four Peaks area. So in this area, you can see only really the tops are above the 900 meter contour. There are, some of the highest areas that this rule would actually apply to if it was the 900 meter contour. And I understand that was the driving force behind that submission, that that would only apply to very small areas. With the 500 meter contour, that's still some way up the slopes in the front country. So it would capture sort of the base of the slopes with the 500 meters. But obviously there's a difference between those two. With the 900, it would only apply to very small parts at the very tops, which it would be less likely that buildings or structures would be established up there. So that would capture, in my view, the 500 meter contour line would capture, in my view, the mid slopes quite well on those front ranges, which are visually quite sensitive because the front ranges provide the visual backdrop to the lowlands and are visually quite prominent. So that is, and I think there's quite a distinction there between the front ranges and then the Rangitata Valley, because the Rangitata Valley keeps rising. And if we look up into this area, again, the Mount Peel would really be the only area at the sort of southeastern extent of the Rangitata Valley that would be captured. And similar to the front ranges, all the mid slopes fall above the 500 meter contour. But then as you get sort of up to Boundary Stream and where the two ONLs change, that's where the terrain really starts to rise, and the 500 meter contour would capture a larger area. So I think I agree that would definitely capture much larger areas, and that would, I don't know how many landowners are up there. For them, that might be a substantial change because it captures all the lower fens, some of which are more intensively farmed, and then higher up as we get to Forest Creek, it comes quite close to the road in that area. So, and around Mesopotamia Station, the 500 meter contour line captures some of the farm buildings as well. So I think in that area, I could anticipate that might be more problematic for the landowner than maybe on the mid slopes of the front ranges. But I don't have a landowner map in front of me to tell you how many landowners would be affected by that. But that's certainly something that either us or the council could provide if that's of relevance.
I might analyse that a little bit more and flesh that out. Yep, thank you.
Mm-hmm.
Did you want me to comment on what that actually means in practical? Yeah. So in essence, where that rule comes in is where you've got a building or structure. So it does have quite an impact in that so there's other standards that apply in the area, and the buildings that are listed in Rule 1 effectively, so the ones we were talking about before, we farm buildings, including residential units and public amenity buildings. So previously they would have been, so between the 500 and 900, they would have been permitted subject to the other controls which relate to height. I think there's a size of building, reflectivity. So the main impact of the rule is that between the 500 and the 900, those buildings, even if they met the other standards, would not be permitted. It'd require a consent in the recommended rule framework. It would be as a restricted discretionary activity, but retaining the non-complying where we're above the 900, so it would take a tiered approach. So that is the key change and the impact on those properties that are between the 500 and the 900, is that where some buildings would have been permitted subject to the other standards, they'd go into that requiring a consent category.
Yes, Ms White. I've got to go back to NFL R5. I didn't quite hear what you said to Commissioner Mackay in answer to that, but my question is, the new rule request for NLF5 to permit buildings for Mahinga Kai activities, so can you just explain to me why other buildings, types of buildings are permitted and yet Mahinga Kai activity buildings are not permitted?
The short answer is no, because I wasn't involved in the rule drafting. My general understanding is it relates to the type of activities that are anticipated in the underlying zone. So the fact that it's a rural area, so the type of buildings that are permitted but subject to the controls on built form relate largely to farm buildings and public amenity buildings, because that is consistent essentially with the underlying zone. So I'm not certain that that's why that distinction was made between only permitting those types of buildings as opposed to permitting any types of buildings as long as they met those standards. So that is a guess on my part, but as a planner, that's what I would anticipate why those have been essentially given the permitted status.
So given that you can't get, the Kati Huirapa are not allowed to have a permitted activity status to erect buildings, how do they continue their associations with the landscape?
I think part of that depends on the question as to how the building would assist with that. In a number of these areas, they are also identified as SASMs, and there are similarly controls on built form in those areas because they are culturally important landscapes. So even if there was a permitted activity status in the natural features and landscape chapter, in a number of those areas, that doesn't necessarily mean that a consent requirement wouldn't be triggered under the sites and areas of significance to Māori chapter as well. So then the areas are not exactly the same, but there is a significant area that's identified as a Wāhi Te Puna landscape in the SASM chapter that is broadly consistent with the ONL.
I appreciate that, but the associations with the whole landscape, not just for a part of it, like in their area, it's like, in their reservation. So I'm just wondering how they can maintain their associations outside of SASMs.
Sorry, I'm not quite sure that I understand the question. I think the point that I was trying to make is that there's a lot of overlap. So Unfortunately, I don't have a map in front of me to show you, but a lot of the area that's identified as an ONL is also identified as an SASM.
Okay, all right, thank you. Oh, actually, I do have other questions, sorry. I'll just go back up here. Your new definition of overgrazing and trampling, are you confident that the definition will assist in managing the ratio of stock numbers, for instance, compared to the size of the confined area?
So that definition has been one that's come about through the advice of Mr Harding. It's also one that has been contemplated or is used in the Mackenzie District Plan.
Sorry?
It's one that's been used in the Mackenzie District Plan as well. Mr Mike can possibly comment on it a bit further because he's been, it's essentially his recommendation around that.
Yeah.
Are you able to assist with that, Mr Harding?
Sorry, can you repeat the question, please?
Are you confident that the new definition for overgrazing and trampling will assist with managing the ratio of stock numbers compared to the size of the confined area? So I'm not sure, I mean, I know it's just a definition. Does that direct policies, or does it assist with a policy or a rule to make sure that it's not an overstocked area?
So that might be a planning question for me, the way that you've briefed it. So yes, it's essentially that the reason for the definition is because that term is used in a rule. So it's to be clear that where we have added so I guess the concern that was raised by submitters is that because the definition of Indigenous vegetation clearance includes grazing, that there might be areas where, for example, sheep currently graze in an SNA area, and that's fine because it hasn't impacted on the values that are there, which is why it is significant. So an additional permitted activity rule has been recommended within SNAs to allow for grazing in those areas, but an exclusion to say, but it can't be overgrazing or trampling where that's within an area of improved pasture. So in essence, that definition is then linked to that to say, yes, continued type of grazing is permitted, but not when it gets to that level. So that's how it impacts the rules. I think the question might be then to Mr Harding as to, is he confident that the particular definition of overgrazing and trampling is capturing the right things to ensure that that stock can't basically destroy the SNA. So that, I think, might be the question for Mr Harding, is he comfortable with that definition as it's been proposed?
Yes, I'll double check that though and provide advice back to Liz. But just by way of background, perhaps, the situation has arisen because in identifying SNAs, there's some vegetation types which, such as tree land, where we have scattered remnant trees over pasture. And in practical terms, well, it wasn't practical to put an SNA or to describe every tree as an SNA because ecologically it's a vegetation type tree land, scattered trees over pasture, which is great. So the reason for this provision is to permit that continued use, which is grazing of pasture. And the other situation which is likely to arise is that SNAs on limestone landforms often have areas of exposed limestone rock, but some of the ecologically valuable or ecological values there are also on the soils, adjacent soils and grassland adjacent to those outcrops. So the SNA boundaries are drawn to include those, but those areas are grazed, and grazing is not necessarily a bad thing in those situations. So so that's the gestation for it, or the reason for it. I'll double check the rule and get back to you. But I was comfortable when I last looked, put it that way.
Thank you. I'm going to come back to you if that's all right, Mr. Harding, but I want to ask another question of Ms. White. My query is about Mr. Harding's recommendation, and it's to do with Eco P2. Is grazing livestock considered an ongoing farming practice?
Yes, I would think it is. So that's the intent.
So would the last sentence in clause 6 be needed?
In clause 6,
Yes. Where it says arising from grazing within areas of improved pasture.
so the way that the policy works in this instance is that the stem of the policy talks in a broad term about providing for activities where appropriate for health and safety, wellbeing of customary. And then it says by enabling clearance, and then it lists out essentially the activities that are then reflected in the permitted activity rule. So if it's not included in clause 7, then it's not clear that that's to be enabled. So you need both. So the bit that I've added or recommended be added to the stem is to recognise that we're not just talking about providing for clearance for health and safety, well-being or customary reasons, but in this instance it's to allow for ongoing farming practices. And then 7 is clear about what it is that is therefore enabled through the rule framework.
Okay, that makes sense, thank you. And I'm just going to go back to Mr. Harding, if that's all right. Is it ecologically best to clear all Indigenous vegetation from improved pasture, as Forest and Bird have requested?
Sorry, what was the question? Is it ecologically...
Is it ecologically best to clear Indigenous vegetation from improved pasture?
No. I'm not sure I'm understanding the question though, sorry.
So Forest and Bird have requested to remove all Indigenous vegetation from improved pasture, and I'm just asking you, is that ecologically sound to do that?
I'm not sure that that's,
Oh,
we're talking at the same, so is the submission from Forest and Bird is to remove, not physically remove Indigenous vegetation from, so it's not really an ecological answer.
so they
it's
want the
more
words
rule.
removed.
The words removed.
Right,
I think
got
is
you.
what the issue is.
Yes, that's my understanding, is that what, in essence, I think what they have said is rather than being linked to improved pasture, they have a preference that it's linked to areas, I think that the word might have possibly used as fully converted. So,
I get you, understand.
yeah. So that they're saying what you're allowing for is potentially too broad, or clearance in areas is too broad and it should be narrow. I don't think they're suggesting that, the vegetation be removed,
So they've also asked to map improved pasture. What's the advantage of mapping improved pasture, apart from the obvious? So what's the advantage of mapping improved pasture?
So I might answer this first, and then I think Mr. Harding can also comment on it. But so my understanding is that they haven't asked that improved pasture be mapped. They've asked that something along the lines of fully converted land is mapped. My understanding of...
I gave a safety briefing at the beginning, but thank you.
now I've lost my train of thought. Yes, so what I understand that they've asked for is that what they've referred to as something along the lines of fully converted land is mapped, and then clearance is essentially only permitted in those areas, which effectively would be regrowth. So in areas that have historically been cleared of Indigenous vegetation, it would allow for, as a permitted activity, for clearance essentially of Indigenous vegetation that's regrown in those areas. Now, based on their submission, I understand that they see the advantage of that as it narrows down what vegetation clearance is permitted. So improved pasture is a broader term than I think what it is that they're requesting. So rather than saying where you meet the definition of improved pasture, clearance would be permitted, they're saying you should map areas, but only those that have been previously fully converted, and therefore only permit clearance in those areas. What the mapping of that would not do, in my opinion, is it would not address the issue of how do you manage clearance outside those mapped areas. And so to my mind, even if you were able to map them, but I think there's a natural justice issue there, but even if you were able to map them, I still don't think it gets you any further ahead in terms of what is the appropriate management regime for clearance outside those areas. But Mr Harding could perhaps, if you wanted to hear, Mr Harding could perhaps comment on what's the difference between sort of what's captured by the definition of improved pasture and what would be captured in terms of fully converted land. But I think it's probably important to note that that question of what clearance is allowed has tried to sort of deal with that in the rule framework. So rather than through mapping, it's sort of, so where we've recommended a rule that talks about clearance and improved pasture, but not where it's in the naturally uncommon ecosystems, is to try and kind of address that balance that's required. Yeah.
Thank you. Thank you for that clarification. That's all the questions I have.
Would you like me to add to that, or you?
No. Well, yes, actually, you could. Sorry.
Just briefly, the converted land, which has been mapped in some other districts, is defined as land where Indigenous vegetation has been completely removed and the land's been converted to pasture or crops. Now, the advantage of that is it provides certainty and clarity, both to landowners and to district councils. In contrast, the improved pasture definition, which works well in most parts of the country, doesn't work well on non-woody ecosystems. And it effectively means that any areas of non-woody vegetation, even Indigenous vegetation, could be defined as improved pasture. The definition is quite broad. And so that's how the issue has arisen. It's an attempt to try and more accurately define land that has been converted from, or rather land at which Indigenous vegetation is not present. So those are the, one's quite a specific definition and quite clear, and the other's quite broad.
And I read your submission, Mr Harding, did you resurvey those areas that were surveyed 20 years ago to update the condition of Indigenous biodiversity?
If you're referring to SNAs, no, there's been no survey or further survey or review. That the district-wide survey, as you say, occurred over quite a long period of time, and there's been the ones that were reviewed, were the ones that were raised by submitters. Ms White asked me to comment specifically on those, but no, there has not been a general resurvey or review of the existing SNAs.
But in your survey, the one that you did, you covered, I think it was 95% of property. I think in only 10, you couldn't do 10 properties because they wouldn't allow access. Were those 10 in the higher country areas?
That's correct. There is, from memory, I think 2 properties in the lowland parts of the district, and the remainder were the larger properties up the Rangitata Valley. And 95% is the proportion of landowners who provided access, the proportion of landowners who were approached as part of the SNA survey who provided access for surveys. Those that didn't provide access, those properties were surveyed by a desktop method, but otherwise the process was the same. The draft SNA reports were sent to those landowners, their comments were taken account of, and then the SNA is finalised.
Okay, so in your survey, did you, like, how much of the area of Timaru did you cover?
I can't give you a precise figure or proportion, but all areas which we thought likely to support significant ecological values were surveyed. So that was determined by a number of means: aerial photography initially, roadside views, and then of course increasingly familiarity with the district as properties were surveyed. So all areas, I guess to clarify, areas of woody vegetation or wetland are quite obvious using that method, but areas of low-growing vegetation such as grasslands or Stonefield, for example, are less obvious from those methods. So the survey was an attempt to comprehensively cover all the indigenous vegetation habitat that we thought was present.
That's all. Thank you. Thanks, Mr. Harding. Thanks, Ms. White.
Thank you. Ms. White, I just had a couple of things for you. I'm just conscious of time, and we've got a couple of submitters who are waiting and probably have other commitments. So if I just flag them now, and perhaps on the main issue I want to talk to you about, if I can tell you what I'm thinking, and you can come back to me once the submitters have spoken. So just a couple of housekeeping things. I think a map showing the overlay of ONL with SASMs would be useful to the panel. And the other area, just picking up on a comment or discussion I had with Ms. Villa about the relationship of the ONLs and VALs with the Water Conservation Order for the Rangitata, and whether there's a mapping exercise that can be undertaken there that shows the extent of the influence of the Water Conservation Order with the boundaries of the ONL. That would be helpful, and then in addition to that, a sort of a comparison of value, what the values that are protected in the Water Conservation Order versus the district plan. Would be useful. But my main point for you was really just understanding the use or the recommendation around the use of an advice note to address the issue around commercial forestry and the effect of the regulations. And I'm just not clear on whether or not that's intended to flag an entire carve-out of regulatory matters related to commercial forestry that are within the ambit of the regulations, or whether there's some residual regulatory impact of the district plan, and therefore is an advice note appropriate, or should we be looking to include effectively a permitted activity that permits in the district plan that which is permitted by the regulations? Is that clear? I'm just not sure. And I'll ask the similar question of Councillor for Port Blakely as well, just to understand that. Okay, and yes, I think we will move on. So thank you very much, and thank you to Mr. Harding and Ms. Pfluger. The panel's got no further questions for you at this time, but if something arises out of submissions, we'll let Ms. Villa know and you can come back. Right. So our first submitter of the day was Rangitata Diversion Race Management, and I know you've been waiting, so thank you for your patience. And I think your legal counsel are online, is that?
Yes, good morning. Can you hear me?
Yes, you could come up and have a seat here.
So Vanessa and Corey are together?
Yeah. Yep, that's absolutely fine. Thank you. We're in your hands.
Thank you. I'll kick off. So good morning. My name's Vanessa Ham. Corey Lipinski, who's been helping me navigate this process, is sitting with me, and we appear for Rangitata Diversion Race Management Limited. Mr. Tony McCormick, who is the CEO, is sitting in the room today with you, so we do have a bit of a hybrid situation. And Rangitata Diversion Race Management Limited, or RDRML as we shorten it to, its infrastructure is largely located within the Ashburton district, but
obviously through this process we have picked up the overlays which apply to the rock weir located in the Rangitata River, and then the rules that derive from that. I will speak briefly to my legal submissions and obviously answer any questions and then hand over to Mr McCormick. Can I just check the legal submissions and the evidence have been pre-read?
Well, we've done a lot of reading, so any help you can give us in reminding us what you've said, that would be gratefully appreciated, but you don't have to read it word for word.
Certainly. Well, just to recap, in terms of this hearing, there are two overlays applying to the rock weir. Those are ONL2, which is the Peel Forest overlay, and the VAL. The submissions address both overlays, but I have noted the discussion from the reporting officer as to whether there should be any overlap between the ONL and the VAL. So that's the overlay that we're dealing with, and half of the rock weir is subject to that overlay, given that the boundary of the districts between Timaru and Ashburton runs down approximately the centre line of the Rangitata River. My submissions really address three issues. Firstly, whether there's clear jurisdiction for the Timaru District Council to create the rules. Secondly, even if there is jurisdiction, whether it's appropriate or a good idea to do so. And then thirdly, we have suggested a shopping list of relief to address the issues from the submitter's perspective, but I think there are some options in there which would also be acceptable to the council, so I'll go through those as well. Just on the first of the issues around the jurisdiction, I won't labour that. I agree there is some overlap between sections 9 and 13, and really the nub of my submission is that any rules need to tie back or shoot back to the respective council functions. And when I look at the Timaru District Plan, given that the ONL overlay in particular is largely relating to the mountain ranges, it's not clear to me that there's a clear intention to exercise a territorial authority function in respect of the activity that RDR is undertaking, which is the rock weir in the Rangitata River. So my submission is that that's not clear, and I suggest it is appropriate for the council to be clear about its intention as to how it regulates its functions. With that said, I'll move on to the question of merits and really whether it's appropriate to have the dual regulation or not. On that topic, I put forward three reasons as to why it wasn't appropriate. The first of those is that really the jurisdiction of the Timaru District Council only extends halfway across the Rangitata River. So I query whether it is appropriate or a good idea to exercise jurisdiction in effect of what is only half a piece of infrastructure, because the other half is located in the Ashburton district. That leads on to the second point I raised, which is really whether it leads to sort of confusion and unnecessary duplication. So the rock weir is clearly already subject to ECAN's rules. And I know there was a question earlier about the impact of the Water Conservation Order. So that order really acts to create an umbrella of rules within which ECAN can exercise its functions. The Water Conservation Order does include specific provisions with respect to RDR, given that the infrastructure has been so long-standing. And we have used one of the provisions in the Water Conservation Order as the basis for one of the suggested relief points. The question was also raised about the adjacent territorial authority, the Ashburton District. The short point is that consent would not be required under the Ashburton District Plan. But just to explain, and I'm sure Ms White will come back to you on this as well, but just to explain how that works, the Ashburton District Council similarly has overlays which extend to its boundary, but its rules around earthworks are somewhat more, I would say, enabling in that they are a simple volume and square area calculation. I think it's 5,000 cubic metres and 2,000 square metres in any 1 year. So given that that of course only applies to half of the rock weir, the half located in the Ashburton district, that doesn't trigger any need for consent. There's a further prohibition in their rules around areas of significant conservation value, but that has a specific exemption for RDR infrastructure, which is specifically named, and I'll come back to that as a possibility when we discuss the relief. So it's my submission that really it's sort of unnecessary duplication and confusion to have, overlapping rules between ECAN, Timaru District, and Ashburton District, and the Ashburton District plan is certainly not problematic in the way that it's been set up. The last point I raised in respect of the merits was that the overlays have been established with existing activities in mind. In other words, when the overlay has been assessed, things on the ground have been taken into account. So ONL2 remains outstanding regardless of whether, or even with the rock weir in place. So on that basis, my submission is that there's no need or warrant to then create rules around that, given that ONL2 has already been determined to be outstanding with the rock weir there. With that, I will move to the relief. Just to preface briefly in respect of the Section 42A report, the reporting officer had recommended that rock weirs be treated the same as other items. I have flagged in there that in respect of the rules relating to this overlay in particular, they don't include replacement. And that is distinct from the rules relating to the significant Māori sites overlays, the SASM overlays, where replacement is included. That is important from RDRML's perspective because the nature of the rock weir, as you will have seen from Mr McCormick's evidence, and he will speak to, is that during flood events it decays, and so RDRML gets back in the river to rebuild the rock weir. So that could be considered replacement. And I think if the council was minded to put specific provisions in the rules and standards, we would be asking for replacement to be included in there. And secondly, just to mention the height limit as well, because there are height limits in the standards. And again, they make perfect sense when you're dealing with issues on land, but they are difficult when dealing with a rock weir in a riverbed where it's not possible to measure that precisely, and there is some risk that the height limit in the standard could be exceeded. Just with those general comments, I'll just move to the shopping list in our legal submissions, and that is at page 6. And paragraph 18 onwards. There's essentially 6 suggestions there, and they really fall into the most preferable through to the least preferable. And it's really the ones in the middle that I think would meet the interests of both RDR and the council. So the first suggestion, as per the RDRML submission, was simply to remove the overlays as they extend across the river to the edge of the Timaru district boundary. Now, I anticipate that to be the least favourable option to the council in terms of preserving the integrity of the overlays as they've been determined by the landscape architect. So the next items on the shopping list, so our 2, 3 and 4, really relate to creating an exemption for rock weirs where they fall under the overlays, and we've made 3 suggestions in that regard. The first is simply to have a provision saying that although the overlays cover the riverbed, they don't apply to the rules don't apply to the bed of the river. The second one is to acknowledge that existing rock weirs are part of the existing environment and are exempt from any rules. And we've proposed some wording around that. And the third suggestion is to pick up wording from the Water Conservation Order, which is the provisions of this section, and I've just square bracketed natural features and landscapes, do not apply to the maintenance authorised by the Canterbury Regional Council of existing rock weirs and river works to the same level and extent as occurring as at 1 January 2000, or to the placing of new rock works and the carrying out of river engineering works necessary for flood and asset protection purposes. So that clause has been adapted from the Water Conservation Order, and I'll just read out the reference for Ms Vella and Ms White. That's in clause 8, which relates to restrictions on damming, and it's subclause 3. I can't tell you the reason for the 2000 date. I suspect that relates to when the Water Conservation Order proposal was first promulgated, although the final order is dated 2006. But that would address the matter from RDR's perspective. So any of those three options in my submission would address both the submitter's concerns, but also preserve the overlay from the council's perspective. The only thing I would add in respect of those three suggestions is that we have endeavoured to take a principled approach and refer to rock weirs. Obviously, from RDRML's perspective, there would be no difficulty specifically exempting the RDR rock weir, which may address a question I heard earlier as to whether there would be any unintended consequences by exempting rock weirs generally. So just to confirm, that would also be acceptable to RDRML. The last two items in our shopping list really endeavour to work with the rules in the proposed district plan, but include further provisions and standards that would address the issue from RDR's perspective. So one of those, and they're set out in the appendices to our submissions, but one of those is essentially just to have a permitted activity rule for existing rock weirs, and the other one is to make amendments to the ONL and VAL rules and standards to include existing rock weirs, but also to include a provision around the height, just to make sure that that wouldn't be problematic for RDRML in the future. As I say, those two are the least preferable options from RDRML's perspective, but do endeavour to work with the rules of the plan as promoted. So with that, I don't propose to say anything further, but I'm obviously happy to answer any questions.
Thank you for that. Look, from my perspective, they're very practical and helpful suggestions, and we have asked Ms White to do a little bit more work around the comparative analysis of adjoining districts in the Water Conservation Order as well. So when that work emerges, perhaps if you can, or Ms White can engage with you around that, and you can check that, whether that meets with your understanding.
Certainly.
Then we can look at those issues more clearly. So do you have any? Yep.
Thank you, Ms Ham. I do have one question for you. You referred to the relief sought, the desire to have replacement within the provisions along with maintenance and repair for the existing rock weir. When does the replacement of a rock weir constitute a new structure as opposed to the maintenance or repair of an existing structure?
Yes. Look, it's not, I mean, I don't think the term replacement was defined. The concern from RDR's perspective is that sometimes, depending on the flood event, up to 65% of the rock weir erodes, so it is more than half. So it wouldn't want to be in the situation where it's being asserted that rebuilding more than half the rock weir is not maintenance or repair. So it is a cautionary request, but I'm not aware of any hard and fast rule around when we tip into replacement or not.
Thank you. So it is very much around the desire to recreate the rock wall for its full purpose, and it's less about creating a different form of a weir into the
Yes,
future
that's
if need
right.
be. Yeah. Okay. Thank you.
Look, my question was on that, but I actually think it was potentially a question for Mr. McCormick, because what I was trying to relate with that then is, why have we given this example of December 2019 where 65% was washed away? So, and how often would that kind of event happen so that how we know the line between that replacement and new?
I can get Mr. McCormick to talk to that when we get to him.
Thank you. I would perhaps suggest reinstatement instead of replacement might actually ease everyone's, and I'd certainly be comfortable with that, because it is about just recreating what was there beforehand, and it's a little bit more than maintenance on those big ones. As far as frequency, I did note in my evidence I labelled that flood as 2009. That was the 2019 flood, which did a lot of damage around the district. But on a busy year, we might be in 3 times repairing or reinstating, and the degree of that work would depend on the degree of that flood. The 2019, I think, was about a 1 in 50 year flood. Quite a bit of work. So look, a lot of the time it is just a little bit of maintenance, just to maintain the height. But it's those big events like you've seen in that flood and the whole idea is that it takes it out and creates a floodway. So yes, I haven't talked with Vanessa about it, but reinstatement would be a term that I think might sit better with everybody. Avoid those concerns that have just been raised.
Right. Thank you very much for that. Ms Ham, if you wanted to reflect on that alternative, I'm happy for that to occur, but it seems like there's a bit of a spectrum between maintenance and replacement, and perhaps that's the right landing point, but we understand.
No, look, I have no difficulty with reinstatement. It was more that replacement was the word that was used in the SASM related rules. Yes.
Thank you. Ms Ham, will the panel have a few further questions for Mr McCormick, so we'll deal with those now.
Certainly. Well, can I just ask that we go to Mr McCormick and he has an opportunity just to speak to his evidence briefly before we get into questions?
Absolutely. We have read it and have got it in front of us here, but we're certainly able to accommodate that. So, Mr McCormick, thank you. We have your written evidence, but please give us a bit of a précis of what you've and emphasise any points that you'd like to make, and then we'll have some questions for you. Thank you.
At the risk of sounding a bit like Seven Sharp, I thought I might talk to my pictures. All these pictures were in my evidence, but there was a couple of things. I really just wanted to give you some comfort, I guess, about the nature of our works, the nature of the facility. So the RDR has been there for 85 years. It was... Okay. And I guess just a little bit of a personal thing, in many of my roles, I've worked out that when Mother Nature is one of your key business partners, you have to learn to be very flexible and adapt and prepared to work with Mother Nature, because you'll never win the competition against it. And the design of this facility is very much aligned with that. The weir is fusible. It is there to... As you can see on this, all our assets are on the north bank, and it's only the weir that extends into the TDC area. And the weir is there simply to maintain a water level so we can divert the water. It has been there, well, from the initiation date, because it's all about, providing a floodway when it's required, but maintaining that water level. And in this picture, as I say, this predates both 2019, I think, the flood, or might have been just after it, but it certainly is in need of a bit of repair. It would normally be a bit more defined, have less leakage, and we do have this channel, which we've done some work on more recently, that provides for rafters, kayakers and fish passage. This picture, is a better condition weir. You can see what it's doing. The river level on the upstream side is obviously slightly higher than the downstream side, and the flood that I talked about. The only other things I really wanted to say is what it's not. I mean, even earthworks, defining this as earthworks makes me nervous because it really is quite unique. We pick and place rock, and as Ms Ham referred to, even the issue of heights, talking about defined heights of either excavation or the height of the weir is quite difficult for us. Our consent defines a level, and that's what we do, and I guess that one is a good example. We build the weir to create a crest level that therefore holds and diverts water. So it's not quarrying, it's not extractive, and it is an existing facility. So, and the consent would be one of the simplest consents I have in my suite of about 50, which just says maintain the crest level by using existing materials within a 2 kilometre stretch. So that's quite relevant, we never go certainly upstream 2 kilometres. Now and again we might venture there, but the extent of works is very well defined. And I think really that's all I'd like to say. I would like to acknowledge both Ms White and Ms Vella for their input into working up constructive suggestions and outcomes as we work through this.
Do you do any monitoring on fish passage so that, the weir enables fish passage?
We don't monitor fish passage or measure fish going through. We've recently spent $18 million on our fish screen to ensure that the downstream migrating small fry come into the get. They are all safely returned to the river. The only monitoring, I guess, is the fish spawning surveys that are done upstream. We're not involved in that. That's carry out those on an annual basis. The species of concern tends to be salmon, and there's so much going on in that area globally. But the rangitata, once again, is one.
Yeah.
I'd suggest the weir is not the issue.
Yeah.
Rest of the fish screen virtually eliminating the adverse. But there's no question that the upstream migrating fish, which salmon will be tuna, they will have no problem with this. If you look up the gorge, they'll have a much bigger challenge getting through that and getting at it.
Yeah, that's right. Okay, thank you.
Thank you very much for that presentation. That's very helpful, and we'll hear back from your legal counsel once the further comparative work's done. So thank you. Thank you, Ms Ham, for your attendance.
Thank you. So just to check, no further questions for Mr McCormick or I?
No, not at this time, but as I said, there's a little more work that's being done by Ms White, so we'll give you an opportunity to review that, and if there's any issues arising, we can address that at a later time. But thank you.
Thank you, and thank you for your time.
Right. Ms Vila, just before we go to the Regional Council, just in terms of the ONL assessment, one question I didn't put to Ms Pfluger was the extent to which the ONL does take into account the infrastructure for the Rangitata diversion race. So if that could be clarified, happy for that to be done in writing, but just picking up on the point from the submitter that it's there, so it must have taken it into account. But yeah, thank you. Regional Council. Yes, that's great, thank you. Thank you. Right, who's leading? Is it Ms Francis? Are you leading the? It's quite a lineup. Thank you.
Sorry. To my left immediately, we have Dr. Jean Jack. She's an ecologist and team leader with Canterbury Regional Council. Next, we have Michael Boschen. I hope I pronounced your name right. He's a river engineering officer based here in Timaru. And then we have Jolene Irvine, who is our rivers planning advisor with Canterbury Regional Council. So if I could start. Unfortunately, I need to say that there needs to be a correction to paragraph 46 of my evidence. It currently refers to paragraphs 40 to 42, and that's incorrect. It should refer to paragraphs 43 to 45, so just to correct that. Would you like a bit of a synopsis on all of the evidence, or would you just want...
I had understood, and correct me if we're wrong, that there'd been a reasonable amount of progress made with resolving issues. So perhaps we don't need to go through all of the evidence in any detail, but certainly if there are matters that are not yet resolved and you want to highlight those for us, please do. Otherwise, just give us an overview. That would be helpful.
Okay, just to summarise, we've had discussions with Ms White and with the Department of Conservation in relation to the overlay for the bat protection area, and Ms Irvine has proposed new wording in her summary statement, which has been agreed with the Department of Conservation. So if you have any questions about that, probably Ms Irvine's the first person to put that through, and Mr Boschen is able to support that in terms of the practical implications. The other issue that was in relation to some concerns we had about wording within the permitted activity rule in relation to definitions around it was the depositional landforms and the cultivated area. So those new definitions have been proposed for that. So if you have any questions about that, that would be for Dr. Jack. That's probably that's the main outstanding ones, I think.
We might just move to questions.
Yep.
Well, I will take the opportunity to ask Dr. Jack then about the cultivated land definition and dispositional landforms as opposed to natural uncommon ecosystems. So starting with the cultivated land, with that particular definition, it seems to me that, so I just wanted to check whether that particular definition that's now been recommended by the reporting officer does provide the relief sought by the Regional Council.
Yeah, hi. Yeah, I think the proposed changes or a definition for that was going to put a temporal element into the cultivated land. And yeah, I considered the 15 years as appropriate, somewhat aligns with what you might expect to have developed after 15 years. My concern was around that there are areas that have been historically cultivated decades ago that have subsequently developed significant vegetation or habitats. That I'm mostly familiar with around the Waimakariri floodplains and places that you could point to and say they were cultivated. So this just puts that temporal parameter around it. Yeah.
Great, thank you. And my second question, we talked about this a little bit this morning with Mr. Harding, and that was whether the naturally uncommon ecosystems is a better replacement to the dispositional landforms, and his evidence was that actually it more closely aligns with the RPS. So I just wanted to find out from you what you consider the more appropriate term is.
Yes, I think the naturally uncommon ecosystems will be much more encompassing of vegetation that's going to be determined to be ecologically significant, because that will align with the RPS criteria. I understand that concern that provision was particular to the upper Rangirikitata with regards to oversowing. But yes, it will be more broad, and depositional landforms include the outwash gravels and the moraines and the braided rivers that you'll get up in the upper Rangirikitata. But it would also cover limestone outcrops, any other uncommon ecosystems. There's like 76 or so in the country. Yeah.
Sorry. Thank you. My next question is in your evidence you talk about the limitations of the SNA mapping process, and particularly you point out about how landowner agreement is necessary, and that becomes a limitation. In this plan, we've had evidence from Mr. Harding that 105 landowners were approached, 95 gave consent, and the remaining 10 were done through desktop analysis. So given that, how much of a issue do you think the lack of landowner access is for the mapping in this district?
Yeah, I guess it's limited to that they've then undertaken desktop assessment anyway. I guess I was making the point that certain values would not be able to be understood or mapped when you need to go on site to understand them. So it's been limited to what was available on desktops. I'm not sure if those for which access was not allowed, were there some that were not allowed, that were not, that, like, no SNAs were determined for those properties, which you might have to go on to determine them. So I'm not quite sure if there was a gap there or not.
Yeah, like were the 10 out of the 10 designated or only one?
Yeah, did all the ones without access still have SNAs, and were the boundaries of those SNAs comprehensive given a lack of ground survey? So even though you might be able to recognise SNAs on these properties that you don't get access to, you presumably have only mapped the bits of that property that are obvious from desktop. You might go onto a property and determine further extent of the SNA from being on the property. Yeah.
My understanding of his evidence this morning also was that it's mostly was those high country stations that weren't given access. And so does that make any difference that it was those particular areas? Are there more ecological values there that we should be aware of?
I'm not sure. I'm not hugely familiar with what has been mapped in that upper catchment. I'm just pretty sure that when you usually do ground survey, you'll find more things will become more apparent when you're actually on site than what's available on a desktop survey. Yeah. So particularly those low stature ecosystems that that you can't see on aerial imagery.
Yeah. And in Mr. Harding's sorry, I'll cut you off.
I was just going to say that I wouldn't limit it to just the upper. There will be, I think, in some of the rest of my evidence just goes on to talk about the things that aren't obvious from desktop mapping, and particularly faunal habitats, that might not be reliant on Indigenous vegetation. Yeah.
Okay, thank you. And my last question is, so in Mr. Harding's evidence, he talks about the limitations on having resources, and therefore, there is a need to actually identify when you're doing surveys, you have to target those areas that have like the high value sites, and some of the unknown perceived low value sites haven't been mapped and don't get mapped. And so from your perspective, how much of an issue is this? Targeting areas when there's a need to limit your resources.
Yeah, no, I think it's wise to prioritise your effort to capture more with limited resource and time. I think there will be areas that go unmapped, which could be just as important as those that are mapped, but for which are difficult given the effort and expertise required. So particularly thinking about things like invertebrate surveys or things that need specialist survey and effort identification. Yeah.
And that's why it's important to have rules outside of...
Yeah, it'll assist with the protection of such areas.
Okay, thank you. Did you want me to go and ask questions of others?
I'll just see if there's any other questions. Did you have questions for Ms. Jack? Come to Ms. Irvine shortly.
Okay.
Can any SNA be identified without ground truthing, say from desktop studies or from doing, surveys on neighbouring properties?
Yes, you can identify significant ecological values from desktop information or aerial imagery, so some of the things will be quite apparent. Some of the naturally uncommon ecosystems, limestone outcrops would be quite, and where they have Indigenous vegetation or habitats. So, yeah, you could be reliant on past survey reports or what could be seen from the roadside. So it's possible to map these or to identify.
How robust would it be if you couldn't ground truth it, I mean? Like, would it stand up in court?
Yeah, there will be a temporal element to it. So obviously past surveys are dated, so it would depend on the values that have been identified, how apparent they are in aerial imagery, for instance. Saying that, I am aware of limitations to the use of aerial imagery in courts. So I would always look for recent ground survey to provide the evidence that the value exists currently. There'll always be that challenge.
Okay, thank you.
Yes.
and should do. I think was,
I guess it would go some way to further protecting significant ecological
even if that information meets sufficient standards to reliant on ensuring it's sufficiently robust to pick up the areas that could become SNA.
You lost me a bit there, but I think essentially there will be benefit, and it would assist with that protection of SNAs or significant natural areas if further mapping and assessment is undertaken. And then in my evidence, I suggest that, you know, things could be prioritised towards further mapping of these values that were perhaps not such a focus or underrepresented in the current suite of SNAs. So I'm talking about the faunal habitats or use of non-Indigenous vegetation. So there's habitat.
Asking us to include those to satisfy ourselves that there's sufficient information available now today in this process from
Right.
the district plan. Are you suggesting, do you just making a submission to the council that it should prioritise its resources in the future
Yes.
to implement this?
Yes, because it's an iterative process that I think you'll always be finding new values, given that some areas, you know, it's dynamic, things will change in their values or over time. So it's not a static map that you're going to tick off.
But there's what the MPs advise the council, is that
You identify all of them.
once that are mapped and we're sufficiently satisfied that there's a sufficient distribution of the district plan, then that's one way of implementing. But then there's more work ongoing for the council, either if it picks up an area through a resource consent process or through its own evaluative work. But then that will be the subject of a future change, not this process. Struggling to understand how, as a panel, we future SNAs.
Yeah, I guess I'm just saying that it's a iterative process, and that might conflict somewhat with what the MPS is asking for, that it's saying map them all now, when they could change. Like if they either we know there's sites, or we suspect it's quite likely there's sites that haven't been mapped, and that those sites might change over time to become significant, or even to, you know, lose their significance. So you're dealing with ecological processes that change over time. Yeah.
And I might be expanding question, but how do you capture, the key section provides that framework, doesn't it? It provides the direction to councils as to how it goes about keeping an eye on new information, further evaluations.
Yes, and I think that leads to why we ended up accepting the definition for SNAs, because of what's actually written in the MPSIB, because at a different level, as Dr. Jack said, SNA is going to change over time, in particular with things like climate change. One of the criteria is about the limits of distribution for a species. So with climate change, that's going to change, and that's why initially we were opposing the definition that said all that matters is what's mapped and included in the schedule. But the MPSIB makes it very clear that that is the definition. It has to be in a schedule and it has to be mapped in the plan. So, yeah.
But it doesn't mean that the council can't
Change it in future.
over time and then
Yes. Yes, that's correct.
Yeah. Now, yeah.
Thank you, Ms Irvine. I'm interested in a couple of drafting questions here. So it may be more appropriate for Ms Francis, but they are on your evidence statement, so I'll start with you. Under permitted 2, you've got the tree is, and then you've got 3 clauses there, and you've got ground level, ground level, ground level underlined. Where did that come from, that drafting?
The drafting for per 1 and per 2 are as proposed in the Timaru District Council plan. I did not make any changes to those draftings.
So when I look at Eco R4, we're looking at Eco R4, aren't we? Yes. Per 1 and per 2 and per 3, as notified, there's no underlining of or additions for ground level or ground level?
Excuse me if I can, they're hyperlinked in the plan. That's why they show up as underlined.
Excellent. I was very confused there for a moment. That explains that question. Excellent. I'm here, I have noticed that, and this is probably more a question for Ms White, given it was a notified provision, in number 2, there's a word greater at the end, ground level greater, and I'm wondering if that's superfluous. Anyhow, back to my next question for you. So in relation to permitted 3, where you've convened with Doc and also Ms White on this drafting, and they're all in agreement of that, did you say? Or was just Doc, or...?
I guess those submitters will need to speak for themselves, but my understanding is that we are all in agreement. I am prepared to recommend that drafting.
So clause 3 of that, it relies on a external document to the district plan. So the works are assessed as being consistent with the Department of Conservation's Bat Roost protocols, and there's a date there, October 24. My understanding is that it can present challenges down the track, having a reference to an external document that can be updated, and then all of a sudden you're creating a bit of a problem with how the rule can be interpreted because there might be a more recent protocol which applies. Is that something you've discussed with Ms Francis at all?
Absolutely. Yep, this was part of the conversation we had with Doc, and again, I think they're probably best placed to talk to the inclusion of that date. My position on it is we looked at having drafting to refer to a current version of a protocol, knowing that as it evolved in time, we would move with it. But for legal certainty, it was preferred to have a date in there. I think as a regional council, either regardless or as well as what is documented within the district plan, we would also move with the time. So if there is a future version that might be more restrictive, the expectation would be for the regional council to also comply with whatever update is required, just to maintain that public servant, expectation.
Sure. So does that mean that then this permitted activity condition can't be applied if the reference is incorrect, in the case that there's a more restrictive or a changed protocol?
The permitted activity could always and would always apply, held to that 4th version of the document there, but typically when these types of reports are reviewed, they get more restrictive, and so if there's a new criteria that comes in that becomes of value to protect the habitat, I would think through our relationship with DOC we would still honour that agreement or that requirement. So the including the date provides certainty, I would be quite happy for it to be removed. But I think the protocols now are thorough and provide confidence about the expected assessments required.
Okay, thank you. So there's a bit of goodwill built in there, which I'm not certain how robust that is for a planning provision, but perhaps that's something Ms. White could comment for us. And that is the extent of my questions. Thank you.
Thank you. Thank you.
Good afternoon. My question was more of an understanding of practically what happens in this particular scenario. So in your evidence, you talk about a situation where there is a tree that's been identified as causing a risk, and then the bat specialist and council staff will go out and assess the risk. And in your statement, you talk about, well, in this particular scenario, that tree remains today. And what I want to understand is, well, who makes a decision about whether or not the tree stays, and how do they make that decision, and what factors go into making that decision?
Sure. So ultimately the decision for that tree's to remain, is it sits with DOC as protectors of that endangered species. The maintenance of that tree going forward as an increased risk to the scheme, the asset in particular being a stop bank, is upheld by Environment Canterbury and the river engineering team, so we'll monitor that tree a bit more closely.
And what type of mitigation do you do if the tree can't be removed and it's still a risk? What happens from a practical perspective?
Practically, there is no mitigation other than monitoring. The tree is to be maintained for the sake of the endangered species. Should it tip or should it fall, will be wind felled, we would then enact emergency repairs to the stop bank. Mm-hmm.
Does ECAN use specific types of trees for stop banks?
Tricky question. We don't technically use trees for stop banks whatsoever. However, historically, berm vegetation, which is vegetation intentionally planted between the fairway and the stop bank, which is intended to reduce flood velocities and in a way, subsequently protect the stop bank, historically have been planted closer to the stop banks than current design specs would allow for. And it's those legacy trees that we are looking at with a bit of a closer lens because their risk to the integrity of that stop bank is at question. So in answer to your question, trees are not used for stop banks.
Right.
They are very separately.
Are they used for flood protection?
They are indeed.
Okay, so what types of trees are used for flood protection?
Currently under review by MPI, but existing vegetation is a large range of different willow species and poplar as well.
And they're existing, you don't plant new willows?
We do still, but again, that's under review by MPI as to what species will be allowed going forward.
Well, because that's still under review and it's not, no decisions have been made, if exotic tree varieties used are limited to one or two types, i.e. monoculture, how does that meet Indigenous biodiversity objectives?
I'm sorry, but I'm not capable of answering that question. It's not my area of expertise.
Have native trees been considered for flood protection?
Absolutely. Native trees are in fact used on occasion by a separate team. We have a separate team within ECAN that implements or plants them, and they have planted them in conjunction with the varying species of willows and poplar that we've used over the years. They're not a preferred vegetation type for flood protection simply due to the length of time they take to establish. The nature of trees as a flood protection vegetation is largely for their root structure that prevents erosion. And natives take, 5, 10-fold times for the type of growth that we expect.
So would the idea of planting exotics and natives together to meet two objectives be preferred?
I would like to think so. Whether that's the view of the entirety of ECAN, I can't say, but I can tell you that I have seen them planted in conjunction, and it pleases me to see that.
Okay, that's good.
I can probably add a little bit to that if you would like.
Thank you.
Just wanted to draw your attention to the recent government funding over the last 3 to 4 years through Shovel Ready, or whatever the correct term is for it, and part of that funding, Environment Canterbury had a berm transition project which included extensive underplanting of native vegetation amongst our berm vegetation, the concept being to either re-establish native seed bank, but also to try and maintain some weed growth, so go in and deal with things like old man's bed, which is of a significant threat to our flood protection vegetation, and then establish undergrowth of native vegetation to prevent the weed from coming back. So I think in my substantive evidence, I referred to an example as well where that project and that funding supported a native planting project to increase bat habitat from a planting point of view in conjunction with DOC, who worked to put in some bat roost poles. So they are examples where the council are trying to, get funding to include these multi-benefit or integrated programs, flood protection and biodiversity enhancement.
So the berm review that Mr Boshin was talking about, are they considering using both?
Sorry, repeat the question.
The berm review, is the review considering different types of Indigenous plants?
I think it's ongoing and iterative, and at the moment there is a place for the use of willows within flood protection, and I'll probably come back and talk some more about that in the natural hazards chapter. The concept of including natives is not so much about enhancing flood protection, it's about trying to get diversity into the berms. So the review of a planting, it's not so much that we have a project where we're creating a document that assesses and commits to certain things. It's just a part of our new culture of looking for opportunities for multiple benefits.
Yeah. I know that's good. Thank you.
Thank you.
Department of Conservation want to come forward and occupy the tables, and we'll just make sure that we've got the technology in place. We'll get underway. Welcome, everyone. Just before we start with the Director General submission, Commissioner Mackay just made a disclosure of a previous involvement in an issue just for our conflicts register, and she'll just repeat that now for your benefit. Thank you.
Kia ora. So this morning I disclosed that in the evidence that's been shared by Mr Clayton, he refers to a particular case, Kaitariti in the Bailey paddocks, and I disclosed that at the time of that survey I was the General Manager for Taumutu Runanga that joined the Forest and Bird Action, and that survey, or that case, what you're referring to, directly related to that particular case. I was the General Manager instructing the lawyer, but I was not the lawyer acting for Taumutu.
Just to give you an opportunity, if you had any concerns, Ms Newell, you could raise them, but it seemed to me to be sufficiently remote and historical in relation to the issues in front of us.
Yes,
Thanks. I'm Susan Newell. I'm with the Department of Conservation as an in-house lawyer, and with me I have Ms Williams, who's prepared planning evidence, Mr Clayton, who's an ecologist, and Mr Waugh, who's here to talk about peka peka. I heard the panel say earlier that you have pre-read submissions and evidence.
Yes, we've had the material that was pre-circulated and had an opportunity to read it, but just given the number of appearances, would be helpful for you to set the scene and highlight anything of a particular importance, and the same in terms of the summary statements for your witnesses as well. Would be
Thank you.
Grateful if you could take us through those too.
So I'll just quickly take you through the legal submissions and then probably hand over to Mr Clayton next. So the Director General's submission is quite focused on the plan's provisions regarding the protection of Indigenous vegetation, really, and the rules for clearance of Indigenous vegetation and the protection of the habitat for peka peka. In the submissions, I start with just setting out the legal framework, which I'm sure you're all very familiar with, Section 6C of the Act and Section 31(1)(b) being the Council's function to maintain Indigenous biodiversity. The National Policy Statement for Indigenous Biodiversity is also a relevant instrument, which very recently was changed a little bit. We have looked at whether that changes material for the current purposes, and the reasoning is set out in the legal submissions, but effectively the conclusion that we have reached is that any areas that were identified as SNAs in the proposed plan as notified are now NPSIB SNAs as defined in the Amendment Act. So they have legal effect, and the amendments to the legislation really had quite a confined effect of just removing the obligation that was there to identify and map further SNAs and then for them to have legal effect under the MPSIB. So I think we've walked through the reasoning for that in quite a lot of detail, but hopefully if there's any further questions or disagreement, we could maybe discuss it.
You were here obviously just before the break, and just the exchange that we had with Environment Canterbury, just in terms of the role of the MPSIB.
Yes.
And what might happen to the future processes that...
Yes, and I wrote down what you said, Madam Chair. You said something like the regulatory framework needs to be sufficiently robust to pick up SNAs that are not yet identified. I would agree with that position. I don't think that there's that the Amendment Act imposes an obligation now on the council to immediately go forth and identify and map SNAs. The effect of the amendment regulation was to defer that obligation to do so as soon as reasonably practicable. That being said, though, I'm sorry I interrupted you, but was that the essence of your question? The department's submission really is to highlight that we think there's still a bit of a gap in the way the plan is structured, in that the framework doesn't adequately identify Indigenous vegetation outside of SNAs or have methods that enable any as yet unidentified vegetation that might qualify as significant to be picked up. So Ms Williams has suggested some alternative wording that might better ensure that that happens as people undertake their activities. If there's triggers for applying for resource consents that would ensure that any as yet unidentified Indigenous vegetation can be identified before it's cleared as a permitted activity, then that would go a long way to addressing the gaps that we think are in the current drafting.
Sorry to interrupt you, but just trying to sort of understand whether or not the department or the Director General is suggesting that there should be an equivalent regulatory framework as if it were an SNA, or whether or not there is an acknowledgement that even through a resource consent it may not be a complete assessment or evaluation that would necessarily meet the same threshold of getting it into the district plan as an SNA. Won't have gone through a Section 32 analysis at a resource consent level. It will just be an evidential matter about the qualities.
Yes.
Or the integrity of the Indigenous.
So it's not so much getting something in the plan. I think we all agree that a plan change would be required to do that. It's more to ensure that as a matter of fact and evidence, an area is assessed and it turns out that there are values there that meet the criteria, at least in the Canterbury Regional Policy Statement for significance, then there's an appropriate response to that having been identified. And I note that in Mr Harding's evidence, he's acknowledged that he was unable to do a complete survey in the Rangitata, for instance, to check on the ground whether there are as yet unidentified SNAs, and he also acknowledged that there were probably some types of Indigenous vegetation which could qualify as significant but which are difficult to pick up at a high level survey that could nonetheless be significant. And I'm thinking particularly in Mr Clayton can obviously talk about this more, but the not big woody vegetation, trees and what have you, but the smaller, more cryptic species that they may be quite unique to the limestone outcrops or similar areas but not have been identified yet. The lower areas that could exist within farmed areas on private land. And that brings me to another point that's been raised in the Director General's submissions, which is the Indigenous vegetation activity and clearance activity within areas of improved pasture. And this is where the example from Kaitariti was relevant, because experience has shown that the definition of improved pasture as it appears in the MPSIB still leaves quite a lot of uncertainty for people trying to read the plan and understand whether what the boundaries of the area of improved pasture are, what the boundaries of the area of Indigenous vegetation is, whether it is within an area of improved pasture. So applying that definition really depends a lot on the perspective from which you're trying to apply it. And I mean in the physical sense, at what level of focus from what difference. So when you're taking a very broad perspective, probably vast areas would appear to be improved pasture, but there might be patches of Indigenous vegetation that is significant that you can't see unless you zoom in a bit closer, for example. So it's those kind of practical application issues that remain of concern. And in relation to that question, Ms. Williams, has identified that there appears to be a bit of an anomaly with the cascade of provisions for Indigenous vegetation clearance within areas of improved pasture in different ecosystem types. So the standard for what we've been calling the sensitive areas seems to be at odds with the standard for some of the other areas, and Ms. Williams will talk about that in more detail. And I think from this morning's discussion, the issues around bats are largely resolved, so I won't go further with that. And I'm happy to take more questions, otherwise I'm happy to hand over to Mr. Clayton. Actually, sorry, there is one other thing I wanted to mention, if I can. There was some discussion earlier about incorporation by reference to the standards. We did think about that and concluded that as long as we refer to the specific date of the DOC protocols within the plan, even though that will fix that protocol from the current date in time for the plan's purposes, that seems to be acceptable for a standard to incorporate a document by reference, and we would be satisfied that it sets a minimum standard. So on that basis, we wouldn't have an issue with incorporation by reference to a specified date for the protocol. The other thing that came up this morning was Mr. Harding was referring to whether to substitute a reference to naturally uncommon ecosystems for the reference to depositional landforms. In theory, that sounds like a reasonable thing to do. I had one concern that depositional landforms are defined. It's a defined term in the MPSIB, whereas I'm not aware that naturally uncommon ecosystems is a defined term anywhere. So I just wanted to flag that. And I'm sorry, I don't have a solution for that at present, but I think that might be something that we could take away and work on if the panel was minded to hear from us again on it. Sorry. Mr Clayton is first.
Kia ora. I'm a terrestrial ecologist. I've spent about 25 years studying and practicing conservation management in New Zealand. So my comments into the Timaru District Plan are based on relevant ecological literature and also through experience working in uncommon and threatened ecosystems, such as the braided rivers, limestone ecosystems, and the numerous features associated with the coastal and dryland parts of the district. The evidence, which I think you've seen, provides information about the rare and uncommon ecosystems in the Timaru District, discusses some of the most threatened species associated with these areas. Some examples being the rare plant and fauna in the South Canterbury limestone bluffs, some of the braided rivers and wetland birds, and the skinks in the inland foothills. There's also some evidence about the examples of threatened species on private land outside the protected lands network, being the reserves and covenants, and also outside of the mapped SNAs. I've talked about the remnant biodiversity that's possibly less threatened, but is frequently present in the mosaic of farmland and provides often remnants of habitat for indigenous fauna that was once widespread. I'd like to acknowledge the benefits of the work undertaken by the Timaru District to complete so many SNA surveys in the district, and generally endorse the rules that apply to managing them, giving a degree of certainty to all parties. I also wanted to note that there are many areas of indigenous biodiversity that remain scattered throughout private land that have not been identified and or mapped in the district plan. Despite our knowledge about the importance of protecting and maintaining indigenous biodiversity, the compounding pressures of more intensive land use, environmental changes and invasive species continues to occur and has caused attrition and ongoing biodiversity loss. Many of the areas of remaining biodiversity in all parts of the district occur within a mosaic of improved pasture. And while those areas may not qualify as SNAs, they do need to be managed appropriately if the district is to retain its indigenous biodiversity. So thank you for your time, and I'm happy to answer any questions.
So I just have quite a broad question, and that question is, when we've talked about the difficulty of having landowner access and ground truthing, and so what is missed?
So I think Mr. Harding talked about the limitations, and you talked this morning about how high that adherence to having access to sites was, and I just wanted to point out, so Mr. Harding acknowledged an inability to get to sites where it was less woody. So the easily identifiable starting point for getting to sites to assess them and properly was probably from aerial photography or local knowledge, as he said, and just a general strong appreciation of the district's ecology. But a lot of the biodiversity I'm talking about is cryptic, so it's embedded within a mosaic of grasslands, of lower stature vegetation, or it's smaller in scale. So it wouldn't have triggered an interest for an ecologist doing a district-wide survey. He also acknowledged that the access to the upper rangitata was not given. So those are two good examples he's mentioned. The third point I'd make is that over time, the application of criteria which were used 20 years ago would have a different result. So if we've lost certain amounts of biodiversity in some of the districts, let's say in the lowlands, over that time, it gives greater significance to what remains. So I think if Mr. Harding was given an opportunity to start again, we would probably find a lot more would trigger significance criteria. Does that answer? Yeah. Cool.
Thank you, Mr. Clayton. You've referenced a couple of times in your speaking notes today, but also in your submission, you talk about many of the areas that qualify as SNAs have been but the exercise is unfinished, meaning there are still large areas that are likely to meet the criteria for SNAs but are unmapped. And then you talk about it again today. But my question to you is, what is the solution to this engagement? Like, it's all good and well saying we've done a great job, but it's unfinished. But what in your experience, what does that engagement look like?
This is a great question. I guess I can't speak for the council's responsibilities to undertake it and or how they would go about it. In my experience, willing engagement is the key. I guess because of that, what I said before, the need to reinterpret, the rules of what is significant. There's been a change in, I guess, the application of the ecological criteria. So we would need to start with a new lens on that. As far as getting the data, I know what from ECAN this morning. I agree. There is a certain amount of effort that could be put into desktop survey as a cut to make a subset where we could possibly engage more. It's a very difficult question to answer, though. Could you give me more?
You've repeated it a few times,
yeah.
but I don't see, where it fits and how you achieve it.
Yeah, well, I guess I'm passing the responsibility to the council.
Yes.
Yeah.
I know you are.
I don't know how to achieve it. Yeah, it's tricky. Yeah.
I've just got one question, Mr. Clayton. Your paragraph 47 and 48, Indigenous vegetation clearance, and you talk about the forms of Indigenous vegetation clearance that would have a destructive impact. Can you just tell me what forms of vegetation clearance are destructive?
So I think they are defined in the plan under one of the definitions, and I think Ms. Williams is going to talk about what Ms. Neal talked about with the instruments not lining up properly. So it's to do with the sensitive areas. So it looks like there is an anomaly in the cascading of the rules. So the destruction is simply it's a paraphrase for that being allowed within those areas. So any of the vegetation clearance.
So you're talking about crushing and things like that?
Yeah. So we've got, I think there's 7 or 8 different in the actual definition of what vegetation clearance involves. It includes cultivation, crushing, trampling, mob stocking. I think all of the possible.
Are they all destructive?
I think in the sense of the effect on indigenous vegetation, they are. It is, it's an encompassing term, I'm guessing. So yes, they could be. Yeah.
Okay. Thank you.
Mr. Waugh.
My turn.
Yeah.
Hi, my name is Simon Waugh, and I have been a biodiversity ranger for the Department of Conservation for 3 years now. Part of my role involves the monitoring of long-tailed bats in the Timaru district. Under the Department of Conservation's threat classification system, long-tailed bats are ranked as threatened nationally critical. This is the most severe threat ranking before extinction. So my evidence addresses the distribution of long-tailed bats in the Timaru district, the impacts on long-tailed bats from tree clearance, impacts on long-tailed bats from artificial lighting, DOC's management of long-tailed bats in the Timaru district, best practice for mitigating impacts on bats when felling trees in long-tailed bat habitat areas, and some specific comments on the S42A report. So in terms of my comments on that report, I support the proposal in the S42A report to extend the bat habitat protection area to align with the long-tailed bat overlay as defined by ECAN's Canterbury maps. So this extension would match known bat habitat in the district much better. In regards to the proposal in the S42A report to include the use of an automatic bat monitor in the matters of discretion in Eco R4, I think it would be better not to include this. So an automatic bat monitor is a very useful tool for detecting the presence of bats. However, it can only be used by a suitably qualified or experienced expert, and it can't be used to rule out necessarily a tree being a bat roosting tree. Thank you. Happy to take any questions.
Works well with bat habitat protection area with landowners, as I understand. Explain a little bit about that process, like, you know, a tree's identified or a tree's not identified, it's monitored and surveyed, and then it's identified as a bat roost habitat or bat roost tree. Explain what comes first. Do landowners approach you, or explain a bit about that process?
Sure, yeah. Typically, I guess our interaction with landowners in regards to bats is that we do annual catch and release surveys where we catch bats and we tag them with a radio tracker, and we use that to follow them back to roost trees, and that's how we find roost trees. So a lot of our engagement with landowners is when we believe a bat is roosting in a tree on private property, we'd approach them and ask for their permission to come onto the property and sort of complete our survey and pinpoint it down to a specific tree. We do occasionally get approached by landowners when they wish to fell a tree and they want advice from us on how best to go about that, particularly if it's a known roosting tree. Known roosting trees in the district have not all of the time, but the vast majority of the time, they have a sign attached to them by us to identify them as such.
Okay.
That answer your question?
When does the ABM come into play?
So the ABM, the automatic bat monitor, it's an audio listening device. It detects the sounds of bat echolocations and records them as a pictogram and image of sound wavelengths. So we conduct ABM surveys on 5 of the colonies in South Canterbury annually as a way to try and measure population increase, decrease, or stability, I guess. But they can be used also to search for the presence of bats. So if you identified an area that, I guess, looked batty, for lack of a better word, you could put out ABMs and try and find bats in areas that we didn't know they existed before. And certainly in the case of a suitably qualified expert supervising tree felling, it is a tool that they'd use to, one of many, to try and establish what's going on around a tree with bats. Yep.
What level of skill is needed to recognise attributes of trees suitable for bat roosts?
Yeah, good question. Some things are very obvious, like knot holes and cracks. So bats are a tree roosting species. They live inside cavities in trees. Some attributes not so easily recognised. I have seen trees that are bat roosting trees that you can't tell from the ground that there are cavities. They do sometimes enter through, I guess, sort of chimney formations that are broken branches that lead down into a cavity.
Right.
And so a visual survey from the ground is just sort of just a starting point, really. Yeah.
Okay, thank you. And has DOC committed to the same help that they give to current landowners for new bat areas on private property. Would that commitment still be there to help landowners?
We have limited capacity in the district, I guess. Certainly whenever like a private landowner, like a farmer, reaches out to us and asks for help, we really do attempt to honour that they've tried to do the right thing, and we make an effort to help out in that case. A lot of the BAT surveying in regards to tree felling that we're asked to do, probably 90% of it is by ECAN felling trees in the river berms. Certainly they fell thousands of trees every year, and we don't have capacity to help at that scale, I guess, yeah.
Okay. What would you advise the council to be aware of? Oh, now my computer's gone down. What would you advise the council be aware of if one day they decide not to seek DOC's technical assistance in the habitat protection area, that habitat protection area?
They being ECAN?
No, this council, the Timaru District Council.
So, I'm so sorry, could you please repeat that?
So what would you advise the council to be aware of if one day they decide not to seek DOC's help or technical assistance to identify bat habitat protection areas?
Okay. I guess there are a number of bat experts and bat ecologists around the country that you could seek help from. It doesn't have to be the department. There's any number of independent ecologists and contractors that can help you make decisions about bat habitat identification or management.
So I presume protecting bats would be a nationwide thing? So there'd be a holistic approach, like so I've lost my train of thought. I'll come back to that question.
Okay.
Bats are averse to light, but they're averse to blue light, aren't they? Blue wavelength light.
Yes, so it appears that there's evidence that it's the UV light and the blue wavelength light in artificial light that they are particularly averse to. So if an area has to be lit and it overlaps with bat habitat, it would appear that using warm lighting has less effect on their behaviour. Yep.
Interesting. My last question, is it? Oh yes, my last question. How long would an ABM survey take, and what seasons are best for surveying?
I guess it depends on the purpose of the survey. So the minimum required by DOC's protocols for minimising, sorry, it's a real mouthful, protocols for minimising the risk of felling occupied bat roosts, which is the sort of standard, gold standard protocol that DOC has produced about tree felling in bat areas. It specifies that you need at least 2 consecutive nights at greater than 7 degrees temperature and without rainfall. So bats enter a torpor, a kind of hibernation over winter. So yeah, certainly when it's colder than 7 degrees at night, and in this district, that's the entirety of winter, they're inactive. And in terms of detecting them with an audio monitoring device, that can only pick up their echolocations when they are active and are flying around.
And with regard to Port Blakely, who's got 2 forests, as I understand it, that contain bat roost trees, when did their felling take place?
When does their felling take place? Yeah. I guess in the case of Port Blakely specifically, they have a colony present in the Raincliff forest.
Yes.
And in the Māori Gully, up Pleasant Valley Way near Te Moana. The Māori Gully colony is it's present in an SNA, so they don't do any felling
Yeah,
there. It's
yeah.
it's not production forestry, it's a bush block. And then in the Raincliffe Forest, that's an old arboretum that was planted in the 1800s with western red cedars and oaks. And they own the land, but I believe they don't fell any of those trees for production forestry
Okay.
purposes. They just maintain it. Yeah.
Okay. Thank you very much. Been
You're
really
welcome.
helpful.
I don't have any specific questions, but I can tell you I did not know very much about long-tailed bats until 2 weeks ago. So thank you very much for your submission and the detail that went into it as well. So thank you for that.
Thank you.
My question is just around the bat overlay and the extension to it. And there were some submitters who obviously thought that that shouldn't happen. But I can see through your submission and all your different dots that it does make sense to extend that. But what is your view on labelling it as an SNA rather than that extension to the overlay map? Do you have a view on that at all, or do you think the extension to the map is the best way to achieve your recordings or monitoring?
I think that extension to the map is the best way to protect bats in this district. So that map was produced by someone at ECAN. I'm actually not sure who, but it was drawn based on DOCS monitoring and roostery data. And it's very, very similar to how I would have drawn it if I'd been asked to draw it. As to whether it's an SNA or something else, I kind of think that's outside of my area of expertise, yeah.
I only have one really quick question, but before I say that, I just wanted to say you have a really cool job.
Thank you, yeah.
Yeah, what a great job you have. My question is just about the photograph on page 8, because I also didn't know a lot about bats, and in that particular photograph, it shows the size of a bat just over a thumbnail, and I just wanted to know, is that the normal size of the bats that we're talking about that currently are roosting here? They're quite tiny.
Yes, they're tiny, yep. They typically weigh about 10 to 12 grams. That's about the weight of a $2 coin. It's like a mouse with wings, basically. Yeah,
Right.
they're minuscule. Yeah.
Thank you, interesting.
You triggered another question.
Sorry.
Thank you. A lot of my questions have been covered, but I just wanted to check my understanding of your recommendation to exclude specifically writing in the bat monitor within the rule.
Sure.
So I understand that they're a useful tool, but am I correct in thinking that what you're saying is that the utility may not extend to what the rule's trying to achieve, but regardless of whether it's written and prescribed in a plan provision, it's still a tool that may or may not be used by the appropriate person?
That's correct, yes, absolutely. Yes, so it's one tool of many, and whoever the suitably qualified expert is that's assessing a tree may well choose to use an ABM depending on the circumstance, yeah.
And more a comment really, your evidence addressed the impacts on long-tailed bats from artificial light, and I understand from Ms Williams' evidence that you're anticipating talking to us about that in hearing F on general district-wide matters. We will be dealing with light, so I think you can tell that we'll all be interested in hearing from you again about the bat.
Okay.
Thank you.
Cool. Thank you very much.
Bats extend north, and do they extend to the Waihora area, for instance?
I guess in this district, the furthest north we have a record of is Peel Forest. And
That's special.
yeah, yeah, but there's still more searching that could be done by us. Yeah.
Thank you.
Thanks. Okay. Cheers.
Kia ora, thank you. My name is Liz Williams. I'm an RMA planner at Te Papa Atawhai, Department of Conservation. Thank you for hearing me today. So I have done some summary speaking notes, but perhaps it's better just to pick up on some of the points that were discussed at the hearing today. So from my understanding, the Council's Section 42A report officer, Liz White's done a summary statement from the 7th of November. So it looks like a lot of the amendments we've recommended have been adopted. The only thing I picked up on was that in relation to the improved pasture amendment to Eco R1 rules, she suggested that my proposed drafting creates some uncertainties and requires a council to make a subjective assessment on that. I agree with those comments, and I think it can be worked out with further drafting. So I'm happy to input on that if that's required. Secondly, so we talked about removing the reference to automatic bat monitors. I think that's been agreed to in the summary statement. And also the inconsistencies for the improved pasture in the rules. So I think that, I haven't seen the drafting, but I think that's going to be looked at as well. So the only other outstanding thing is the aligning the plan objectives and policies with the MPSIB. And there's been some discussion about that today, particularly about the non-complying assessment and having regard to national policy statements through the resource consent assessment. The only point I'd make in regards to that is I think there are examples of other proposed plans that are starting to incorporate the wording from the MPSIB into their district plans, and they're at similar stages to the Timaru District Councils. And I fully appreciate that it's difficult to include those exceptions that are specified in the MPSIB. The Waimakariri proposed district plan talks about the avoidance of adverse effects on SNAs, and they specify dealing with effects outside of SNAs through the effects management hierarchy. So they made that change as part of the Section 42A report reply at the hearing stage. So I fully acknowledge it's not yet gone through the final decisions. And they've sort of dealt with the exceptions the same way that I've talked about in my evidence through the infrastructure exceptions. So they haven't specifically dealt with the other activities. But again, I guess you can refer back to the MPSIB to look at those exceptions in more detail. The other plan that I'm aware of, the other proposed plan that I'm aware of, is the Te Tai Opatuni plan in the West Coast. They've basically put in the MPSIB wording right into the district plan, so it includes everything, word for word, pretty much copying the MPSIB. So that's quite an extensive change. So I think my amendments proposed are really just looking at the objectives and policies and adding some assessment matters for the restricted discretionary considerations for clearance outside of SNAs. I think I've set that out in Appendix 1 of my evidence. I think, yeah, that's all I have to say. If you've got any questions.
Thank you, Ms. Williams. Can I just get a clarification from you just in terms of your primary brief of evidence at paragraph 44, when you're discussing perhaps improvements to the rules to better align with the MPSIB for areas outside of the mapped SNAs, and you are dealing with a matter of discretion. When it refers to when assessed against the Appendix 5 criteria, can I just clarify, is that Appendix 5 of what?
That's proposed Timaru District Plan. I think they've got the significance criteria in their Appendix 5.
Right, and that aligns, your
That's-
understanding that aligns with the NPSIB Appendix 1 criteria? Or is it a different criteria?
It's the Canterbury Regional Policy Statement criteria, but it's very closely aligns with the NPSIB.
Thank you. Commissioner Day Cleveland.
Thank you, Ms Williams. I'd like to run a couple of questions past you so that I understand exactly what you're looking to achieve. So if I can take you to paragraph 33 of your evidence in chief. So here you're concerned that there is no policy to direct the avoidance of adverse effects, yet you do acknowledge that Policy 5, Eco Policy 5, directs avoidance of clearance in NCAs.
Yeah.
In my mind, I'm seeing that achieving the pretty similar thing in terms of having an avoid policy. So, and you're suggesting that you needed an additional policy to specifically say avoid adverse effects. Have I understood that correctly, or is there some more nuance you could talk me through there?
Yes, really looking to align it better with the NPSIB, which talks about avoiding certain adverse effects on SNAs, so it lists it out in that criteria. So it's kind of putting a trigger or a hook in the proposed district plan to look at the NPSIB and understand what those adverse effects, what needs to be avoided, what those effects are that need to be avoided.
And so those adverse effects that you're suggesting could be in a specific policy, is that broader than the what policy P5 is trying to achieve when it directs the avoidance of clearance?
Could you repeat the question, sorry?
So you've explained why you want to have an explicit policy,
Yeah.
which expressly states avoid the adverse effects, so that the criteria can be fully recognised in terms of what constitutes an adverse effect.
Yes.
And in your evidence, you've also acknowledged that Eco Policy 5 already directs the avoidance of clearance in SNAs. So I'm wanting to understand how the two policies might work together, or what one does that the other doesn't.
Yes, so my recommended amendments is to Eco P5. To Eco P. Eco P5. So it just includes in clause 1 by avoiding adverse effects. So it's, I read the proposed policy as meaning that you're just avoiding the activities, but it's specifically in the NPSIB avoiding adverse effects. So whatever's happening within that SNA, you need to avoid those effects of those activities within that.
So does that then suggest that the effects of those activities are so uncertain that it requires a specific policy? Is that what you're saying?
That's right, yeah.
Right, okay, I see. Thank you. And in relation to clearance outside of NSAs, you would have heard us talking this morning with Council's legal counsel, Ms Valla, and also Ms White. Were you able to tune into that conversation?
Yes, yeah.
Could you just talk me through, looking at the rules in front of us, what your concern is in relation to clearance in areas outside of an SNA?
Yeah, sure. So one of the things is that well, we've talked a bit about this today, but the unmapped SNAs, so ones that may have significance that haven't been incorporated into the plan as a mapped SNA. So by adding this additional wording, it provides, my effects management hierarchy first talks about avoidance of effect, practical. And then secondly, this policy is used through the restricted discretionary activities and the assessment matters, so the decision would be restricted to those assessment matters. So I think it's important to refer to the effects management hierarchy there, because that's the way that this sort of, you work through how the effects will be managed of those activities.
And so I think the example that we were advised about this morning was an activity that was then went into non-complying and say didn't pass through the gateway test, or if it did pass through the gateway test, then section 104(1)(b)
Yes.
would then require through that consenting process,
Yes.
consideration of those very issues, those matters under the NPSIB. What precisely is your concern? What is the precise gap, if there is that pathway?
Yes, so I think it's really just specifying the avoidance of adverse effects within the district plan policies. I fully recognise that the RMA is set up so that you would still revert back to referring to the national policy statement, but I think by including it in the district plan, it gives it possibly more weight, but it sort of provides that trigger or the hook for when you're assessing a resource consent application, what you need to be considering.
Thank you. I'm pretty sure I've understood that, so thank you for helping me through that. You've already answered a question I had at the start, that you now accept the Section 42A recommendation on, so I think that brings me to the end of my questions. Thank you.
I should just point out too, I forgot to say, so in my speaking notes, I've just talked about the Federated Farmers' proposal to remove the term grazing in the definition of Indigenous vegetation clearance. I think there was a discussion with Liz White about that earlier today, and I support Liz's position that that term shouldn't be removed from the definition.
I didn't quite catch that, sorry. Could you speak?
Sorry.
Maybe you might want to move your microphone just a bit closer. Thank you.
So I was just saying, in my speaking notes, I've just referred to that Federated Farmers evidence proposing an amendment to the definition of clearance of Indigenous vegetation to remove the term grazing. I think it was discussed earlier today with Liz White, and so I support Liz's position on that it shouldn't be removed, and it's dealt with through those permitted activity provisions in the eco chapter.
Thank you, that's helpful to confirm that.
Oh, and I should say too that so ECAN's evidence has talked about the new provisions in the plan for permitted activity, so we agree with that permitted activity standard.
Thank you.
I just have one question. It's this language between dispositional landform and naturally uncommon ecosystem. What I had understood from evidence this morning was that the naturally uncommon ecosystems was preferred because it is referred to in higher order planning instruments, but it may not be. Do you know what is referred to, where, and what would therefore be better?
So I know depositional landforms is defined in the NPSIB. I'm not sure that threatened and uncommon ecosystems are defined in higher order documents, but I'd have to check.
Ms Williams. If we were to accept the Director General's submission to include NPSIB requirements to the ECO chapter for the effects management hierarchy, would the amendments to policies and matters of discretion likely to generate submissions in opposition that are substantial?
In terms, generate submissions through?
By including that clause. The effects-based.
The effects management hierarchy
Yes.
wording. So that's copied out from the NPSIB. So that's the national direction to how those effects are dealt with for areas outside of SNAs.
But if we were to accept that, if we were to accept it, if we were to, do you agree that including that clause into policies and matters of discretion would generate substantial opposition?
So our original submission raised this, so there's scope to make those changes.
Okay, all good. I have another question, my last question. Is DOG concerned about the opportunity to extend bat habitat protection areas when at Port Bakeley's Mr Robinson's paragraph 56 states the cost to include an ecologist prematurely to undertake assessments of potential roost trees will, in his opinion, deter the public from notifying their intentions to remove trees and result in unintended consequences?
So there's a permitted standard, and so for anything that's not complied with, they need to apply for a resource consent and it would get assessed that way. It's not my place to comment on the economics of all the costs involved in doing that, but it's standard for other things where you would get an ecological assessment to support your resource consent application.
Can I just jump in on that, sorry?
Yes,
Right?
maybe you could answer that, please.
I believe, and I could be wrong, that his comments in that submission were around the wording of having a suitably qualified ecologist.
Yes.
And then in the section 42A report, it was proposed that that's changed to a suitably qualified expert. And so I think the point he was making is that you don't necessarily want to hire a private sector bat ecologist to do this work when it could be anyone who's qualified enough to assess for tree felling, but not necessarily an ecologist.
So I'm really asking, is DOC concerned about the fallout from that, with regard to extending the bat habitat protection areas or bat roosting trees, or extending it beyond what you already know?
I'm not sure what you mean by that, sorry.
So,
because I think the extended layer is based on known areas of bat roost areas.
Yes, sorry, I shouldn't have used bat protection area. I should have just used looking for more bat roost trees.
Outside of
what you already know. Future bat roost trees I'm talking about, given Mr Robinson's comment about if basically what it's saying, if the landowners have to pay for expertise, it might deter them. Have you got concerned about that with regard to extending the areas of bat protection trees?
Yeah, that's a good question. I don't know that it's necessarily that expensive or prohibitively expensive, but I can't comment on that.
Okay.
For a landowner to engage someone to assess a tree for them, yeah.
Okay. All right, thank you.
Williams, I'm just am having a little bit of trouble just understanding what the Director General is suggesting should occur for the appropriate regulation of effects on Indigenous biodiversity outside of SNAs. And just wanted to sort of test with you my thinking, and if I've gone off track, then please correct me. But the reason we're looking at the issue of Indigenous biodiversity outside of SNAs is specifically comes out of provision in the MPS 3.16, I think. But that provision talks about if a new subdivision use or development is outside an SNA and not on a specified Māori land, and it goes on to address those, but any significant adverse effects on of the new subdivision use and development on Indigenous biodiversity outside the SNA must be managed by applying the effects management hierarchy. So it automatically just narrows it down to talking about significant adverse effects. And I'm having trouble with the rules that you're proposing and the matters of your discretion and how it's speaking to that requirement. It seemed to be almost muddling the requirement to maintain Indigenous biodiversity, all Indigenous biodiversity, and not separating out the pathway for the response for SNAs, which is different to the response for Indigenous biodiversity. Are you able to comment on that? Where in the rule framework of the proposed plan or your recommendations to us addressing significant adverse effects in accordance with the effects hierarchy?
So for SNAs, it would be wherever it became a non-complying activity for Indigenous vegetation.
Yep.
And then for the other rule set, it's to do with the Indigenous vegetation clearance for insensitive areas and all other areas, so that new rule, clause 4. And it's where the activity status is restricted discretionary.
But the matter of discretion doesn't appear to be directed at significant adverse effects. So how do we leap? Is there?
Yeah, so
what's the process for identifying the significant adverse effects? Should we only be focused on significant adverse effects on Indigenous biodiversity?
So for unmapped SNAs, so the NPSIB directs that we apply the effects management hierarchy.
Only to significant adverse effects?
Yeah, so possibly you could add and managing the significant adverse effects of activities by applying the effects management hierarchy in that new EcoPX, maintaining Indigenous biodiversity policy.
Because it is important, and it is an important distinction, isn't it?
Yeah.
Because
yes.
I think that was sort of the origin of my earlier comment. Otherwise, we're simply trying to adapt the SNA regime to something that hasn't yet gone through a Section 32 process, and I'm not sure that that's what's intended by, it's qualified the response for areas outside SNAs, hasn't it? The MPS.
Yeah, I mean, I've copied the wording from the MPSIB, so, and that's to apply to areas outside of SNAs and managing the significant adverse effects by applying the effects management hierarchy.
Yeah.
Yes, there's also a clause in the MPSIB, clause 316, which talks about all other adverse effects must be managed to give effect to the objective and policies of this national policy statement. So that might be around things like restoration and that sort of thing.
Right. So is there a conflict then in the provisions within the MPSIB, or do you think the two work? You can do both. You can limit your response to managing significant adverse effects, but then you have to still make them consistent with to give effect to the objective and policies, all other adverse effects. Okay. So the difference is we're looking to avoid significant adverse effects, but we can manage all other adverse effects with a view to maintaining Indigenous biodiversity.
That's right.
That's how they work together. Okay. No, I think I understand that now. Thank you for that. And just picking up again on that reference to Appendix 5, which is derived from the RPS, you say. I'm just wondering at what point that appendix should be updated to reflect the wording in the MPSIB, and is there a need to kind of split the appendices so that we have the older criteria or the wording from the RPS applying to the already identified SNAs, but there should be a different approach looking forward, and that it should better align with the MPSI, or should adopt the MPSIB
for future
criteria?
mapped SNAs. At the moment, I think the Canterbury Regional Policy Statement's criteria is fairly well aligns with the MPSIB criteria. And I'm aware that the future amendments are looking at some of the significance criteria within the MPSIB. So it's possibly better to wait until the full plan change is undertaken to give full effect to the MPSIB once possibly those changes have happened.
So in your opinion, there's no material difference that we should be considering between Appendix 5 and Appendix 1 of the MPSIB?
I'd have to have a bit more of a closer look at that before I can comment.
Okay. Could you do that and just set out what your view, just do a bit of an audit on the two and just identify whether there are any omissions, things we should think about? That would be helpful. Okay. I think that's all from panel, so thank you. Ms Newell, did you have anything else you wanted to add?
No, thank you. I think the points I might have added got covered in the end, so I have nothing further. Thank you for your time. Appreciate the panel taking the time to hear from us. Thank you.
Okay, thank you, Commissioner. My name is Justin O'Brien and I'm employed as a support analyst by Rangitata Dairies Limited Partnership, or just referred to as Rangitata Dairies. So Rangitata Dairies own and operate 7 dairy farms, 5 of which are located in the Timaru district. Additionally, there's 5 support properties, 1 of which is located in the Timaru district. And just on the bottom of the second page, I've just got a map outlining the property locations for your reference. So the submission primarily relates to the policies and rules within the proposed district plan relating to natural character, but more particularly the riparian margin provisions. Regarding the natural character riparian margin, Rangitata Dairies farming activities, at least in places, does include the riparian margin of the Rangitata River as defined in the plan. So Rangitata Dairies submission sought that the farming activities were recognised in the policies relating to the riparian margin, as the farming activities within the margin could be considered as being inconsistent with the Council's proposed objectives and policies. For example, Policy 1 of the proposed plan and the natural character values and farmland within the riparian margin may be considered to be incompatible with the natural character values set out in the policy. While the farming and related activities is in an existing use and as such can continue subject to provisions in the Act, Rangatato Dewey sought some certainty that activities associated with and enabling farming could continue to be undertaken. And as such, Rangatato Dewey supports the recommended changes to Policy Natural Character Policy 5 and Rule Natural Character Rule 3, as these changes will enable more certainty around the farming activities. Rangatato Dewey are aware that any work sought to be undertaken beyond those permitted by the existing use provisions or the plan will require resource consent, and the respective provisions of the plan will apply. And also note that Rangatato Dewey also accepts the Officer recommendations with regard to policies 4 and 6 of the proposed plan. And just a final comment there around hazardous substances. Really the key thing there is just clarification around the what is considered agri-chemicals. It's not a point we wish to pursue, but it was just more to be clear about whether dairy shed chemicals were considered as agri-chemicals in relation to the application of the provisions of the plan. That's really all I wanted to note. Thank you.
Your paragraph 6, why do existing use rights not provide enough certainty?
They do for the farming activities, but it may come down to where you're talking about scale and extent. The key thing that would be concerned us from an existing use, it's not so much the farming, but we are in a floodplain and earthwork provisions, for example, following a flood, fine as far as reinstating fences, tracks, pipelines, that sort of thing. But if you had to do remedial earthworks, that's the, I guess, is a grey area, and that's really the key part of our submission, Commissioner. Yeah.
I just had one question about your submission on hazardous substances and trying to understand better. You've said in your evidence there might be substances that are used for farming activity and stored on farms that aren't agri-chemicals, and I wanted to know what would they be?
What I'm specifically referring to, Commissioner, is dairy shed cleaning chemicals. That are chemicals that are used to clean dairy shed plant, which I would not have considered to be agri-chemicals, and hence the point that we've raised in our submission. Yep.
Thank you, Mr. O'Brien. Just to follow up to that question, are those cleaning chemicals, would they be typically associated with dairy activities?
They'd be specifically for cleaning dairy sheds.
Yes,
yeah.
And so they would be very common throughout the district and therefore could be considered. Yes, I think that we spoke to Mr. Willis this morning.
Okay, yep.
And he seemed quite confident that they would meet the definition of agrochemicals.
Fine, yeah.
However, I think he was interested in knowing what the chemicals were, so now we know. So we'll probably have Mr. Willis comment on that in due course. Thank you. Thanks for your submission.
Okay, thank you.
Go. You can hear me now, can't you, Stacey? Thanks for allowing us to speak to our submission today. My name's Greg Anderson and this is Rachel Thomas. I'm the President of South Canterbury Federated Farmers and Rachel's our Senior Policy Advisor. Maybe I'll just sort of give a couple of opening remarks and Rachel can talk to our submission, then I want to finish off with a couple of comments about the discussion I've heard this afternoon. I think it's important to remember that this is hard, don't take this the wrong way, but I'm the only person in this room not getting paid here today. Yet I represent the people who all these rules are going to affect probably the most. And it's frustrating from my point of view, representing farmers, coming to these things sometimes, and I sometimes wonder if we're listened to. I've taken a day off work today travelled 140 odd Ks, and we appreciate our chance to speak, but we hope you actually listen to the points we're trying to make. There's a real battle in the society now around private property rights, which has been eroded a lot in the farming community, and it's a worry to us. So I'll just leave it at that, and we'll hop into it.
Good afternoon, Commissioners. I understand that you've had a lot of reading, so I'll take you through some of our outstanding concerns within the submission. So many of our points have been resolved, so I thank Ms White for her recommendations within the 42A. Probably the main point of contention remaining for us is around the permitted activity status for Indigenous vegetation clearance. And perhaps I will firstly just provide a clarification to my paragraph 28, which I think has been raised this morning, and then also in the department's evidence that was just presented. So I apologise, but I was actually missing a little bit of narrative from that paragraph that explains that the amendment I had proposed for the definition of Indigenous vegetation clearance is as an alternative to the permitted activity status, noting that that recommendation from Ms White to include the Per 1 of Eco R14 is only a recommendation, and if that recommendation is not accepted, then our preference would be to amend the definition, both obviously ending with the same outcome. In terms of clarity for plan users and for our members, I think it's much more beneficial to go with the amendment through the plan with the permitted activity status. But we have significant concerns over the 2 metre width. We consider like a number of different methods that would be utilised for clearance, mechanical being one of them. A ute, for instance, is over 2 metres wide, so that would assume that only a small digger would be able to be used. Many digger buckets are 2 metres themselves, so diggers are often much wider than that. I think the only thing that would qualify under 2 metres would be a quad bike, which is around 1.9, I think. And I just struggle to understand the rationale from opting with that 2 metre width. And in my view, if it's permitted as an activity, then I don't understand why there should be restrictions around it. And Greg can talk more to this, but you know, clearing a larger amount is more onerous on the farmer. It will cost more, it will take longer. So the farmer is only going to clear the width absolutely needed in order to carry out that activity. And I'll make one further point as well. I note that the activity allows for maintenance, repair or replacement, but it doesn't actually state installation or upgrade. And there are 3 things in particular that we would see as beneficial for permitted activity status being allowed for, and that would be fences, farm tracks and fire breaks, which are all very important things that farmers carry out.
So I think just to add to that, as Rachel said, like the fire breaks is self-explanatory, the fencing, you know, we're talking about all these indigenous biodiversity areas, we've got to fence them, so, you know, you've got to have the ability to be able to do it. And like so she talked about the tracks, well, I mean, the 2 metre rule, it's a health and safety thing. If you only have a 2 metre track, how can anyone pass on it? Because quite often vehicles are going up and down farm tracks. You know, it's all just common sense stuff. I mean, and her comment about having the 2 metres, well, I mean, it's a very costly exercise to put a fence break in or a track in. You're not going to make it any bigger than you have to. It's going to be as small as you can get, as economically practical, because it costs a lot of money. So why would you make it any bigger than necessary? But when you've got a restrictive size, all of a sudden people have got to be out there measuring it, and it's just adding more bureaucracy, I'm afraid.
Thank you, and thank you for your submission. Can I just on that, clearly the issues that you raise are sort of practical matters that relate to farming activity. Do you have an understanding of how the council arrived at the 2 metres in the first place?
My understanding from listening to Ms White this morning was that it was based on other plans, and I apologise I didn't have much time to look at others, but I did look at the West Coast plan, and that I think is 3 or 4 metres. And there is also a provision within that for construction of new fences, and there's no width restriction on that.
And what involvement did Federated Farmers have in terms of the drafting of this plan? What engagement have you had with the council?
So Federated Farmers, not myself, but previous staff member, has been involved in a working group, which has been involved in the drafting.
And do you know whether the issues that you're raising with us today
were
addressed in that process?
The issue that I'm raising today is something which has come through from the 42A, so it wasn't something that was in the initial plan.
Thank you.
And just to Commissioner Solomon's comment earlier on when she was talking to the DOC submission, she asked about does vegetation clearance, is it completely destructive? Does the Indigenous biodiversity disappear forever? Well, in my experience, that's not always the case. I can show numerous examples of fence lines that have been cleared of Indigenous biodiversity and it's back growing there. And I can show you tracks where it's back growing there. Matagari springs up as soon as you bulldozer stuff over the bank. It's back growing again. So it's not completely destructive. So I thought that was an unfair comment that Doc made. Just as far as not all Indigenous clearance is completely destructive of that species of plant.
I'll see if the other panel, Commissioner.
Thank you. In paragraph 15 of your evidence, Ms Thomas, you advise caution when determining a rule in the framework, and the reason for that is that the RPS and the Land and Water Plan are yet to be notified and may dictate the approach. I'm interested in your understanding of our remit to contemplate awaiting a future process that hasn't occurred yet. I'd be interested in your comment there. Thank you.
I appreciate the difficulty that all councils are in regards to the freshwater announcement earlier in the year, and not only freshwater but also the RMA. And I think it makes it very difficult, so I fully appreciate that. But what I was meaning by that paragraph 15 is that the RPS is the umbrella for the district plan. You know, it sets the overall policy direction, and being an affected stakeholder, we have been subject to Schedule 1 consultation on the RPS, as I'm sure the council also have been, and are aware of some directional change within there that might affect the plan. So I'm just advising caution in that, which I'm sure that you are all very aware of.
Thank you. And just getting back to the 2 metre specification in the current rule, the proposed rule, as notified. Did I hear before that, did you put forward an alternative that you think is appropriate? Is that something for you, Mr Anderson? What would be, in your mind, an appropriate, if there was going to be a specification there?
I don't understand why we need a measurement. It doesn't make common sense to me.
Yeah, okay.
I mean, long as it's a fence line or a fire break, it's built to what you need to build it for.
Okay, thank you. And Ms Thomas, do you have a view on that?
I think you could complicate things by looking at each individual activity within that standard and breaking down, you know, should this be 2 metres, should this be 4 metres? But I agree with Mr Anderson that there shouldn't be any limit, and that for fencing fire breaks, the actual installation of those should be permitted as well.
For example, a fence line might be 2.5 metres wide, but a fire break might have to be 5 metres wide.
Thank you. I had another question there about the grazing, deleting the grazing from the definition, but you've addressed that for us, so thank you.
Yep. Kia ora, those were actually my questions, so that's really helpful, but I thought it would be remiss of me not to actually stop and acknowledge what you started with, Mr. Anderson, about being here advocating for your community and the time that it takes to do that. So I did want to just stop and acknowledge that and let you know it is heard. Like before I was a commissioner, I've been an advocate for my communities, and quite often I've sat there and gone, what do these people know about Māori communities, or what do these people know about farming? So I just wanted to acknowledge that many people have been in your position as well, and I've been one of them, so
thanks very
well
much.
done.
Just a comment to Councillor Scott. You asked Stacey about, I think it was around Indigenous biodiversity, and you were asking about, I just can't remember how your question went. You asked one of the things I think the most important thing we have to remember is engagement with that community has worked really well in New Zealand. We've got 1.6 million hectares in Kiritu Natural Biodiversity Trust done on a voluntary basis. No rules, nothing. So I get really frustrated when we talk about, it's like we were talking earlier on with the doc, we're talking about, they kept going on trying to identify areas of unseen Indigenous biodiversity in improved pastures. Well, I mean, every improved pasture in South Canterbury's got sedge grass in it, which is a native species. Most people wouldn't even know what sedge grass is. It's those little rushes that grow up in your paddock. I mean, are we going to say we can't graze that paddock or put stock on it because it's got sedge grass in it? We've got to be very careful about where we head. It's got to be what's actually naturally significant to the community and what we're protecting.
I asked a question of, of federated farmers at the last hearing, and I was kindly supplied the answer in writing, which was really helpful, thank you. I have 3 follow-up questions to that. I'm not sure if you're aware of my question at the last hearing, but I'm going to ask you the same on my 3rd question. Given federated farmers and their farmer member experience and knowledge, are no complaints instruments offered often by landowners? That's my first question. When they develop land for residential purposes.
Can you just repeat that? I didn't quite hear that second bit.
Are no complaints instruments offered often by landowners when they develop land for residential purposes, or they sell to a developer for residential purposes? No complaints instruments. This is in light of reverse sensitivity.
Well, it's a difficult one because, I mean, if I'm putting my own hat on, I've always been a wee bit against subdivision, of good productive land getting sold off and developed. But then it goes back to private property rights. Where do we decide? Who tells that person might be getting the end of their farming career, want to have family submission, and they subdivide some land off or develop it? It's a really difficult conundrum, and I know federated farmers we always promote private property rights, but I struggle with it with subdivision personally. Development of productive land.
Do you know if no complaints policies effective? Is that an effective mechanism to prevent no complaints or reverse sensitivity after the sections have been turned into residential properties?
Oh, I see where you're coming from there. It's an interesting one. I mean, I always have a wee bit of chuckle about out here at the Levels Raceway when people went and built houses beside a racetrack. I mean, I think that's what you're getting at about people complaining about the reverse sensitivity on what your activities you're undertaking. Yeah, that's probably why I'd rather they stayed in the cities and not moved out in the country.
Okay. So my last question, and this is the question I originally asked federated farmers, but I'm asking you as the chairperson of South Canterbury Federated Farmers, what measures do South Canterbury Federated Farmers take with their farmer members when farmland is being sold to avoid reverse sensitivity effects arising down the track when that land is subdivided for residential use? Do you advise them to, the issue is reverse sensitivity once the residential properties are up.
Yeah, I mean, that's a really difficult question. I mean, no, we probably haven't got a policy. We've always allowed members. I mean, I don't agree with a lot of the places getting planted in trees, but if a farmer wants to plant his property in trees, that's.
Well, reverse sensitivity is often an issue for landowners.
Yeah, I understand that.
Yeah.
I mean, yeah, it's a difficult, because I mean, my answer would be, well, if you moved out, bought a bit of land out and thing where you're going to get that's part of moving that area.
Right.
That's I mean, I know that's my hard and fast thinking, but that's why I think there's got to be some thought into development of land as you push out in the country from both sides of the fence, from council and from.
Yeah.
Allowing willy-nilly subdivision hasn't been good for New Zealand.
No.
I don't believe. It's interesting when you travel in Europe, you don't see many houses between the towns. It's just farmland or natural land.
Yeah. I know, thank you. Thanks very much.
I have no further questions. Thank you very much. I've just pulled up the council section. And just probably try and work out where 2 metres may have come from. And I'm looking at a table in section 2.2.1 changes proposed. And there's only one reference. And under the 2.3 and 2.4, quantification of cost. Impacts on biodiversity values, associated communities are difficult to value and it is seen as inappropriate to try and do. I just wonder in your role as a planner, whether you consider costs and benefits of what we've been discussing around two practical farming.
So I think what this paragraph is saying, so this is paragraph 2.3 in the S. So in this case, it's talking about the quantification, it says quantification of costs and benefits has not been undertaken, but it goes on to say it's the impacts on biodiversity values are difficult to value in monetary terms. And in my experience, it is common to not assess or not try and put a monetary value on the biodiversity value. But I wonder if perhaps your question was also around, could there be quantification of the economic cost? And in that sense, yes, where that can be undertaken relatively easily, that would be, in my view, done. And even if it's not necessarily quantified, it would at least be acknowledged. So a common one that I'm used to would be saying this would require a resource consent and there would be the costs associated with the resource consent being obtained, and that might include ecological advice, which has a cost associated with it. So that would be relatively common, but I think here that my understanding of that paragraph is it's more about saying, trying to quantify in monetary terms the impact on biodiversity values is the thing that's been seen as difficult.
Just from more consideration section,
So I think the answer to that, but I'm not sure, is that further on in the Section 32 report, so it's Section 5 where it evaluates the options, is where the benefits and costs are provided. What I would say about that is I think it sets out various options there, and they are what I'd call it's an aggregated assessment, so it's not assessing individual specific provisions. And my recollection is that the Section 32 reports for this plan didn't take that approach of assessing individual provisions. They did assess the provision, the overall approach and the package of provisions in the round.
In terms of a estimate, say, for such as varying funds that come in order for us to change that, I guess I'm just struggling a little bit of information in order to undertake that.
They won't listen to that. Sorry, I just one other note I wrote down I forgot to mention. Sorry, Commissioner Solomon. Just going also about the long-tailed bats. You know, in my mind, it's an easy solution. You know, because we're looking about the destruction of the habitat, and there's concerns about identifying trees that they're living in. Well, I mean, this is all about education from DOC and from the Timaru District Council on what farmers have got to look out for. You know, I don't think we need to spend a whole lot of money getting an ecologist in to tell you whether there's a bat in there. There'll be a template which can help you identify trees which they potentially could be living in, and then let's work together with it rather than just have these hard and fast rules and have costs put on landowners to go out and find ecologists to discover where the bats are. I think it's all about an education program. Thanks very much.
before we return to the list of submitters, Ms White, sorry, and I just wanted to redirect my question before the break. Was probably a little bit unfairly put to you in terms of the Section 32 analysis for the particular rule that we were discussing in the context of that submitter. I just wanted to acknowledge that the recommendation to include the 2 metres has come through submissions and that you've addressed that in your 42A report. But the panel's just a little bit concerned that we don't have a comprehensive basis under Section 32 or 32AA to evaluate the significance of that change, nor the request from the submitter and your assistance in that area would be helpful. We do note, and I had the wrong rule open, that the 2 metres is used in other rules in the notified plan, and that's where that appears in the context of the Section 32 that was notified with the plan. So my apologies, I merged those issues together, but thank you. To come forward to the table and make your submission. When you're ready.
Is that right? Good. I'd just like to introduce myself. I'm Rhys Hart. I'm a retired farmer. I've been farming since I was 21 years of age. Although I'm out of farming now, I still, and my wife and I, own 2 blocks of land that we lease to family and neighbours, and we have a real interest in this proposed district plan because it affects both of our properties. In addition to my farming life, I'd have to say I'm not a lawyer and I'm not a planner, but I have had governance experience. I've been involved in the meat industry, both in the UK and here. I've been a director of 3 companies. I ended up chairman of one of them. We employed 7,000 people and turned over $2.5 billion a year. So I have a real interest in governance, and particularly the governance of the Timaru District Council and how this process has been handled. Now, I'm probably not here to talk about how we got here, but it does have a bearing on the subject, and what we're here to talk about today is SNAs, and of course the legislation has been changed, and so there's no new SNAs to be considered for the next 3 years. We're talking about existing SNAs. But the point I want to make to you is that the properties that we have both SNAs and SASMs sort of incorporated into the same areas. So my comments might verge across 2 of these things at times, but we will be giving a presentation in February next year specifically on SASMs. I have formed a group. We call ourselves the Limestone Group. There's 14 of us in it. And we're pretty upset at the proposed plan because we're quite badly affected by it. And so we're taking legal advice and looking at all the options before us. I just have to say to you, one of the things that's gone wrong here, and the reason why we are disaffected in the way that we are, we were shut out of this process at the early stages. There was a lack of consultation. Now, that didn't apply right across the board to this provisional plan. I know the council consulted widely in other areas, But when it concerned properties that had SASMs and SNAs on them, we were shut out and mystified as to why. So we knew about the map overlays and the detail in the provisional plan. Once it became notified, it became a fact. And so how did we end up in this position? Well, we got hold of a letter, and it has been written by Mr. John Henry of the Aoraki Environmental Consultancy Group to the council, and it said, because of a spiritual connection to these sites that iwi had, that no one else, particularly people like us, could comment on them, comment on proposed changes or anything to do with them. It also advised the council that it would be wise not to publish the mapping overlays on the sites involved because they were worried about vandalism and a whole lot of other things. So as a result of that, the planning department and the external consultants that were employed by the planning department did a desktop plan. Now, you don't have to be a Rhodes Scholar to work out what a desktop plan means. It's inaccurate for a start. It has a lot of things in it that, quite frankly, will not work. And that's why we've formed our group. And to give the council credit, they have appointed Aaron over here, who is a conciliator, to meet with us to see if we can resolve some of these differences. And that's a great idea, but they're late to the party. The damage has been done, and to a certain extent we may be able to improve the situation a bit. But I think when you stand back and look at this, the planning department of the council was marching to the drumbeat of John Henry, and it's put us all in this situation, which is not ideal. So I'm reminded of the Prime Minister's comments 3 months ago to the local government conference. He said council's role is to collect the rubbish, deliver fresh water to households, and maintain the roads and footpaths, and nothing else. And here we have the Timaru District Council embarking on a strategy here where they will have to adjudicate on spiritual issues and cultural issues. They'll have to decide whether I'm qualified to comment or not. It's absolutely crazy, and it is not a basis to go forward. It's very divisive. Right, to get back to the SNAs. Most of us have limestone escarpments on our properties, and these are common. They run from Southland, Otago, Canterbury, right through to Marlborough. And my comment is that they're limestone outcrops, cliffs, caves, etc., and they're wonderful structures. They're virtually indestructible. There is one exception, the formation of limeworks, where the area's blasted or ripped and crushed. And we've had 2 limeworks on our property which are now closed, but there's 3 or 4 major limeworks in the region. I'd have to say if anyone wanted to start a limeworks nowadays, it would be virtually impossible to get through the red tape, to get through the consent process. And even then, when you got through it, you'd have to get a permit from the Department of Mines and Quarries, and I don't think anyone would bother. So I don't see the formation of limeworks in the future posing a danger to these limestone SNAs. Yet, when we look at this proposed plan, we are being almost treated as out-of-control children about to destruct these sites at any time. I just have to remind you all that we have been the best allies and protectors of these sites that both iwi and the district have had. We've done it in our own time, at our own cost. We haven't asked for anything. We haven't been offered anything. We've done it. And so when we get dumped upon by excessive heavy-handed regulations and sort of accused of being environmental vandals, you can understand how we feel. We're mystified. We think we've been a help in preserving all these sites. And we've entertained thousands of people over the years, overseas people, trade commissioners, governor-generals, the lot. The most important groups that we've entertained are school children. One year we had 700 come through. So we're on side when it comes to looking after these sites, but you wouldn't think so looking at this plan. And remember, this plan was written without consultation with us. If only the planners had got out of their seats and pulled their boots on and come around and inspected these sites and talked to us and seen the farming activities that go on in and around the sites that's gone on for generations, we may have got somewhere. We may have reached a consensus, and it would have been so much better if we could have gone forward on that basis. So one other point, I've got two other points to make. One other point is, it seems as if the planners of the Timaru District Council are in a race with ECAN to put further regulations and restrictions on sites, such as SNAs, such as limestone sites, for example. So if you wanted to do anything, let's say a limeworks that we've talked about, you have to go through a rigorous consent process with ECAN. So why on earth would the City Council want to double up on all of that? I mean, it's bad enough and expensive enough as it is. Why do we have to get it times two? Now, the other thing about this plan, and I note, and I've put in my notes to you, Rules General S42A, specifically on analysis point 7.12.4, change in land use. Now, it is to do with the clearance of vegetation, of course, indigenous vegetation, and that has a bearing on what land use is allowed. But in terms of limiting people's ability to change their land use, we have the wording able to continue farming in existing areas. In other words, you're able to continue doing what you've always done. Now, on the surface of it, it seems like, well, this is a concession. But when you look at it, it's anything but. Because farming is a dynamic industry, the only constant in farming is change. Farming has to change to adapt and survive. Individual farmers have to do the same to stay viable. And I'll give you a case. Right now, sheep farming is in a state of crisis. This has happened 2 or 3 times in my lifetime, and generally things happen. The meat companies reduce the cost structure, they find better paying markets, and we get over it and go on. Right now, the opportunity for finding cost savings is quite limited. We've had the easy gains. And when you look at markets, the opportunity to develop new products, new branding strategies, etc., once again has been well canvassed. And the lift that we've had in the last 10 years has largely been China-driven. That situation doesn't exist today. China's in financial trouble itself, and its dominance in the market is considerably less. So what I'm saying is this: sheep farmers are in a desperate position, and they will want to change land use. They will come to the council and say, could be anything. They want to subdivide, could be for residential use, lifestyle use. They might want to change to cattle, as it says in the brackets here, or deer. They might want to intensive crop, orcharding, market gardening, forestry. They could want to set up, I suppose, an adventure park. They could go in for tourism. There's a whole lot of things. So just imagine when farmers who are desperate to restructure, they come to the council and the council says, oh, we're going to let you carry on what you've always done, but you want to change. You're crossing a red line here. Our planners, assisted by John Henry, have drawn up strict guidelines regarding changes. And you've got to go through an extensive resort hearing, etc., etc. You have got to allow farming to change. If we tie farming down and put a massive handbrake on, it's going to be completely unworkable and unacceptable. So that is my other point that I make. If you people want to be really radical, you could declare South Canterbury a compliance-free zone. Promote ourselves as being something different. Invite new ideas, new people, embrace change, bring in new capital. The place would boom. You'd be all out of jobs, but I'm sure you'd find one somewhere else. Anyway, that's my point. I'm happy to ask or answer questions.
Thank you, Mr Hart, for your submission. I'd just like to note that we're not engaging today on the issue of the placement of SASMs across properties. That's a matter for another hearing, and there will be a lot of evidence presented in relation to that hearing, which I encourage you to read before you attend. I'd also refer you to the evidence that was presented at the opening sessions of this hearing, if you haven't already read it, which explains the process that the council has adopted in terms of consultation. And we can perhaps discuss that with you when you return at the next hearing. But for this hearing, I'm interested in your submissions in relation to the areas of ecological significance, and I wondered if you could just give us some sense in terms of your practice and your farming activities, or from your knowledge about your experience with the RMA and whether and how that may have impacted in farming operations.
Well, it hasn't impacted on me to date because I've been out of farming for 10 or 15 years, but the implications are serious for the property which my son runs a bull beef unit on. You wouldn't believe it, but 65% of the property has been covered in this mapping overlay that comes under restrictions of the new district plan. And you take one look at that and you think, well, you know, the business has had it, it's no longer viable, we can't. And yet this is a business that's been in our family for 115 years. This is a business that's probably left these sites that you're looking at protecting in better condition today than they were 100 years ago. So can you understand our frustration here?
Yeah. So is the issue, would it be fair to say the issue is more in terms of the scale as it impacts your particular property rather than in principle the concept that we may need to provide some protection for significant ecological areas as directed by the legislation?
Yes, I think you may need to, but you can do that in such a way as it's not going to impact farming operation, because let's face it, if the planners had actually gone round and had a look before they drew these rules up, they would see that it as it is today, they would be quite happy with the vegetation that's there. So that's not likely to change. But in terms of the scale that you mentioned, that is another point. So if you have a property that's 1,000 hectares and you have one SNA site on it, it might be the size of an average house. So where do the restrictions end? If the sheep farmer running sheep on 1,000 hectares wants to change the operation completely, he might have an overseas investor come in, they want to convert to deer. But hello, we've got one SNA on the place the size of a house. What happens there? So do you restrict on the whole property, or do you put a 2-metre fence around the SNA? I mean, all these things could have been resolved if it had been handled correctly early on with a bit of dialogue and consultation.
So are you seeking removal of the SNAs from your property, or are you seeking changes to the way in which they're regulated by perhaps providing for other methods, non-regulatory methods, other methods that perhaps incentivise farmers to look after the areas rather than curtailing farming activities? I'm just not quite clear, and I've looked at your written submission, what you're actually asking in terms of changes to the plan.
Right, well, what we would like to do is carry on the business of farming, but that might mean that we have to change the type of farming that we're doing. Now, surely it's not beyond the planning department of the council to come up with regulations that allow movement, allow change to occur, as long as the existing vegetation, indigenous vegetation, etc., is protected. So we don't want to be wiped off the map with our farming venture because of a planning department that's running out of control.
Okay, I think you've made your point, and I'll just see if my other commissioners have questions. Thanks.
Thank you, Mr. Hart. Just like to acknowledge your part and role in your stewardship. It's obvious you care very deeply about the SNAs and the BPAs, the overlays and their significance, given the fact that you've protected them over the years. In your experience, is it possible that might not be the case for all landowners? Would you accept that
yes,
have no control then risks the very values across the entire district? Like, how do you reconcile that? Not everyone may have the principled approach that you've articulated to us today.
Yes, I see your point, but can you point me to a case in the last 50 years where these sites have been vandalised? They simply haven't been. Most farmers are proud of these sites, and they wouldn't see anything happen to them. You might get the odd rogue person, but surely councils can take this into account. What was the other point you made?
I think you've responded. That's fine. I was interested in your understanding of whether this positive stewardship is common across the district, or whether you had understood perhaps others who weren't as careful with these values.
No, I'm not aware of anyone that doesn't respect the values of these SNAs. Quite the reverse, in fact.
Thank you. And when you talk about being shut out of your own land, does that relate to the idea that the overlays will stop you doing what you're doing now, or is that your impression that if you want to change the scale or nature of your farming, that will mean you can't do so without resource consent?
I do think that. I came in here and I had a meeting with the lady that was in charge of planning, and it was the first look at the overlays that we'd had since the plan had been notified, and I was shocked at the large circles that were drawn all over the property joining up. So the planners, in their zeal to regulate, took plenty, far more than necessary. I mean, if you had an SNA the size of this room, you don't need to take 30 or 40 hectares of prime farmland to protect it. It's absolutely nuts. And so this is why we have fired up our group. We're prepared to see something done, but it's got to be common sense.
Okay, thank you.
Kia ora. I will start just a follow-on question from the previous Commissioner's question about having no knowledge of farming activity causing damage to areas of ecological significance. Are you not aware of any action that Environment Canterbury or any district council might have taken against any farmer for destruction of ecological areas ever?
Yes, I am vaguely aware of one action where people sprayed out indigenous vegetation, but I think ECAN took appropriate action at that time. It's like a lot of things. There are certain rules and do's and don'ts even for residential property owners you can and cannot do, and it's pretty well known in the rural community what's acceptable and what's not. So I probably haven't made myself clear, but I think it can be put in regulations, but you don't have to limit people's ability to change to get the point across. If we put a handbrake on change, we're in trouble. We simply have to move with the times and allow people to adjust to the new environment. The world order is changing, after the American, who knows what lies ahead. People are going to have to change, and we shouldn't be trying to stop them.
And I just have a question regarding the letter that you've referred to a number of times. So we don't have a copy of that letter from Aoraki Consulting, but I did want to know, are those comments limited to only areas where Māori are intending to comment? So you're saying the letter says Māori are saying don't engage with anybody but us. Is that, in that letter, does that refer to all chapters of the proposed district plan, or is it limited only to those parts that relate to Māori custom and spiritual beliefs?
It certainly relates to them. Whether it relates to SNAs specifically or not, I can't say, because the two sites are one and the same. That's the way it is. Some of these sites are SNA sites, and they have a SASM designation put on them. Incidentally, the letter's freely available. It's on the internet. You can look it up. It's addressed to Mr. Alec Wakefield. Is he still the manager of the planning department?
Well, you could provide it potentially as evidence rather.
Don't generally approach these hearings by going onto the internet looking for things ourselves. It needs to come through formally as evidence in this hearing. So if you have a copy of the letter and want to make it available to the hearings administrator, then we're happy to receive it. But yeah.
So in a perfect world, so you said Mr. Wakefield is no longer with the planning department. Is he resigned? Because
we're an independent hearings panel. Not dealing with council or administration.
no. Right, I'll provide it for the next hearing. I've got one here, but I think you need a digital copy.
Could I assist here? The letter that Mr Hart is referring to forms part of the bundle that was included on the website when the plan was notified, so it is a background document that was relied on in that. So perhaps through legal counsel that can be provided to the panel rather than Mr Hart providing it, because it was something that the council has included as part of that. So that will save you having to do it, I think.
All right, thank you very much.
Thank you, Ms White.
Then I'm trying to understand is this letter relevant to SNAs? I understand that you're saying it's for the same physical location, but I'm trying to understand, is it for sites and areas of significance to Māori, or is it for everywhere?
So assuming it's the letter that I'm thinking it is, it was specific to the sites and areas of significance to Māori.
Okay, thank you.
Thank you, Mr Hart, for your submissions. I have a couple of questions. The first question is, I couldn't ascertain whether your SNAs and BPAs have increased in this new proposed district plan, because you sort of talked about lots of circles. So are you saying that they've increased and you are unaware of that? That's my first question.
We're certainly aware of it now. We were unaware that we had these restrictions placed on our property before.
Okay, because you talk about how previous owners and yourselves have cared for the SNAs for a long time, so I presume you've been aware of these SNAs.
Not that they were designated SNAs, they were just features on our farm.
Okay, because a couple of the chapters, the Eco chapter you've submitted against, as well as the NFL chapter, and I just wondered if you had read Ms White's response to your...
Yes, on the clearance.
Because she acknowledges that the areas identified as SNAs and BPAs have retained their significance, in part due to the actions of the landowners. What the PDP seeks to ensure is that these areas are protected on an ongoing basis. I note that the rules in the Eco chapter are relatively narrow in that they relate to managing clearance of Indigenous vegetation and earthworks within SNAs. They do not manage other aspects of farming activities beyond this, and in my view do not shut out landowners from these areas. And then also, it does also go on to say under NFL chapter that it does not restrict grazing. So I just wondered what, I'm trying to also ascertain, what is your main concerns about the rules?
Right, well, in brackets, I haven't got it in front of me, on page 2 of the summary, and I quoted the code numbers there before, it said change of land use, e.g. sheep to deer or cattle, or intensive mob stocking. The point I want to make is it's quite common for people to change from sheep to deer or cattle and change back again. And just because a property has SNAs on it, I don't believe the council has the right to try and stop this change from occurring. As long as the site's not damaged, who cares? Why should you get involved in it?
Thank you, Mr Hart. I think the panel will certainly look more carefully at the rules given what you've raised, and if it's your perception it's going to unreasonably restrict those kinds of changes of land use, we'll have a look again, and it might assist Ms White if you could just perhaps clarify how the rules would apply in that scenario. That might assist us a bit as well, and focus our attention on whether or not there are any changes that we should be considering in the rules. Thank you. Thank you for your time,
All right,
Mr Hart.
thank you. Good.
telcos, Spark New Zealand, Chorus and Vodafone, joining us by video link, and I understand that there are representatives from each of those submitters joining us also, so welcome.
Kia ora, thank you for having us. I'm Tom Anderson. I am the planner engaged by the telecommunication companies for the Timaru district plan process. With me today I have Graham McCarrison from Spark. The other planning managers are unable to join us from what is now 40 South, which was previously a part of One, which was previously a part of Vodafone, who were the original submitter. So there's been a few iterations in the time that's elapsed since then, Chorus and Connexa. So myself and Mr. McCarrison will take us through our submissions relevant to this hearing stream today. In terms of format, I'm in your hands really whether you would like me to read my summary statement, read my evidence in chief, or provide a brief summary of the matters which remain sought.
Perhaps just focus on the matters that remain unresolved and give us an overview, and then we'll see if we've got any questions. Thank you.
Certainly, and apologies if things have moved as well in the time since with recommendations from the 42A officer, but the two matters that remained outstanding through the 42A reports were in regard to Eco Policy 2, where I sought that the term regionally significant infrastructure, which is a defined term in the proposed district plan, rather than referencing some but not all regionally significant infrastructure providers, should be included in that policy. So that was, I thought, quite a minor change. The more significant changes in regards to natural features and landscapes, where the evidence sought permitted provision for poles in outstanding natural landscapes and features and visual amenity landscapes, and we sought encouragement to locate such structures in legal road, as well as to provide mitigation concerning width and light reflectance values. Also sought differentiation in the controls for ONLs, ONFs and VALs, and that's at paragraph 25 of my evidence in chief. I have had a brief look at Ms White's subsequent recommendations, and while I appreciate there has been some movement from Ms White, I do continue to seek the relief sought in my evidence, as that provides for the functional and operational needs of the infrastructure, whilst mitigating as best as possible the effects on those landscape areas. That's my brief summary. I can go into more detail if needed, or happy to answer questions.
Thank you, Mr. Anderson. That's very helpful to have that overview. So, with regard to the second outstanding matter, you're in disagreement based on Ms White's amended approach.
Yes. Still seeking the heights as specified, and the widths and light reflectance values as specified in my statement of evidence.
Yes. So this morning we did, we asked some questions of Ms White and Ms Pfluger. Were you able to tune into that?
No, I wasn't, unfortunately, sorry.
Okay, so the overall gist of it was I was quite interested in in your evidence in chief, you had put forward the point that it's the bulk of a facility that is determinative in terms of dominance as opposed to the height. And
that's from my experience, yes.
Yeah, so that's from your practical experience with other plans and implementation.
That's right.
Yeah.
Yes.
So my question is, have you discussed that matter with a landscape architect at all to support your view?
No, we haven't got landscape evidence for this hearing.
Okay, thank you. So Ms Pfluger, while she accepted your point around the principle that bulk can be an important factor in determining dominance rather than height, she was still of the view that the 25 metres height was too much, and that the visual effects would be too much in that sensitive environment. So you're obviously disagreeing. Can you just talk me through the nature of that disagreement again?
Certainly. So height is obviously provides greater coverage, but it also has another factor which is often overlooked around radio frequency and compliance with New Zealand Standard 2772. So with generations of antenna that are coming out, and Mr. McCarrison might be able to provide a better explanation than me, and this is my interpretation from experience. I'm not an expert in radio frequency, but with 4G, 5G, and now there's some early doors discussion around 6G. In order to achieve compliance with NZS 2772, which is stipulated through the NES and usually through district plans as well, greater height is needed so that the plume does not reach how do I explain this? The dangerous part of the radio frequency plume does not reach publicly accessible areas. Is that right, Graham?
Basically, yeah. So what we're trying to do is work within our safety parameters, and height's one of those. The plumes for a 4G and 5G site is a lot bigger than a 3 and 4G site at the moment. So hence creating a bit more distance, basically. And height enables us to be, in this particular case, in the road, where houses may be near that road environment. So I suppose from an industry point of view, we view roads as infrastructure corridors. They already exist. Utilising height in rural areas enables us to have less sites, and so you reduce the potential proliferation of cell towers, which there isn't going to be that many anyway, given the limited nature of these areas. So, hence, having a few, being a bit higher, delivers a whole lot of benefits to the rural community in particular.
I also understand from talking to radio frequency areas with height, you can get that greater coverage of an area, but that has a greater radio frequency profile to get that coverage, whereas in an urban area it'd be reduced because the cell would be smaller. So there's a couple of factors at play, not just related to landscape, but the landscape aspects being retaining the width to as small as possible, and the light reflectance value as well, which are measures that are often raised by landscape experts and various resource consent applications or other advice for similar type processes.
And so the other advantage of height is that we can look over trees, particularly shoulder belts, those sort of environments, to get into people's houses. So the indoor coverage is increased with that. Trees and radio waves just don't mix particularly well. So, so having low sites that are surrounded by trees, there's just no point in us putting them into that environment, basically. So,
thank you. That's really useful to hear about. And this might be a question for both of you, but I'll start with Mr. Anderson. In your evidence, you mentioned your experience with the Queenstown district, and you also mentioned, I believe from memory, the Christchurch plan as well. Is it more common than not for this standard to be appreciated and reflected within the height standards of other plans generally? Is that your experience, or are you having to attend hearings across the country for the same matter?
We're attending hearings across the country. This is my third in 5 days in different parts of New Zealand, between Hawke's Bay and Invercargill and now Timaru. So, Yeah, and there's many different ways that plans approach it. Obviously, Christchurch has 25 metres and a 6 metre width in ONFs and ONLs, and I don't, from memory, I don't think there's any light reflectance values, whereas Queenstown is 8 metres, and that's worked really well, but that's 8 metres not just in legal road, that's everywhere. But that 8 metres that's worked well was, I've based that on the 2019 Rugby World Cup rollout that Spark called it, where they increased their capacity, and now with the technology moving on, I understand from radio frequency engineers that 8 metre sites are for 5G and going forth are no longer viable because of that safety aspect that needs to be built in.
Yeah, so in Queenstown, yeah, you're starting to see a lot more sites needing to be built. So we will be building more and sites within the ONLs. Queenstown makes it really difficult because basically it is an ONL. It has the advantage that we can get raised areas that overlook areas, so lack of trees often where people are. So it has that advantage. The Christchurch one was a pragmatic consideration of encouraging infrastructure to remain in the roads and not go out into, for example, the Port Hills and Banks Peninsula areas. And that's where we kind of landed on that one. So interesting. Landscape architect supported that for Queenstown Lakes. And there's a range of different rules that we have as each district takes different approaches.
Great, thank you very much. I have no further questions. Thank you.
Thank you.
Kia ora, this is Commissioner Mackay. I think I understand your evidence to say that different topographies need different heights, and what I've heard is that if you're in a low flat area where there could be high buildings and high trees, you need higher structures. And if you have topography that has, like in Queenstown, that's more undulating, that therefore it might not be appropriate for 25 metres or the Port Hills. Is that correct? Is it all down to topography?
Yes, typically topography and vegetation and buildings. So screening on any natural elevation. Yeah, that's it.
And then we have the technical things of cost. So the further away you are from fibre, it becomes very expensive. And also we prefer not to have to cut access tracks into significant landscapes, basically, because our sites do need to be safe for trucks to get up to maintain them. So the tracks will be visible, basically. So hence our preference is to be in the road environment, which has already got been cleared for roads, and leave it that way. Fibre power is usually more accessible of those spaces. So.
Right, no, that's really helpful, thank you. I just have one question. It's about the change to the NFL Rule 3. And in your proposed amendment, it is to remove the visual amenity landscape, the VAL overlay entirely. Was that in the original submission, or is that in response to the recommended amendments from the Section 42A report?
That's in response to the 42A report.
Okay, thank you.
It's Commissioner Solomon here. I'm looking at your paragraph 17, and my query relates to whether the new technology you mention in that paragraph is adequate, because it seems to me that 3G, 4G, 5G and 6G technology is evolving at a reasonably fast rate. So why isn't antennae technology evolving at that same pace?
And the antenna technology is a 3G, 4G, 5G technology. So every time there's a new generation of mobile, or I'm not even sure how to describe it, I might hand over to Mr. McCarrison on that, but the antenna essentially gets swapped on any site.
Yeah, so our industry is forever upgrading and changing out antenna and the equipment that supports antennas. So our 5G antennas currently tend to be kind of square, squat, reasonably narrow, but they're supported with a lot of other radio units to support them going faster. As we're moving forward with the 5G technology, they'll become more integrated, but probably wider and a little bit more fatter. And we need 5G, except it generally needs to be closer to the end user, although the reason for closing down the 3G network, which people use for voice or text, although it's there's not a lot of users on it currently, it's decreasing regularly. So that spectrum is going to be used for enabling us to do better, particularly rural 5G. Basically, so taking it more out into the rural environments rather than just the rural towns and settlements. So,
did that answer the question? Because I realise it's a pretty technical answer, and I understand the genesis of the question. Is that helpful?
Yeah, well, I mean, that's the only answer you're able to give me, then I have to accept that. Thank you.
Yeah. I think the important thing is that the standard NZS 277 2.1 does not change as the generations of antenna or network change, and that's important because that's essentially set by the World Health Organisation, I understand, Graham, derived into the New Zealand context. And that's what protects us, people from potential radio frequency.
Yeah, so the Ministry of Health reviews that every 6 months or so. So just a constant review and reporting, and they make decisions on whether the standards or any other guidance needs to be changed based on the research that's coming out internationally. And so it would be up for them to recommend to the government to make a change to the National Environmental Standard. Our role is to make sure our antennas or the height of the antennas are away from people, people working on a roof, builders, that sort of thing are going to be safe when they do that. For short-term periods, then we often just turn the antennas down, tilt them away, down power them for safety. So there's a whole procedure for that. It happens remotely. You don't need to see anybody going up there. Our technicians just change things around, basically. So.
Okay.
Yeah, these are very sophisticated pieces of kit, very expensive. And it's painful that we regularly are changing them out every 5 years or so. There's just no other infrastructure like it around the world, really. So.
All right, thank you.
I have no additional questions. That's been a very helpful presentation. Thank you very much for your submission.
Thank you.
Thank you for your time.
Our final submitter for today, Mr. Spears.
So I just had, introduce myself. My name's Bruce Spears, a resident of Timaru for 40 odd years, 40 plus. cadastral surveyor, been working in the resource management field for 30 plus years in the Timaru district. So, just got two comments on the today. The first one is natural character. Sorry, no, it's wrong. It's in the definitions. I suggested that council include in an additional diagram of the river cross-section in the riparian margin definition. Giving you a couple of photographs there, took those yesterday on a couple of jobs we've recently done. The nice green one is a nice wee stream. It has esplanade strips on both sides of that stream as part of it, and as you can see, it doesn't conform at all to the existing diagram that's in the definition, which has nice floodplains and all the rest of it. The second one is nice blue sky. I actually tried to get into the bottom of that gully. It's a wee bit rough in there. I didn't make it. There's actually as we're looking up that gully, and you can see it's about 30, 40 metres deep by the size of the trees. We're already above the willows that are in the creek bed itself. It doesn't conform at all to the definition diagram and the definition. These are both quite local. They're within 10 k's of us here at the moment. And if I have to admit, I thought about the jobs I did. There's a 20-metre esplanade strip on the right-hand side of the stream with the yellow, with the blue sky. Goodness knows how anyone can ever use it in terms of the vegetation that's there. As you can see from the other side of the valley, there's a lot of rock bluffs. It's deeply incised into the volcanics that are around Timaru. And there is no floodplain. End of story. I must admit, I forgot about the easiest example. If you want the easiest example of a deeply incised waterway, drive through the scenic reserve. Simple. The lower end of Saltwater Creek does have a profile that matches the definition in the plan. Around at Redruth, you've got a broad floodplain, although quite a bit of it's been built up, including with a rubbish tip. And as you work your way up the valley, it gets into the scenic reserve where you've got a deeply incised river. And as you go further up, it'll actually ease out back again to a smoother topography. So the fact that I believe it would be advantageous if the district plan had more than one simplified example of a riparian margins and river. I appreciate it's come out of the national statement somewhere. If the Timaru District Council was to do something for these deeply incised, they could feed that back into the national statements that's available to the rest of the community as well. That's the first one. And the second one is regarding fencing. This is 6624, natural character R4. I suggested that in terms of fencing, limitation for a post and wire fence is rather limiting in terms of farming operations. And for example, I believe, as the rules are written, that you would need a land use consent to erect a deer fence within 100 metres of the Opihi River, for example. Rather silly. I don't believe it's the intent. I don't believe the farming community would abide by it. I don't believe the district council would enforce it. And if you're making rules that are neither going to be abided by or enforced, they're silly rules. So if you need a fence, I don't think in many cases a wire fence is appropriate. And we'll take, I think you'll find that most of the ECAN fencing against sop banks will all be netting because they don't want animals through because they then damage the stop banks. So again, it's a recommendation to reject the inclusion of netting fencing in that. I think that's quite short-sighted, that if you don't actually include what is going to be used anyhow. That's it.
Thank you. Any questions? Thank you, Mr. Spears. So in terms, I've got the definition of riparian margin up on here on my screen.
I brought my book this time.
I was wondering, Madam Chair, whether we could bring up the definition so that we could look at the diagram. Megan. Thank you. Lovely. Thank you. So if I've understood your submission and your presentation today, you're not in disagreement with the definition of riparian margin, but you think that this diagram only shows one type of riparian margin?
It's not representative of what's available in particularly Timaru. It's a diagram that's representative of plains, the Canterbury Plains. It doesn't represent the rest of the district.
So is your concern around readability, usability from a plan user perspective? Are you concerned there might be confusion?
There is confusion because, for example, in deeply incised waterways, you have trouble with edge of bank, for example. There's no, in many cases, and including in the photograph with the green, where's the edge of the bank in that? And things like that. So,
Ms White, in her Section 42A report, one of the reasons she didn't accept your submission was that the definition doesn't rely on there even being a flood bank on the image. So do you think the image, I think that's a correct summation, if the definition doesn't rely on the floodplain being there,
then the image is misleading to the casual user of the...
So either way you think, yeah, okay, great.
So if you can have one, you need the other.
Okay, thank you. And with regard to Natural Character Rule 4, so your submission point, you considered post and netting fence to be more appropriate?
Is equally appropriate in many circumstances, yes.
Yes. So Ms White, in her Section 42A report, has responded that, in her view, the phrase post and wire would allow for exactly what you're suggesting would be appropriate, wire netting. So she doesn't see that change necessary. Is there something I'm missing there?
My interpretation of a post and wire fence is it's plain wire.
Plain wire?
Yeah.
Post and wire, right.
Whereas in my experience, a netting fence is called a netting fence.
Okay. And so the permitted standard 1 says the fence is a post and wire fence only. So you think that's too limited to just, right, I see. Yeah. Okay, that's clear now. Thank you. I've understood that.
Yeah, I do. Is a netting fence made of wire?
Yes, as is also a chain link fence. But I don't think a chain link fence would be appropriate in many cases.
No. So, okay, thank you.
And also in terms of post, and when we're talking about post, we've got wooden, we've now got plastic, we've got concrete, we've got steel. Okay, so you've got a variation of materials that we're talking about, even in just in post and wire.
those options for post are good then?
They're common types of posts, yeah.
Rather than just saying just a wooden post?
You'll excuse me, from a narrow perspective as a cadastral surveyor, we have to meet requirements in terms of how we describe fencing. Okay? And we can't call a post and netting fence a post and wire fence.
Right, yep.
Okay? So from my narrow professional experience, I bring that through into this. Okay? So, yeah, if you can explain that it's a wire fence includes a netting fence, for example, I don't know. Sorry? No, different thing altogether. Chicken wire is the best way to explain rabbit fencing. Yeah.
Yeah, thank you. I think that's a point worth pondering on, but I appreciate your submission and the practical application of the rules that you've brought to the process. That's helpful. Thank you.
Righto, thank you.
That brings us to the end of the submissions today. We'll just check in with Ms. Vila and Ms. White. Just there were a list of things that have emerged today. If we could perhaps just run quickly through them and just make sure we've captured them and sort of work out who's doing what when, that would be helpful. So put in your hands, Ms. Vila.
Okay, thank you. So I've just sort of got my notes from the day, if I could just sort of scroll through those. In terms of immediate actions, I'm to provide you with a copy of the Water Conservation Order for Rangitata River, which I have here. Along with that, I've got the letter that I think Mr. Rieshart was referring to. So we can hand those up in a minute. Ms. White is to undertake essentially a gap analysis between the PDP and the regional rules in relation to the rules in relation to the riverbed. Particularly in relation to SNAs, I think that is actually. We are also to have, Ms. White's also to have a look at something around, which I'm sure she's got better notes of, something around the standard height in relation to boundary. Nope, is that Andrew? Oh, sorry, that's Nick. Sorry, that's Nick. Thank you. So that's the open space, open space zone standard 3. I think Mr. Boyes is also having a look at something around Rule 10. Sorry, I should have spoken to them before I came to you, but I've got lots of sort of that we need to check and feed back to you in relation to some things. So there's something around Rule 10.3 that doesn't expressly, something that may need to be expressly stated, so I need to just double check what that is. We've got some keeping track of some of the issues around the natural hazards hearing. So that's for Mr. Willis, but that's a later task, I think, just to update you in ahead of the natural hazards hearing and pick that up in the Section 42A report. So it's not for today.
It's related to this managing hazards.
Yes, and the relationship with. Yes, the relationship with the natural hazards chapter. That's right. Ms. White is to have a look at how the adjacent districts deal with rules relating to riverbeds and come back to you on that. And then also for Ms White to have a look at the 2 metre rule around actually I'm not sure if that's a question that you requested of her, but there was an issue around how other plans dealt with the 2 metre rule around Indigenous vegetation clearance for fences and that kind of thing. But that might have just been a note for myself for Ms White to have a look at. Yes. Yes, that's right. Yep, thank you. Also to have a look at the impact of the 500 to 900 metre contour on other landowners, on the number of landowners. A map showing the overlay, the relationship between the ONLs and the SASMs. We're also to have a think about and do some analysis around the relationship of the ONL and the VAL with the water conservation order for Rangitata, and so how the comparison of the values protected by the water conservation order and how you should be considering the water conservation order when you're considering the values that are protected by the rules as currently proposed. And we will, and I've spoken to Ms Ham, we will go back to her for the issues around the Rangitata diversion race management before we come back to you on that. We are to confirm with Ms Fluger that the ONL has taken account of the existing weir. And I said we've got a copy of the letter that we think Mr Rees-Hart was referring to. And Ms White is going to provide some clarification around the rules and particularly how they apply to Mr Rees-Hart's property around the SNAs and changing land uses and the issues that he has raised there. And that is my list. Did you have anything else?
The other thing that I had on my list was there was a question about the tikanga protocol that I was going to confirm whether that was sort of, if there was anything in place or not as yet.
I was just wanting some guidance from you around the use of the advisory note in relation to the commercial forestry rule and whether we needed to elevate that to a permitted activity rule to achieve what I understood the submitter and you were agreeing to in terms of how to capture the NES requirements.
Yeah, so I have seen an advice note used in other plans. That's not to say that that makes it right or not. The intent of it is essentially to be, because the way that the NES is set up, it says you can be stringent in certain circumstances, but therefore if you're not exercising that stringency, then the NES would take precedent, and that's the intent of the advice note, is to be clear that where the rule might otherwise be more stringent, it's not intended to be as it applies to forestry. So I'm comfortable with that being an advice note. The alternate is in effect that you somehow change it from a advice note to another permitted, a per 3 or whatever, and say per 1 and 2 above do not apply to, effectively the same thing, these do not apply to activities managed under the NES. So I think that would be reasonably easy. I think what I would, I don't think we should try and replicate the NES rules themselves in the plan, because that I think is contrary to section, I'm going to say 43. So I think it would more be saying,
if
in
you
effect,
comply, that if you are meeting the permitted activity standard, permitted activity under the district plan, that's what I was sort of envisaging. I was just concerned that the advice note leaves hanging the question of whether there are other rules in the plan that might apply. I mean, you kind of have to go and look and interpret the NES to understand that the district plan can't do that. But it's, just on my reading, I was like, well, and is there another activity standard or what have you that applies? And I didn't think that was the intention, but I just wanted to ensure that the method that was being adopted had regulatory effect rather than just a sort of note.
Yeah, and the intent is also that it applies only to the rule that it's been added to. So the obvious one I can think of is vegetation clearance, and it's saying where vegetation clearance is an activity that's managed in the NES, then that effectively prevails, for want of a better way of putting it.
Yeah.
So that note then would apply essentially to that rule and say, okay, so this rule doesn't apply to that activity. There will obviously be rules across the wider plan where that stringency has been exercised, and therefore that note, or even if it is a permitted standard, whether it's a note, wouldn't apply to those other activities. It's very specific to the...
Ms. Wheeler, is there any case law and guidance around what the sort of impact is of an advisory note? Because some advisory notes are true advisory notes. They might, be a friendly reminder that you need to go and look at something else in the plan or outside the plan. But, yeah, my concern is, does it have regulatory effect? And we're not just creating an argument for another day about whether or not the district plan applies.
I'd need to have a look at that specific question, but I understand what you're saying, yes. Is it merely advisory in its sort of capacity, I guess, or does it actually have the effect of excluding?
Because if you can easily exclude it through the drafting of the permitted activity rule, why wouldn't you just do that? Then it's clear, then there's a limit to where those activities apply, even if it's a precursor to the rule or the set of the rule, except, for activities that are permitted under the NES. Okay. All right. Is there anything else that had? Right. Okay. Well, thank you very much for your help today. It's been great, and we'll see you in the morning.